Counsel for the state are present. Counsel
Welcome
for
to
the
closing
defendant
arguments. You are
present,
joined by Pop Jokes, Plans, and yours truly. Here we go.
Ms. Richins. We're set this morning for closing argument. Mr. Bloodworth, is the state ready to proceed?
Yes, Your Honor.
Ms. Lewis?
We are.
Okay. Anything before we invite the jury in? Mr. Bloodworth?
No, sir.
Ms. Lewis?
No, Your Honor.
All right.
He set no time limits, Joel.
All right. Well, I've got it.
Okay. Cody, we're ready for the jury.
Triple size. Happy Monday, everybody. Hope you had a good weekend.
Oh, all right. Very good. Well, so it goes. While I have this moment, if one member from each of your respective teams would plan to meet with Brittany after closings are complete, just confirm that we have consensus regarding the exhibits that we're sending back into the jury room.
Yes, Your Honor. Can we address physical evidence as well? I don't think we're requesting to send any physical evidence back, but I'm not sure.
For example, the glassine bags of the gummies, etc.
Correct.
Okay. I wasn't planning to send those back, Ms. Lewis.
That's fine.
Not the gummies.
Very good.
Your Honor, is the court sending a computer back for the kind of audio video files? Got it.
We have an air-gapped computer that will not attach to the internet or connect to the internet that they'll be able to use to view files off a thumb drive.
Right, Your Honor.
I'm seeing comments about time limits. I think he was asked on Friday and said he wouldn't put time limits on these closings. I wish he had.
I can't imagine them going more than an hour apiece, right?
Caneros went 4.5 hours each.
Oh, boy.
That's what I say.
Yeah, FYI, this is true. The courtroom has been closed to the public today.
Yeah.
Yeah.
The victim's family asked for a couple of rows, and evidently, I didn't realize this, but they had assigned second row to one family, fifth row to the other family, third and fourth row to the public, and they alternated even odd days which family got the second row and which the fifth. And on the request of Eric's family, they're now doing media first row, 2 and 3, one family, 4 and 5, the other family, and they're still alternating days as to who gets rows 2 and 3 and who gets rows 4 and 5. And there's no room for the public now.
Well, our friend G Money McKelvey is in the courtroom today. I talked to her last night, and she's going to hop on and do tomorrow, I think, a lunch live with us. Even if there is a verdict before then, she'll hop on. She's inside the courtroom today. You see Kouri in her floral blue blouse. She's one of the better dressed defendants that I've seen. You know, you go back to Sarah Boone and a million others. They seem to be in the same thing every day.
Ladies and gentlemen, welcome back. We will begin this morning with jury instructions. Then we'll take a restroom break, and then we'll proceed with closing arguments. You have a copy of the jury instructions on your chair. You're welcome to read along, but you're not required to. You'll be able to bring those back with you into the jury room to review during your deliberations. And we can fast forward to instruction number 13. The preceding pages before instruction 13 are just a written copy of the jury instructions the court gave prior to opening statements. Closing roadmap. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I'll give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. Prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. You have two main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all questions of fact. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances that you find do not exist, you may disregard that instruction. Please perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Regarding closing arguments, when the lawyers give their closing arguments, please keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Please do not interpret anything I've done as indicating that I have any particular view of the evidence or the decision you should reach. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Regarding items not admitted into evidence, transcripts, police reports, or other written audio or visual materials may have been referenced during the trial but not admitted as exhibits. It's common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Regarding witness credibility, in deciding this case, you'll need to decide how believable each witness was. Please use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you're convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, please remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Evidence has been presented that a witness was previously convicted of a crime. This evidence was brought to your attention only to help you evaluate the credibility of that witness. Do not use it for any other purpose. It is not evidence of anything else. An informant is someone who provides evidence against someone else for a personal reason or advantage. The testimony of an informant alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though not corroborated or supported by other evidence. You must examine and weigh an informant's testimony with greater care than the testimony of an ordinary witness. You must determine whether the informant's testimony has been affected by self-interest, by an agreement they have with the government, by their own interest in the outcome of the case, or by prejudice against the defendant. You should not convict a defendant based on the unsupported testimony of an informant unless you believe the unsupported testimony beyond a reasonable doubt. A person may testify under a grant of immunity, that is, an agreement with the government. Their testimony alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though it's not corroborated or supported by other evidence. You should consider testimony given under a grant of immunity with greater care and caution than the testimony of an ordinary witness. You should consider whether testimony under a grant of immunity has been affected by the witness's own interest, the government's agreement, the witness's interest in the outcome of the case, or by prejudice against the defendant. On the other hand, you should also consider that an immunized witness can be prosecuted for perjury for making a false statement. After considering these things, you may give testimony given under a grant of immunity such weight as you feel it deserves. You should not convict a defendant based on the unsupported testimony of an immunized witness unless you believe the unsupported testimony beyond a reasonable doubt. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crime charged. This presumption persists unless the prosecution's evidence convinces you, beyond a reasonable doubt, that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. The defendant has entered a plea of not guilty and denies committing the alleged crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume that the defendant is not guilty. The defendant does not have to prove anything. She does not have to testify, call witnesses, or present evidence. Regarding direct and circumstantial evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside, saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about whether she was the sole author of a book. This evidence was not admitted to prove a character trait of the defendant or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for the limited purposes of determining motive, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict the defendant simply because you believe she may have committed some other acts at another time. Regarding fact versus expert witnesses, there are two types of witnesses: fact witnesses and expert witnesses. Usually a fact witness can testify only about facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of experts, you may look at their qualifications, the reasoning process the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Please use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. Give it whatever weight you think it deserves.
That's
You
Eric's
have heard
sister.
the testimony of law enforcement officers. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Regarding the defendant not testifying, a person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Regarding conduct and mental state, a person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it's enough that the defendant acted recklessly or with criminal negligence or with some other specified mental state. Later, I'll instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. Some definitions. On or about includes any day that is near the day alleged in the information. For pecuniary gain means for the acquisition of money or something of monetary value. Attempt means the actor engages in conduct that constitutes a substantial step toward the commission of the crime and intends to commit the crime, or when causing a particular result is an element of the crime, acts with an awareness that her conduct is reasonably certain to cause the result. Conduct constitutes a substantial step toward the commission of the crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act that puts a writing into circulation and implies, by word or action, that the writing is genuine. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Elements of count 1, criminal homicide, aggravated murder. Kouri Richins is charged in count 1 with committing aggravated murder between on or about March 3rd and March 4th, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins intentionally or knowingly caused the death of Eric Richens under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 3 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Elements of count 2, attempted criminal homicide, attempted aggravated murder. Kouri Richins is charged in count 2 with committing attempted aggravated murder on or about February 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins attempted to intentionally or knowingly cause the death of Eric Richens under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of attempted aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Definitions of mental state related to counts 1 and 2. For the purposes of counts 1 and 2, a person acts intentionally or with intent when her conscious objective is to cause a certain result. A person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. Elements of count 3, insurance fraud. Kouri Richins is charged in count 3 with committing insurance fraud between on or about January 29 and August 31 of 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 4, insurance fraud. Kouri Richins is charged in count 4 with committing insurance fraud on or about June 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins, with intent to deceive or defraud, presented or caused to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract. Knowing that the statement or representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 5, forgery. Kouri Richins is charged in count 5 with committing forgery on or about January 29, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with purpose to defraud anyone, without the authority to do so, did make, execute, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Definitions of mental state for counts 3, 4, and 5. For purposes of counts 3, 4, and 5, a person acts intentionally or with intent when her conscious objective is to engage in certain conduct. A person acts knowingly or with knowledge when the person is aware of the nature of her conduct, or is aware of the particular circumstances surrounding her conduct, or is aware that her conduct is reasonably certain to cause a particular result. A person acts recklessly when she is aware of a substantial and unjustifiable risk that certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway, or her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such a magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an omission. Separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Regarding jury unanimity, because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, please consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views, and keep an open mind about what others have to say. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Let's pause there for now. That went a little quicker than I anticipated. Mr. Bloodworth, would you like to proceed?
Yes, Your Honor, we may proceed and then maybe take an intermission.
Understood.
Like the theater. Those instructions were
No problem.
pretty standard. The only real difference was the instruction on credibility for informants
We sure did.
and those under grants of immunity, and those were the ones you may recall were argued on Friday. The defense thought they were appropriate, and the judge agreed, but they located different instructions.
Mr.
in the
Bloodworth, would you like me to
defense
publish
issues
the slide
deferred.
deck now?
Yes, Your Honor, please.
There you are. Please proceed.
Thank you. Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison, and her mother a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. She met Eric Richens. He was a successful business owner. He had money. They had a son, married, and had 2 more sons. Kouri Richens was on her way. But she was unhappy. She wanted to leave Eric Richens, but did not want to leave his money. Their prenuptial agreement meant that if she left him, she would also leave most of his money. So, Kouri Richens took $250,000 in equity out of Eric Richens' home without him knowing it, so that she could start her own business and earn enough money to leave Eric Richens. Kouri Richins is intensely ambitious. First with Eric's money and then other people's money, Kouri Richins carefully curated the facade of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks. She borrowed money by any means necessary at exorbitant rates. She gambled other people's money and lost. Her business was imploding. All the while, Kouri Richins was more interested in spending time with Josh Grossman than Eric. She dreamed of living in the Midway Mansion with Josh, running it as an event center, farming and raising kids, Eric's kids. But she did not have the money to leave Eric or the money to salvage her business. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die. As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. The state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count and then within each count, element by element, to show to you how the state has met its burden of proving aggravated murder, attempted aggravated murder, 2 counts of fraud, and forgery. That, again, is the reasonable doubt instruction that Judge Mrazek just read, and you will have back with you in the jury room. Judge Mrazek also read this instruction on what evidence is, and it's usually testimony and exhibits. To reiterate, what the attorneys say is not evidence. And as I asked you in opening, please focus on the evidence. Throughout this presentation, I generally use this format for slides. And so everybody understands where we are, the count, and then the element within the count is at the top in the red banner. We then quote some witness testimony, and we cite it because it's the evidence that matters. So that you'll have the exhibits back with you when you deliberate, and you can reference them. Usually it's a transcript, page, line, number of the testimony. We also publish exhibits. And usually we'll have an exhibit number down here. If there's an exhibit, whatever, 2-5, so you can reference it. Let's begin with the aggravated murder count. The evidence will prove that Kouri Richins was the person who committed the aggravated murder. The evidence will prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Karm and Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. That's what matters. That's murder. These two elements are just murder. Right? If we hide this, that's a murder charge. Here we have an aggravated murder charge, and the state will prove two separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? For money. The second aggravator is a how aggravator. How did she do it? Here, by the administration of any substance, here it happens to be fentanyl, but it could be any substance administered in a lethal amount. Either one of those aggravators are what transforms this case from a murder case to an aggravated murder case. So, first count, first element, was it Kouri Richins? Yes. The state has proved that Kouri Richins had the means, here the fentanyl, the illicit street drugs, the motive, here money, and a fresh start at life, and the opportunity to kill Eric Richins. She was the only other adult in the home at the time. Nobody else killed Eric Richins. Now, intentionally or knowingly caused the death of Eric Richins by administering the illicit street drugs. The state will prove with all kinds of evidence, testimony, exhibits, patterns of her behavior, and what each of us know about humans, that she intended to cause Eric's death. She intended it probably as early as December the 7th, 2021, when she booked a trip for her and Josh Grossman to the Caribbean for April. People don't book that trip. Kouri Richins did not book that trip thinking Eric Richins would be alive in April. She booked it knowing he would not. In December, before Eric died, before Kouri Richins murdered Eric, she told her friend, Becky Lloyd, in many ways it would be better if he were dead. That proves she intended to cause his death. This was the New York Life policy that covered the C&E buy-sell agreement. And on January the 1st, 2022, Kouri Richins changed the life insurance beneficiary on Cody's policy from Eric to her. The evidence proves that Kouri Richins didn't understand that was Cody's policy. And when she figured it out, she went ahead and changed it back. Because she planned to murder Eric. She did not plan to murder Cody. But she planned to murder. Kouri Richins asked two people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world. but she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because it is lethal, it is fatal, it kills. And she wanted lethal, fatal death. Kouri Richins is intensely ambitious. She wanted the perfect life, or at least the appearance of the perfect life. And for her, that meant Josh Grossman. But first, Eric had to go away.
So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted, to buy
Did
it.
she ask for blue specifically, or fentanyl specifically, or did she ask for oxygen? What did she ask for?
No. I think she might have asked me for blue. I can't remember.
But you sold her M30, right?
Yeah, I told her what she knew what she was buying.
Okay, so she it wasn't like she's asking for oxys or something like that, and she got the M30.
Right, no.
Okay. She knew that there was fentanyl in those pills.
At Kouri Richins' request, Carmen Lauber purchased illicit street drugs from Robert Crozier. It's those illicit street drugs that killed Eric Richins. It's those illicit street drugs that Kouri used to murder Eric Richins. And while there may be some question as to whether she specifically ordered fentanyl or she knew she was getting fentanyl, the evidence proves she at least knew it. She wanted fatal, lethal, illicit street drugs. And all the testimony from Carmen Lauber, Robert Crozier, digital forensics, we'll get into it, all confirm that Kouri Richins ordered and received illicit street drugs, and that those street drugs contained fentanyl. Illicit street drugs is all that matters. But you heard the testimony that despite confusion in what people were ordering, people were getting fentanyl. The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we know that it was this purchase that ended up killing Eric. It's the fentanyl. We can trace the fentanyl. Next slide. The digital forensics corroborate Carmen Lauber's testimony that 5 days before Kouri Richins murdered Eric Richins, Carmen Lauber purchased for Kouri Richins fentanyl from Robert Crozier at the Maverick in Draper. The call detail records show an extraordinary amount of overlapping communication between Carmen Lauber, Kouri Richins, Carmen Lauber, Robert Crozier during that time. We, of course, don't have the communications. Carmen Lauber deleted them because they were evidence of a drug deal. Kouri Richins deleted them because they were evidence of a drug deal and a murder. Robert Crozier said he had lost his phone. But that's an extraordinary number of communications. We know that Kouri Richins, the evidence proves that Kouri Richins used a Moscow mule and a shot to administer the fentanyl to Eric. She writes it in her orange notebook where she journals what happened the night she murdered Eric. It's a self-serving journal. We'll discuss that down the road. But she wrote Moscow mule and a lemon drop shot. And that is consistent with all the toxicology. Again, in the notes that investigators recovered from the kitchen cabinet in Kouri Richins' home, she wrote Moscow mules. Lemon water, vodka, and rum. She left out the main ingredient, which of course is the ginger beer. But there was ginger beer. We know that from the cock and bull that OME investigator Cam Sessions found in the trash can in the kitchen. It's interesting that Kouri Richins wrote vodka in parentheses rum. The evidence may show that the Moscow mule she made that night was ginger beer and fentanyl. The lemon drop shot may be lemon and fentanyl. Notice that here she writes drink in bed. We'll come back to that in a minute. The cock and bull, as I mentioned, corroborates at least the Moscow mule. And that we know the cause of death from the death certificate was fentanyl. The fentanyl and the illicit street drugs that Kouri Richins got from Carmen Lauber, who got from Robert Crozier. We know that Eric ingested the fentanyl from the Moscow mule, the lemon drop shop, or both. Medical examiner Dr. Pamela Ulmer, toxicologist Brianna Peterson, chief medical examiner Dr. Eric Christensen, all testified that the 20,000 nanograms per milliliter of fentanyl, an extraordinary amount, in his stomach indicates oral ingestion. Indeed, Dr. Christensen not only testified to it, he told Kouri Richins that in their phone call that she recorded. Ms. Peterson's testimony, as well as Dr. Christensen, also proves that the fentanyl was illicit. Again, illicit coming from the street, illegal street drug, illicit fentanyl. And it was their testimony, right, was that there was not only fentanyl in the toxicology, but there was norfentanyl, which was a marker of an illicit fentanyl. There's also acetyl fentanyl as well. But it's the norfentanyl that is a marker of illicit fentanyl, which completely tracks with how Kouri Richins got the illicit street drugs. We also know that Kouri Richins intended to kill Eric Richins because the toxicology contained quetiapine.
Your Honor, we may have lost the audio. Let's reset. My apologies.
They're having an audio issue inside the courtroom, I believe.
Yeah, it's the video thing that went down, whatever you call the video thing.
I like the presentation with the slides. Here we go.
Last one. What is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay. I gotcha.
It's a prescription, mental health medication that's prescribed for different things.
I gotcha.
I think it was her prescription.
The quetiapine in the toxicology for Eric Richins shows that Kouri Richins was involved because she was prescribed quetiapine. Now, this conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her prescription. Of course she knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She feigns the ignorance. She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter. In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911. The evidence proves that is not true. The evidence proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
Damn.
She then unlocked her phone again at 3:08, 3:10, 3:15, 3:19, 3:19. And then 15 minutes later, she called 911. That is not immediately called 911. Perhaps she was staging the scene during these 15 minutes. We're going to discuss the 911 call in a minute. This is a receiver activation. At 3:22:12, when we're in the 911 call, she's on receiver on her phone. The 911 call operator asks her, "Are you on speakerphone?" She says yes, no. She's on receiver. Before we play this, sorry. We're going to listen to the first part, actually most of the 911 call again. I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow. To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a black widow. Listen to how Kouri Richins, on the 911 call, immediately presents, or very soon after the call begins, presents her alibi narrative. Listen to how she tells the 911 dispatcher where she was when Eric died. She is distancing herself. Rather than, he's not breathing, he has no pulse, I have to figure out what to do, I need help, she's saying, hey, look, I was not there, I was in my son's room. That's her alibi. She's distancing herself from the time and the place that she murdered Eric. The 911 call operator asks her to perform CPR. Notice how she distances herself from that. No, I don't know how. No, he's too heavy. No, I can't move him. She is not immediately trying to revive him. We're going to run a clock from the time that the dispatcher asks her if she can start CPR to the time she purportedly starts it. It's 6 minutes. Listen, please, to the portion of the 911 call where the operator instructs Kouri Richins how to remove Eric from the bed. Listen how the dispatcher says, move to the side of the bed. Kouri Richins says she does. Remove the pillows, pull the arm, pull the leg, lift up the sheet, pull him off. If Kouri Richins is following the instructions of the 911 dispatcher, Eric Richins' body is on the floor on the side of the bed, not the foot of the bed where it was found. Listen also to her choice of language. She has dehumanized Eric Richins. When she is talking about removing Eric from the bed and she is protesting and she is saying she cannot, she is not saying, I can't move him. She is saying, I can't move it. Eric is no longer a him to him. She murdered Eric. Eric is an it. Finally, listen to when she says she is performing CPR and the phone is on speaker. The phone's not on speaker. Determine whether she's performing CPR. Okay, Skye.
My husband's not breathing. He's cold. Okay, what's the address? 282 Willow Court. 282 Willow Court? Uh-huh. Okay, what's a good phone number in case we get disconnected? 435 671 4987. Okay, it's going to be in Francis. Okay, tell me exactly what happened. I don't know. I just came in. I was sleeping with my kids. Okay, I can't understand you. I need you to take a deep breath. What's going on? I don't know. I was sleeping in with my kids. I just came in our bed, and I turned over, and he's just cold. He's just cold. Who's cold? My husband. I turned the light on. And he's not breathing? No. He's not breathing? No. I need you to confirm it for me. Is he not breathing? No. Okay, can you do CPR? You don't know. I'm going to tell you how to. Are you willing to do CPR? Yeah. Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it. No, there's not. Available? Okay. I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next, okay? Okay, are you right by your husband right now? Yeah, he's so pale. His mouth is open. Okay, listen carefully. Are you able to lay him on the floor or the ground? On the floor, on the ground? I'm just thinking. I can't touch him. I can't. You can do it. You can do it. You need to calm down, okay? Yellow. We need to help them. I can guide you through CPR. Take a deep breath for me. I'm here with you. He doesn't have a pulse. He doesn't have a pulse? No. There's no pulse. Okay. I'm here with you. I'm here with you. We need to get him help. If you need to put me on speaker, put me on speaker. I'm gonna guide you through CPR, okay? Okay. Tell me when you've done that. Okay, I'm ready. You're ready? Okay, he's on the floor? He's on the bed. Okay, are you able by any chance to move him on the floor? Let me check. Thoughts on it. I don't know what's happening. Okay. I'm here with you. Are you not able to, you're not able to move him to the floor? No, go out. Don't come in here. Oh my God, my sister. You're not able to move him to the floor? Just listen carefully. We just need to get him on the floor. Don't worry about hurting them. No, he's just heavy. Is he still on the bed? Yes. Okay, if there's a sheet or a blanket under them, can you loosen it from the mattress? Yes. Okay, stand at the side of the bed closest to them and remove anything under their head. Okay. Okay. I need you to pull the sheets towards you and slide them off the bed. Don't worry about him falling. We just need to help him now. Okay. Tell me when he's on the floor. I can't move it. It's a dead weight. Like it. You're not. If he has sheets under, pull them to the floor. Don't worry about hurting him. Can you please send somebody? Okay, I have the ambulance that's on the way. Okay, there's another way to do this, okay? Grab their feet. Grab his feet. Okay. Slide them towards you until they're just off the bed. Okay. How old is your husband? 39. 39? Yeah. Okay. Okay, were you able to put his feet off the bed? I'm pulling. Okay, now grab the arm closest to you and pull the rest of the way off the bed. Again, don't worry about the fall. We just need to help them now. I have the ambulance on the way. I just need you to do this, okay, so we can get the help for him. Okay.
Once they arrive, they'll take over. We just need to start CPR now. You are doing great, okay? I just need you to get him on the floor.
Okay, he's on the floor.
You got him on the floor?
Yeah.
Okay, listen carefully, okay? Make sure that there's nothing under his head. Is he laying flat on his back?
Yeah.
Okay. Okay, just listen carefully and I'll tell you how to do chest compressions, okay?
Okay.
Place the heel of your hand on the breastbone. This is in the center of the chest, right between the nipples.
Okay.
Put your other hand on top of that hand.
Okay.
Okay? Start pumping the chest hard and fast, at least twice per second, and 2 inches deep.
Okay.
Okay, start counting out loud so I can count with you, okay? We're gonna count 1, 2, 3, 4, okay? Let me know when you're ready.
1,
1, 2, 3, 4. One, 2, 3, 4. Count out loud so I can hear you. I'm counting with you. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1. If it's easier for you, am I on speaker?
yes.
Okay. 1, 2, 3, 4. Do you know if the front door is open?
No, it's locked.
Are you? I need you to go. Is there anybody else within the home, or is it just you?
It's all my kids.
Okay. Are one of them old enough to go unlock the door?
Yeah, it's unlocked.
It's unlocked now.
Yeah, he's here. He's there.
Okay.
At the, yeah. The protesting that was part of the 6-minute delay in Kouri Richins performing CPR. I can't move it. It is just dead weight. Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him. None of that happened. She's covering up her involvement in murdering Eric Richins. Recall the alibi narrative at the beginning of the 911 call. Her letting the 911 operator and everyone know that she was not with Eric when he died. I was somewhere else. I was distant in place and time. When she calls her father-in-law, Eric's dad, Gene Richins, what does she say right at the outset? I was sleeping with Ashley and I came into the room. Gene, I wasn't there. Wasn't me. When Eric's sister Katie arrives, he wasn't breathing. I went to bed. I was in Ashton's room. He was having nightmares. I wasn't there. It was not me. Her alibi. Her cover-up. This is the written form that sheriff's deputies gave Kouri Richins early morning of March 4th to write out what happened. It says, describe in detail what you saw, know, or heard of the incident. Where does she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink. She didn't start with, I walked into the bedroom at 3 a.m., my husband was not breathing and cold. Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began. And then more of her self-serving alibi narrative. It wasn't me, I wasn't there. Before she gets into really what matters. Intentionally or knowingly caused the death of Eric Richins. We know it was intentional because she planned the immediate reaction. When she spoke with Eric's sister, Katie, very shortly after medical examiners rolled Eric Richins' body out of his home for the last time, she told Katie that she was going to plan the she was going to follow through with the purchase of the Midway mansion. She was going to sell the home that she was living in. And she had a plan for running Eric's business, C&E. The morning of Eric's death. She had those plans in place because she knew she was going to murder Eric. She had already thought about not only murdering him, but what I'm doing immediately after murdering him. Her plan with the Midway mansion is consistent with her dream of living there with Josh Grossman, running it as an event center, farming and raising Eric's kids. Her plan to sell the home she lived in proves that she had no idea that home was in a trust. And she couldn't sell it. Her plan on running Eric Richins' half of C&E shows that she did not understand the buy-sell agreement, the life insurance coverage on the buy-sell agreement, or that that life insurance coverage went to the trust, not her. The morning Eric died, she had a plan on how she was spending Eric's money and didn't realize it was trust money. We know that Kouri Richins intended to kill Eric. The evidence proves that she intended to kill Eric, in part based on her conversation with Josh Grossman shortly after killing Eric. Kouri Richins asked Josh if he had ever killed anybody. Killed was her word. Not have you ever lost a loved one. How do you agree? Not have you ever walked in and found a dead body unexpectedly. Not how do you respond to a tragic and horrible accident. It is have you killed? And then she asked how it made him feel. She asked that because she was working through her own feelings on killing and wanted Josh to help her work through those feelings. And never mind that that's a highly selfish question. She's worried about working through her feelings on killing. Never mind Josh Grossman's feelings on having had to have killed in service of his country. It was her feelings that mattered. walk the dog letter. There's a lot to unpack in this. But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico. She goes on to talk and says, Eric finally told me and asked if Carmen could get him some pain pills and fentanyl from Mexico. Some refers back to pain pills in Mexico from fentanyl. Sorry, pain pills and fentanyl from Mexico. Kouri Richins knows 4 months after she's been arrested for Eric Richins' murder, a year and a half after she murdered him, she knows that she bought fentanyl, and she has to explain it. And how does she explain it? A year and a half after murdering Eric Richins, she blames it on Eric. Oh, I bought it for Eric. That's the sum of the evidence. Her self-serving statement asking her brother to testify falsely that she brought it from Eric. For Eric. Year and a half after she murdered. Kouri Richins did not tell the 911 dispatcher, hey, I just bought some fentanyl for Eric. She didn't tell the paramedics, he might be dying from the fentanyl I just bought for him. He didn't tell the deputies that responded. He didn't tell Detective Woody. He didn't tell Dr. Ulmer. Didn't tell Christensen. Didn't tell her friends. Didn't tell her family. All the off-ramps she had the opportunity to take to say, hey, I bought the fentanyl for Eric. She doesn't, because it did not happen. She did not concoct this story until a year and a half after she killed him. And it is a story. It's a fake story that she wants her brother to testify to. There are, of course, other inaccuracies. Kouri Richins in the Orange Notebook writes, self-servingly, when the EMT walked up to me and said he didn't make it, we did all we could, I lost it, I immediately ran to the bathroom. This is the video of when the EMT walked up to her. We'll stop it there. We could play it for several more minutes. She doesn't immediately or otherwise run to the bathroom and throw up. When people make up stories, they are inconsistent in the retelling. Here, in the orange notebook, Kouri Richins says they make the Moscow Mule and the lemon drop shot in the kitchen, and then they go to bed and brush their teeth. Here, they drink it in the bedroom, not the kitchen. Kouri Richins tells her attorney, it's on the right, she tells her attorney that Eric was on the phone when she went into Ashton's bedroom. But Eric Richins' phone activity tells a different story. Kouri Richins repeatedly said that she went into Ashton's bedroom 9:30, 9:45. Eric was off the phone before 9. In the orange notebook, Kouri Richins says that Eric was awake when she went into Ashton's room. In that rambling phone call with Bryce Knutson that Chelsea Barney recorded, she suggests that he was asleep because she says when she returned to the bedroom about 3 a.m., Eric was in the exact same position as he was when he fell asleep. That means she was there when he fell asleep, not in Ashton's room. Her story is inconsistent in the details. That proves that much of it is fake. We've read text messages throughout this presentation. We'll continue to publish some more for you to read. None of those text messages were recovered from Kouri Richins' phone. They were recovered from Eric's phone, Chelsea Barney's phone, Josh Grossman's phone, but not Kouri Richins' phone, because they were deleted. That is part of her cover-up. When comparing the contents of the phone with few to no text messages, with the contents of the call detail records, with thousands of text messages, that's how we know they were deleted. When Detective Woody executed the first of the search warrants on April the 13th, 2022, and she informed Kouri Richins that toxicology showed that Eric died of fentanyl poisoning, Detective Woody seized her phone. On her phone that she got to replace the seized phone, on the phone that Kouri Richins got to replace the seized phone, these are the searches. What was Kouri Richins worried about? She was worried about the police recovering all her deleted text messages. Why? They're inculpatory. They would further prove that Kouri Richins bought drugs from Carmen Lauber to then murder Eric Richins. Her phone searches reveal what she was thinking. She's worried about being investigated. She's worried about having to take a lie detector test. She's worried about my office. She's worried about her seized electronics. Prison is on her mind. So is money. She's interested in the life insurance. We don't know precisely when these searches were conducted. It's just not in the digital data. We have the data we have. But we do know that she hasn't been paid out yet on life insurance. And she started getting paid out in June of 2022. And this phone she got in April of 2022. So the inference is that these searches occurred between April and June of 2022. This one's the most insightful. If someone is poisoned, what does it go down on the death certificate as? She didn't search if someone accidentally ODs. She doesn't search if somebody is dead for unknown reasons. She searches if somebody is poisoned, because that is what happened. Now we have to prove that Kouri Richins intended to murder Eric Richins, which means we have to prove that Eric Richins did not commit suicide. Kouri herself says he didn't. No mental health concerns. But the other evidence proves it as well. Eric had every reason to live. The first three of which are Carter, Ashton, and Weston. He was a phenomenal father. He protected his boys. He put his money in trust mostly for the benefit of them, to protect them. He was a protector. He's not leaving his boys. He was also planning for the future. He was a successful business person, and he and Cody had future business plans. He had future plans with his sister. They were planning family vacation to Disneyland. He was planning on buying a cabin in the Uintas with his father for the family. Every shred of evidence in this case proves that Eric did not commit suicide. This wasn't an accidental overdose. Eric Richins did not use drugs. He did not use illicit drugs. Set aside THC gummies. Kouri Richins said no, never to Deputy Wynn and Paramedic Offred. These are people that it would have made sense to tell he used illicit drugs to in the moment as Paramedic Offred's trying to save Eric's life. But no, she was honest. Nope, never. Same thing with Dr. Ulmer as they're reviewing the toxicology and trying to explain the fentanyl, right? Dr. Ulmer's like, well, there's this fentanyl, really can't explain it. Did he do illicit drugs? No, never. Grossman, she's honest with anybody. She's honest with Grossman. No, Eric did not use drugs. Her best friend, another person she's honest with. Nope. Life insurance company? No. Chief medical examiner? No. And every bit of evidence that came into this case, everyone who testified and knew Eric well, his friends, his family, no, Eric didn't use illicit drugs. Not even prescription drugs. Your Honor, this might be a good place to take a break.
Let's do it. Folks, one moment, just a friendly reminder. Don't talk about the case. Don't allow anybody to talk to you about it. Do not do anything with your devices during this break related to this case at all. We'll return at 10:20. Please rise for the jury.
So a 15-minute break.
Yeah, 15 minutes. Kouri Richins kind of opening her eyes there as if to check if it is reality, and it is reality. She's making some interesting faces and gesticulating. At one point,
Court's in
there's
recess
an
until
objection.
10:20. Thank you.
All right, so it's a 15-minute break. At one point, there was an objection from Kathy Nestor, and she was told to be seated. Overruled. Very abrupt there. Joe Potuto, I mean, I think this is really effective. You know, prosecutors are not Tim Jansen's. They're not super animated. They're not, you know, they don't have the perfect tie knots like Tim Jansen. But this I thought was really effective with the graphics. What was your overall take so far?
Oh, I did too. I thought what was really effective was the ability to contrast what she claimed to be saying with what was actually happening, and to do it with her own voice, with those videos, with her own texts. I thought it was extremely effective. Really well done.
Yeah, I mean, he starts out. By the way, he's doing this sort of noteless. I mean, he does have exhibits up, but he's just doing, you know, from his head, which is impressive to me. But he mentions the book right out of the gates, a children's book, and he said that you know, talked about motive, intention. This, by the way, I'm sorry. This is the judge's. The judge was giving instructions, so he talks about the book to the jurors and says you can look at it as motive, intention, planning, but not as character assassination. And that was the last set of instructions he gave the jurors. And then Brad Bloodworth, the prosecutor, gets up and talks about how they met, how she meets Eric, and that she's quote unquote incompetent behind the facade, that she was borrowing money at exorbitant rates, that her own business of flipping houses was imploding because she was basically borrowing money and it was becoming a funnel where the money was disappearing. And then he brings up, Joe, the first thing is a graphic of aggravated murder charges, and one is pecuniary gain, which is for money. And the second is, he says, how she did it, which is fentanyl. How important, I guess, is it to have these visual exhibits coincide with what he is telling the jurors here?
Well, I think it's very helpful. Some people are visual, you know, visual learners. They do better reading. We absorb information different ways. So to do it two different ways, I think is really effective. I just thought it was a very, very well organized, you know, step by step by step. And I don't know that it would have been more effective if he was more, you know, sort of evocative. I think it was so effective because it was him simply saying, hey, I'm taking you through this piece by piece by piece. And I just thought it was really, really well done.
Yeah, the objection, that was during, I think, when the 911 call with CPR. Do you know, some people are saying it was Lewis and not Nestor.
I thought it sounded like Lewis. She's the one who has the raspier voice.
Yeah, but any idea what she was objecting to there?
I'd have to go back and look. I think in part it was simply trying to interrupt the flow. I can find it because I thought the judge, I love the way the judge handled it. He didn't give her a chance to even get the objection out. I know what she said. It was facts, not in evidence, because he was talking about the fact that the messages were not on the phone anymore and they had been eliminated. And she started to say, you know, there was no evidence as to that. And she got out 4 words and the judge just stopped her cold.
Yeah, he said, please be seated, I think is what he said.
Yes. In the language you would use to a 6-year-old after you've had it with the 6-year-old all day.
Yeah, pretty much. So, and by the way, we're on now a 10-minute break, and the government is still, you know, doing their closings. I think he probably went about, I'm guessing, close to an hour there.
Well, I know when it started because I wrote it down this time. I said, I'm not going to get caught again with not being able to figure it out. It started at 11:04 Eastern time,
Yeah,
and
so
they just took the break. So
it was about
you're right.
exactly an hour.
Right,
So
you're exactly right. I'll tell you, Joe, the thing I thought that was really well done is his talking about illicit street drugs and saying might have been fentanyl. We know he died of fentanyl, so we know it was fentanyl, but it doesn't matter whether she asked for the Michael Jackson drug or something else. She's the only one in the house. There's no evidence, and he goes on to say that Eric committed suicide or overdosed. And so whatever it was, she wanted something she wanted a killer drug. He didn't say killer drug. I wished he had. And so it doesn't matter what it turns out to be. We don't have to prove it was fentanyl. We have to prove he died of the ingestion, by Kouri getting him to ingest a lethal drug.
Yeah, and this from Sheila Marie, calling your husband it says it all. I never caught that prior to now, and if I did, I didn't remember it, but that's pretty damning too. On the 911 call, she sort of switches from he to an it, which is really, I guess, subconsciously or maybe consciously saying a lot. But Brad Bloodworth goes on to say, again, why this is aggravated, why these are aggravated murder charges and not just regular murder charges, then talks about means, motive, and opportunity, which is what you hear prosecutors talk about a lot. He talked about a trip she had planned with Josh Grossman, her lover. And then to your point, Joe, he gets into the fact that she's not a street savvy person, but had asked specifically for the Michael Jackson drug. So she was looking, and it was clear that she knew that Michael Jackson died. So she was looking for a drug that would kill her husband. And that's small but huge there. I mean, you found that powerful, the fact that she's asking for the Michael Jackson drug.
Yeah, and it's particularly so since, in fact, Hayden Jeffs, who died in that motorcycle accident, and so what he would have, I guess it was his sister that he had told this, what she had actually asked him for was fentanyl. But the state could not get that in because he was gone. It would be hearsay for someone else to report it. That was that big argument they had last week when the defense wanted to get in evidence from someone else that they thought would help the case. And the judge said, well, if you do that, you recognize that Jeff's comments, which we kept out, will then come in. And so the defense decided not to push on the other hearsay they wanted in, because that would have been even stronger, much stronger, if they'd been able to get that in. Yeah,
and then they also, Brad Bloodworth also used video presentations there. He had the Rob Crozier, who's the alleged drug dealer, or I guess not alleged anymore, and plays video of this drug dealer talking about what Kouri was asking for. And then Brad Bloodworth goes on to say, we know she used a Moscow Mule in a shot. We know because she journals it. I mean, Joe, how many times does an alleged killer get themselves convicted because they're writing about it or talking about it? It seems that it happens all the time.
Well, we certainly know in the last, few months. We have Donna Adelson in her jail trying to get somebody else to testify falsely and writing it out for her. And now we have Kouri writing out that walking the dog letter for her brother. So I don't know how often it happens, but we know it's happened twice recently.
Yeah, and then there's talk, Joe, walk us through this part about quidapine, I think it is, which is Seroquel, if I'm pronouncing it correctly. But why does that become important here?
Well, that was also found in I think it wasn't found in his blood. It was found when they did that second autopsy. But the prescription was her prescription, not his. And when she talks to the ME, makes it sound as though she's never heard of the drug in her life and she doesn't know what it does. It's her drug. So it's another instance of her just flat out lying. And why? why would she say to the ME, I've never heard of the drug, I didn't know, it was in a system. So I think what the state is doing is two things. One, to show yet again that she's lying, and two, why would she be lying there about that drug if it weren't that she wanted to distance herself from the fact that it was her prescription drug that was found in, when they did the autopsy on Eric.
Yeah, well, Bloodworth calls that the smoking gun, which is interesting. But you see here from Walkway Renee, Seroquel isn't just a sleeping pill; it's an antipsychotic. My question is, do we know why she was on an antipsychotic, Joe Potuto?
I have no idea.
Yeah,
but I think your mother the other night suggested, didn't she, that she wouldn't diagnose, but maybe
she knew. I mean, I know my mom knows of the medication, I think, but someone said it's prescribed for sleeping as well. It's kind of interesting that it's, I guess, for psychosis too. So I don't know. But I think there's some of that in Kouri Richins, which is what makes it interesting.
Yeah.
But
I didn't realize, Joel, you have to, I'm really impressed at the prosecutor, because you have to really examine closely the evidence, really closely. I had not realized, and I listened to that recording, the 911 call, but he's right. The person on the 911 call is talking to her about going to the side of the bed and trying to get him off the bed, and he's found at the foot of the bed. Mm-hmm. Now that's not a big deal, but it's another piece of, her story, and the evidence that you can't dispute don't turn out to be in the same place.
Yeah, well, I thought that was a really super effective part of the closing. Was Brad Bloodworth gets up and goes through, before playing the 911 call, explains the entire call, sort of play by play, and he starts by saying she's setting up the alibi by saying, I was in my son's room, and then he says, you're gonna hear her say, I can't move him, and then switches to I can't move it. And he says, Eric isn't it. And then on top of it all, Joe, they put in a CPR timer. They put in this graphic that is ticking away, showing you how long before she claims to do CPR. But then after she, quote unquote, attempts CPR, she talks about how it is just dead weight, again, using it. But people in the chat and the jurors are going to point this out, I'm almost sure too. She's not breathing heavy. It's not easy to do CPR. I mean, it's a certain cadence for a long period of time, and she's not at all winded, and doesn't sound like she did it at all. So again, Joe, the effectiveness of replaying this 911 call for the jurors to hear it yet again.
Yeah, he did a great job. I imagine what he did was he wrote out the chronology and the points in evidence that he really wanted to emphasize, and then they went back through and found the video, the audio, the text messages, all of the places in the testimony where they could introduce the information to underscore what he was saying. And he did with Carmen Laubert, because she's got to be corroborated as much as possible. He not only used Crozier, but he put up that schematic that the forensic, the person who was doing the phone calls had done, showing that Carmen Lauer said where she met Crozier, jibes with the phone evidence. And I also thought it was really effective to talk about the number of texts and the 3 phone calls among Carmen Lauber, Crozier, and Kouri Richins over that period of time. And, you're left with what possible reason could there be other than the drug deal?
Yeah.
Now, I'm assuming that the defense is not going to say, well, we'll hear. But my guess is they're not going to say that Kouri didn't ask for the drugs. They're going to say she didn't ask for anything like this, because it's a lot of evidence to go against to say it didn't happen.
Yeah, that's a good point. Well, that's a good point. I mean, and we're going to see how they're going to have an uphill battle. I mean, to me, this is overwhelming evidence. There are people in the chat who are saying, there's always going to be some, but there are people I saw in the chat saying that it is not beyond a reasonable doubt for them at this point. I'm not sure because I don't see it that way, but I have a feeling this is going to be a very quick deliberation. But I could be.
Well, they've got the
absolutely
5 counts, so and 3 of them are different from the murder and the attempted murder. And actually, the attempted murder really is different because it's a different date, and there's different evidence there. I still, I guess, would not be surprised if the jury came back with guilty on 4 counts, but either hung or were not guilty on that February attempted murder count. Because I do think there's less evidence there. Now, they may decide if she killed in March, she probably tried in February.
Yeah. Yeah. Primetime KCL. I also love how the prosecution is walking the jurors through each charge. Right after playing that 911 call, they juxtapose it to a message that Kouri sends to her best friend about, quote unquote, trying so damn hard to revive him, and it's very clear that she did not do that.
231-500-139. Mr. Bloodworth, are we ready for the
Thank
jury?
you to Skye.
Ms. Lewis?
Yeah, sure.
Let's do it.
All right, we're picking back up closing arguments from the government. Brad Bloodworth is the prosecutor.
I'm looking forward to how he handles the theft of her friend's $45,000, on that house purchase. That to me is just a terrible thing she did.
Yeah.
And I hope he goes after her on it.
Please have a seat as you come in.
Kouri,
Yes.
by the way, she had noticeable objections during that closing that she was speaking to Kathy Nestor about.
She's, this judge has let her make facial
Please have a seat.
expressions.
Yeah.
Other things, he's let the
Mr.
defense
Bloodworth,
lawyers
just make sure that mic is still on, and please proceed. Very good.
Thank you, Your Honor. Recall at the outset of closing when we were looking at the aggravated murder charge. I mentioned the first 2 elements are murder, and then we get into the 2 aggravators. So the closing up until now has been the murder charge. That is straight murder, but the state, of course, has charged aggravated murder. So now we'll talk about the 2 aggravators. The why aggravator, money motive, and the how aggravator, administering any substance in a lethal amount. You'll recall Brooke Carrington's testimony. And when she began her forensic accounting analysis, this drew her attention. The number of overdraft and non-sufficient funds transactions beginning in April. That jumped from 1 in September to 37 in October, beginning in October. That jumped from 1 in September to 37 in October to 77 in December. And Brooke Carrington's analysis was the beginning of the downward financial death spiral. Then Ms. Carrington analyzed the overall debt, and it showed a growing debt picture nearing $8 million in debt when Kouri Richins closed on the Midway Mansion. All the while, she's not paying it off. She's barely sending her creditors any money. And it's never an increasing amount of money. It's flat. The payday loans particularly showed distress to Ms. Carrington. This isn't a traditional mortgage. This isn't even hard money lending. This is give me money today, I'll give you money when you get paid at an extraordinary, exorbitant interest rate. And when Brooke Carrington saw this, she sees the line here go flat. Payday lenders would no longer lend to Kouri Richins. She was barely paying them off, or barely paying towards them. Kouri Richins lost money flipping homes. You heard Brooke Carrington testify about the extraordinary growth and unsustainable level of growth for even sophisticated business people. Kouri Richins is not a sophisticated business person. She didn't even understand fundamental accounting, fundamental tax reporting. Brooke Carrington plotted out the profitability analysis of each of Kouri Richins' home flips. Kouri Richins, when she bought a home, when you total up the home she bought and the loans she took out, she started her projects $2 million in the hole. When she was finished her projects, of money that Brooke could trace to expenses, she could only trace about half of it to expenses because Kouri Richins did not conduct normal accounting. Kouri Richins lost $469,000 on her home flips. But recall that Brooke Carrington testifies there's this other pot out there of $400,000 that I know she lost. I just can't trace it to a particular project. When you add those up, it's nearly $900,000 loss in flipping homes alone. And recall that Brooke Carrington said that does not count the foreclosures. While deliberating, you'll have this, and on the second page, you'll see all the foreclosures. She lost millions more in foreclosures. To include foreclosures on Chelsea Barney's home and the Midway Mansion. Kouri Richins would borrow money by any means necessary. 6 times she submitted inaccurate bank statements to lenders to get money. Those bank statements reflected her business account and balances in C&E's business account. This evidence proves the level of financial desperation that Kouri Richins was in late 2021 and early 2022. The next level of financial desperation is taking $45,000 of your best friend's hard-earned cash tips from waitressing, telling her that you are going to apply that as a down payment to a mortgage on her house where she lives with her partner and her children. And then diverting part of it to pay off Fund 5 merchant, a payday lender. And spending the remainder of it, as Brooke Carrington testified, on expenses to rehabilitate homes and servicing existing debt. then telling your friend, your best friend, since middle school, that you applied the money to the loan, here's the deed, sign the deed, and then not filing it. And you will see, if you review that Brooke Carrington's schedule that had all the property transactions, you'll see that not only did Kouri Richins not file the deed, she took out another loan on the house. That's the loan that was foreclosed on, that resulted in Chelsea Barney, her partner, and their children getting evicted and losing their life savings. That is the next level of financial desperation that Kouri Richins was in January 2022. There's the tax liabilities. In the grand scheme of the amount of debt, 150 grand in tax liabilities is de minimis, but they were on her mind. There's an interesting little nugget here. She underreported her expenses in flipping homes to her tax accountant, which resulted in her paying more taxes than she would have. One would think a sophisticated business person would think to limit their tax liability. That's not what interested Kouri Richins. What interested her was the appearance of success in business, the appearance of affluence. And by underreporting her expenses, it looks like she made more money than she did, and she appeared more successful than she was. Because she cared not about being successful, she cared about her facade. She cared about appearing successful. You'll recall that C&E distributed $36,000 to pay some of this $150,000 tax liability, which Kouri Richins then diverted to close on a home. And her tax liability was on her mind. 2 days before murdering Eric Richins, she spent over an hour and a half on the phone with the IRS. It was on her mind because if the IRS moved on her tax liabilities, Eric would find out. She had to fix it with the IRS before Eric found out. You're familiar. Kouri Richins needed cash immediately when she murdered Eric. Eric's long-term earning potential, immaterial. She wanted to close on the Midway Mansion. She had no money to refurbish it, to flip it right away, to run it as an event center. But she was going to close on it. She needed money now. Doesn't matter if Eric's going to earn a ton of money down the road. That does not help her now with the Midway Mansion. It does not help her now with servicing her existing debt. She needs money now because she's closing on the Midway Mansion on March the 4th. And when she closes on the Midway Mansion, it's worth $2.9 million. She's borrowing $3.2 million. None of it's her money. She's reaching into other people's pockets to get that money. Not only does she want money to purchase the Midway Mansion, she wants $87,000 for herself. She takes out $87,000 at closing, and how does she spend it? Servicing existing debt and expenses for rehabs. She ultimately closed on the Midway Mansion the day after she murdered Eric. There's an interesting thought here. Did she close on the Midway Mansion in spite of murdering Eric? Or did she close on it because she murdered Eric? She hedged. She was supposed to close on the 4th. She didn't want to close until she knew Eric Richins was dead. Because she knew she would have his money. She knew she could do something with the mansion. And that's why when everybody else signed on the 4th, or in advance of the 4th, she signed on the 5th. It's unconscionable that she closed in spite of his death. It's unconscionable that she closed because of his death. This is probably Kouri Richens' true plan for the Midway Mansion. And if Eric had not put most of his assets into trust, it could have happened. Recall Brooke Harrington's testimony that after closing on the Midway Mansion, Kouri Richens' liabilities were right about $8 million, and she was in the hole $1.6 million. Her net worth was negative $1.6 million when she murdered Eric. And that her business was in financial distress, her financial enterprise was collapsing, had been collapsing, and but for a significant infusion of cash and capital would continue to collapse. That significant infusion of cash and capital was supposed to be Eric Richins' money. You have a fortunate perspective during this case in that you get to observe the defendant. You get to observe Kouri Richins. And you observe her affect with some when some witnesses testify, and you observe her affect change when other witnesses testify. You observed that when we played the 911 call during trial, her affect was flat, no emotion. You also observe that when Brooke Harrington testified about the financial distress of her business, she was exercised. Because that testimony pierced her facade. It pierced her facade of being a successful, privileged, and affluent person. It was a narcissistic injury. She was bothered because the world saw that she is indeed not a success and not affluent. The bulk of Eric Richins' estate was in insurance coverage. Some of it got paid out to the trust, some of it got paid out to Kouri Richins. Kouri Richins knew this. knew that much of his estate was insurance coverage. And different than taking money from Eric's home equity, different than taking money from Eric's bank account, to take Eric's insurance money, Eric has to die. Now for the aggravator of administration of any substance in a lethal amount. The substance here happened to have been fentanyl, could have been any part of the illicit street drug that she bought, happened to be fentanyl that she administered in a Moscow Mule and a shot or a shot. But we know that's how she administered it because it was in his belly. We know it was a lethal amount. The death certificate, fentanyl killed him. That's the substance, lethal amount. Can be as small as 3 nanograms per milliliter. And in this case, he had 15. 5 times what can be a lethal amount. That, by the way, is not an accident. That amount of fentanyl shows that Kouri Richins wanted Eric not only dead, but good and dead. Now, count 2, the aggravated murder. The elements are the same as count 1. The only difference is attempt. Attempt requires, as the court instructed, a substantial step. There's plenty of substantial steps, from ordering the drugs to making the Moscow Mule. Here, the aggravated murder count proves the attempted aggravated murder count and vice versa. The commonalities between Kouri Richins' conduct are not coincidental. In each instance, she purchased drugs from Karm and Lauber a few days out. In each instance, she spoke with the IRS a few days out. Taxes were on her mind. Eric would find out if the IRS was after them. In each case, she had an immediate financial stressor. We just discussed closing on the Midway Mansion. If you look at Brooke Carrington's materials, she had a note due on Chelsea Barney's house shortly before February the 14th. She had an immediate financial stressor in each instance. In each instance, she administered the substance in a way that Eric would ingest it. On Valentine's Day, it was a sandwich. When she murdered him, it was a drink. Notice that she learned from her mistake. One can season a sandwich with fentanyl. Eric can eat it, tell something's wrong, set the fentanyl-laced sandwich aside. You throw a lemon drop shot back. By the time Eric would notice, the shot was in. It was in his body. Moscow Mule, just to be good and sure. In each case, she leaves Eric alone. She distances herself from the dirty deed. She leaves the bedroom when she murders him. She leaves the county when she attempts to murder him. That's part of her alibi. Not only can she not be present, she has to be distant. So that when she calls 911, she says, I wasn't even there. I was in Utah County. And in each case, she has a delayed response, right? It's the delayed response in calling 911 when she murders him. And it's her delayed response in returning home when she failed to murder him. The element of, again, is it Kouri Richins? Yes. She is the person with the means, the motive, and the opportunity. Nobody else. The means, illicit street drugs in the sandwich. The motive, money, fresh start at life. The opportunity, she left the sandwich in Eric's truck. Intentionally or knowingly caused the death of Eric Richins, right? It's attempt, so attempted to cause the death of Eric Richins. The same reasons. She told Becky Lloyd it would be better if he were dead. She wanted the Michael Jackson stuff, the lethal stuff, the fatal stuff, the stuff that kills. She wanted Eric Richins' life insurance. You only get life insurance when Eric's dead. The commonalities persist. Kouri Richins ordered fentanyl from Carmen Lauber, or ordered something from Carmen Lauber, the Michael Jackson stuff, the fatal stuff. Carmen says, I told her I could get her fentanyl. She said, okay, get the fentanyl. But she ordered illicit street drugs from Carmen Lauber, who got them from Robert Crozier at the Maverick in Draper. Again, the volume of calls during the drug purchase between both Kouri Richins and Carmen Lauber and Robert Crozier and Carmen Lauber. And recall, we don't have the content of the texts because they were deleted from Kouri Richins' phone, deleted from Carmen Lauber's phone, and Crozier lost his phone. The IRS was on her mind. She called him twice, 3 days before attempting to murder Eric Richins. We know she placed the call to the Mirror Lake Diner to order a potentially fatal sandwich. We know that Kouri ordered it. Kouri picked it up in person. It was swiped. Don't know if you can tell that's Kouri Richins' signature, but notice it's one stroke. There's no pen lift. We'll talk more about that in a minute. Kouri Richins then distanced herself. She left the sandwich for Eric, and she drove an hour away to meet up with Josh Grossman on Valentine's Day. There's another commonality between the attempted murder and the murder, of course. They're big days. Losing your husband on Valentine's Day, that garners extra sympathy, extra attention. Losing your husband the same day you're supposed to close on the biggest purchase of your life, that garners extra attention. The type of attention that Kouri Richins relishes in. You heard Kouri Richins testify how Eric was a cowboy when it came to injury or illness. He worked through it all. He cowboyed up. Cowboys don't go to the hospital unless they're near death. They don't even think about going to the hospital unless they're near death. And at 11:33, Eric's thinking about going to the hospital. And then all the activity, the physical activity on his phone ceases for 87 minutes in the middle of a busy workday. Shortly after activity resumes in Eric's phone, he calls his best friend and business partner Kouri Wright. Recall Cody said he could hear the fear in Eric's voice, a fear he'd only heard twice before, both times associated with death. A fear he heard when Eric told him his mother had passed away, and a fear he heard when someone who struck Eric's truck in an automobile accident, and Eric thought that person might have passed away. He then spoke with his hunting buddy and close friend Josh Kays. You know and learn a lot about somebody when you hunt together and travel together. And Josh Kays said Eric sounded somber and serious. Josh asked Eric perhaps the two most pertinent questions: if he was going to the hospital, and what was he going to do about it? Let's turn to alley staking, singular, not plural. Clearly close with Kouri. Friends since middle school. You observed the banter when Ms. Staking was testifying, the banter between her and Kouri Richins. It was friendly. She's still friendly with her. And Allie Staking testified about how a week or two after Valentine's Day, when Kouri Richins attempted to murder Eric, when I questioned her, she said, well, Eric jokingly, kind of jokingly, maybe jokingly, said that Kouri Richins tried to poison me. Perhaps joking. But Kouri Richins' reaction is what was important here. Kouri said no. She got defensive. That is not what happened. It was like an allergic reaction or something. It wasn't at all dramatic. She is covering up her poisoning him. Then when defense counsel questioned Ms. Staking, Ms. Staking kind of backed off the jokiness of Eric's comment and attributed the jokiness to everyone else. Ali Staking said, well, defense counsel questioned, what did he tell you? That he believed Kouri had tried to poison him. Maybe it was one of those joking things like, I'm sending a message to Kouri Richins. I know what you tried to do. I'm joking about it, but I'm going to let you know. Maybe he was serious. Either way, comes back to Kouri Richins trying to poison him on Valentine's Day. Kouri Richins repeatedly tries to cover up that she tried to murder Eric on Valentine's Day. She says she was home with him. She tells her best friend, Chelsea Barney, I was home with him. She was not. She was with Josh Grossman. She did not come home until after 6:30 p.m. She was saying he never broke out in hives or used an EpiPen. That means he broke out in hives and used an EpiPen. When she spoke with her mother on August the 22nd, when she says she didn't put a love note and the sandwich in the front seat of his truck, she put a love note and the sandwich in the front seat of his truck. She is trying to distance herself. She is trying to cover up. She is trying to deflect. When Eric said he was thinking about heading to the hospital, what did she say? Take a nap. Call me when you're up. She's saying that thinking he will take a nap and not wake up. When he does, Eric texts Kouri. He's asking if she's home because he had just said, I'm going to hospital. Then he had stopped communicating, or he said, I'm thinking about going to the hospital, and then stopped communicating for nearly 2 hours. He's figuring she was coming home to assist him, but she wasn't. She's in Provo waiting for her cabinet installer guy. Maybe. She says then she's going to head home in 20 minutes. Nearly 2 hours later, question mark, where are you? You were heading home 20 minutes ago. She responds, what? Thanks for answering. Did you call? You didn't call. She thinks he's heading home. She's not. She's trying to figure out what to do. She's trying to figure out what to do because Eric survived. She had not planned on that. She is delaying to make her plan. And then at 6:34, Eric texts, we're headed in there. Food is on the front seat of his truck. The same place she left the poisoned sandwich with the love note. Eric Richins is telling her, I know what you did. That is the attempted aggravated murder. But that is the attempted murder. Now, of course, we have the two aggravators. They're the same. Same as with the aggravated murder. The money motive, same. Similar financial distress, same. There's also the first start at life motive, right? That hasn't changed a bit. Josh Grossman, it's Josh Grossman on Valentine's Day, and he's Josh Grossman on March the 4th. Money motive the same, fresh start at life motive the same. Now the second aggravator, administration of any substance in a lethal amount. Recall Dr. Eric Christensen's testimony that hives, EpiPen, all consistent with an opiate-like or an opiate allergic-like response, a pseudo-allergic response. Hives, EpiPen, along with zero activity, shows that Kouri Richins attempted to administer the illicit street drugs that she bought 3 days earlier from Karm and Lauber in a lethal amount. She just failed. Next guy. Okay, the insurance fraud. There are two insurance frauds. Let me distinguish them, please, for you. The first one is a scheme charge, a fraud scheme. The second one is a fraud claim charge. Count 3, the scheme charge relates to the $100,000 True Stage policy. We're going to put it up in a minute. The fraud claim charge relates to the $250,000 True Stage policy. The forgery, which we will get to, is a forgery related to count 3, the scheme charge. Let me unpack them now. Okay. Different than the aggravated murder and attempted aggravated murder, I'll address all elements of the insurance fraud scheme kind of at once because they all jump out of this single page. And the scheme is quite simple. Kouri Richens wanted to murder Eric Richens, thus took out an insurance policy on his life to get money for murdering Eric Richens. Then she murdered Eric Richens, and then she submitted a claim to get the money. That is the scheme. And we know it was Kouri Richens because everything on this application for this $100,000 true stage insurance policy returns to Kouri Richens. Kouri Richens received the application because she was a member of PED-FED. The application was addressed to her at her work address, so she would have been the one to receive it. If there was any questions about it, any further follow-up mailings about it, they would go to her and not to Eric. This applicant information is all her, but the partner information is all her as well. Her work address, no email address where they could contact Eric. We'll get to the Social Security number in a minute. The primary phone, that's not Eric's phone. You'll see that Eric's phone is 801-792-9317. And when you look at this closely during deliberations, you'll see that was originally a 7 that she later marked up to read like an 8. She initially wrote his correct phone number, then did not want anyone from True States to call him, so she changed the 7 to an 8. So that Eric would never know that this policy existed. After Kouri Richens took $250,000 out of Eric's home equity, he put all of his insurance that he knew about into the trust. If Eric had filled this out, the beneficiary would have been the trust, not Kouri Richens. Then we'll get to the signature. That's the fraud count 5 as well. It plays into this. We'll talk to it during count 3. But it's also the freestanding charge in count 5. Let's go to the next page. The Social Security number was blacked out for privacy reasons on the application we just reviewed. But you'll recall Ann Coates testifying that the last 6 digits were transposed. We all know our own Social Security numbers. We often get a little bit confused on our spouses. Eric did not sign the application. Matt Throckmorton, the handwriting expert. Eric did not sign it. It was probably a simulated forgery. Recall his testimony that Eric Richins has pen lifts in his signature. The forged one didn't have any pen lifts. You'll see Kouri Richins' signature throughout this case. No pen lifts. Then, Kouri Richins filed a claim for this $100,000 true stage policy. It's actually the same claim for both policies. And she said she really does not know where her husband, Eric, got the fentanyl from. Of course she knows. She ordered it from Karm and Lauber. That is the fraud scheme. Plan to kill Eric, fill out life insurance so I can get money for killing Eric, kill Eric, and then claim the money. Now for the insurance fraud claim count 4. This is the true stage $250,000 policy. This is the claimant's statement filled out. Kouri Richins beneficiary, Kouri Richins email, Kouri Richins address. Everything about this claim says Kouri Richins is submitting this claim. And then, like before, the fraud here, the falseness of it is she says she doesn't know where the fentanyl came from, when in fact she ordered illicit street drugs from Karm Lauber. And indeed, later in the Walk the Dog letter, admits to asking Karm for fentanyl. Finally, count 5, the forgery charge. We've discussed most of the forgery when we discussed count 3. But there's this without the authority to do so element. It's not a forgery if Eric gave Kouri Richins permission. The state has to prove that Kouri Richins did not sign Eric's name with permission, with authority. All of the evidence in this case proves that Kouri Richins does not ask for permission, she takes. She took with the home equity loan. She took other people's money. She's a taker, not an asker. Finally, like I mentioned earlier, Eric Richins, the evidence proves, would have put the trust as the beneficiary, not Kouri Richins. If he had given permission, it would have been permission to make the trust the beneficiary. That's the forgery charge. Let's please now turn to Kouri's motive for a fresh start at life. You heard the instructions. The state does not have to prove any motive except for the pecuniary gain motive because it's an aggravator. But motive explains why Kouri murdered Eric Richins, why she attempted to murder him. Motive explains a lot here. These texts at this point are familiar. The day after Kouri Richins speaks with Becky Lloyd and tells Becky Lloyd she would be better if Eric were dead, she texts Josh Grossman that she's in love with him, a man not her husband. If I was divorced right now and asked you to marry me, would you? That's the day after the attempted murder. If he could just go away and you could just be here, life would be so perfect. We're familiar with this text. We've read it already today. I ask you to read it again. This time, replace the word divorce with the word murder. This graphic shows a juxtaposition between Josh and Eric that is insightful to what Kouri thinks about each of them. In each instance, she is texting, well, she is kind of simultaneously texting. These are laid out chronologically. She is simultaneously texting with both Josh and Eric about closing on the Midway mansion. And she's so excited she is so excited texting with Josh. I can't believe it. I want to celebrate with you. Love you, love you, love you. Thank you for always being my support, shoulder, and rock. I need you all the time. Some things I could never do without your encouragement. You have no idea how much I appreciate you. Eric tries to reach out. You want a shot? Can't. Sorry, busy. Then right back to Josh Grossman. To me, you're worth millions a year. I'm honored to be your best friend, your lover, your go-to. Life is going to be different, I promise. You're one hell of a patient person. I hate your hard days. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please. By Friday, of course, Eric Richins was dead. Kouri had murdered him. She's right. Life's going to be different. She promised him. It was. Then, 16 days after Kouri Richins murdered Eric, are we there yet? And then 1 month later, Kouri's ready for Kouri's ready for Josh to be her husband. Josh Grossman loved Kouri Richins. He believed that she loved him. Not sure that's true. You saw him testify. He was gutted. As a grown-ass man, gutted. You also observed Kouri Richins' affect when he testified. Flat. The evidence proves that Kouri Richins attempted to murder Eric Richins, and that she committed 2 counts of insurance fraud and forgery. The evidence does not support any other rational explanation. The state, since its opening statement, has stressed the requirement to consider the evidence that has been admitted and not what the attorneys say. What the attorneys say, insinuate, speculate, is not evidence. Please let me show you why the state has stressed this. In the defense's opening statement,
oh boy,
counsel said that the evidence will show that Kouri Richins had a 1/2 interest in the Willow Court home. There is no evidence of that. and indeed contrary evidence. Defense counsel said that the evidence would show that Eric was always checking Kouri's phone. There's no evidence of that. Defense counsel said that the evidence will show Eric and Kouri Richins went to marriage counseling. There's no evidence of that. Defense counsel said that the evidence will show in the few weeks before Eric died, his closest friend thought that he and Kouri Richins were the happiest together that the friend had ever seen. There's no evidence of that. Defense counsel said that the night Eric died, he and Kouri Richins had their drinks and set their cups in the sink. There's no evidence of that. Defense counsel said that the evidence will show that the cups were sitting in the sink and the nanny put them in the dishwasher the next morning and they still had fluid in them. There's no evidence of that. Defense counsel said that Eric talked to a friend named Scott Wagner at 10 p.m. the night he died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show Eric unlocked Kouri Richins' phone at 10:30 p.m. the night he died, and this is the last thing that he did. There's no evidence of that. Defense counsel said that the evidence would show investigators interviewed Kouri over and over and over again about what happened the night that Eric died. There's no evidence of that. Defense counsel said that the evidence would show that law enforcement secretly recorded Kouri Richins' phone conversations for over a year after Eric died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request. You did not hear that, although she did write it in the Walk the Dog letter 4 months after she was arrested. In listening to defense counsel's closing argument, please only consider the evidence that has been admitted.
Ms. Lewis.
Wow. We went after the
Mark,
defense.
can we address something outside the presence of the jury before
Of
we
course.
start?
Folks, let's give you an opportunity to stretch your legs, use the restroom. Please
She
rise
wants
to the
to
jury.
talk outside the presence of the jury.
Yeah, she had
I-
an objection to something he said. I think it might be the references to her demeanor, but that's only a guess.
I thought that was effective, though, coming full circle from their openings, claiming what there was no evidence of in their openings.
Quite a list.
Yeah, prior to their closings. Again, Kouri noticeably different today with her facial expressions, so let's listen in here.
Your Honor, at this point, we'd like to make a motion for mistrial and make a proffer on it.
Good luck.
First of all, at multiple points in the prosecution's closing, he made efforts to dehumanize the defendant, in fact, calling her a black widow, comparing her to a deadly spider, calling her a narcissist when there's been no evidence introduced to support that, no expert testimony, nothing of the nature. Furthermore, it's completely improper for the prosecution to comment on her demeanor while she sat at counsel table. That's a comment on her failure to testify. Asking the jury to take into consideration facial expressions, which in his opinion may or may not have happened. I don't know what he's basing that on, but it's improper, and it's our suggestion that is a comment on her failure to testify by revealing what her response to testimony was, is calling upon her to testify in this case. Furthermore, in the closing, there was wild speculation on what was in Kouri Richins' mind, completely made up by Mr. Bloodworth with no evidence whatsoever to support it. Also, Mr. Bloodworth wrongly told the jury that giving any illicit street drugs to Mr. Richins was sufficient to support aggravated murder. That, in fact, is not true. The only drug that would support aggravated murder would be fentanyl. what he said to the contrary is not consistent with the court's instructions, and we would ask that that be corrected with a curative instruction, that they should follow the court's instructions on what it takes. It would not be sufficient if she bought some other type of drug that did not cause his death. That's just not the law.
That's not what he said. Either.
Let's see, just a moment.
He said it didn't matter which drug, deadly drug,
I think
caused
that's
the
it,
death. Not that it could be a drug that didn't cause the death, at least as
Mr.
I
Bloodworth?
heard it.
Forgive me. I need a little bit more detail as I go through these.
Yeah.
Which of these do you want a curative instruction regarding? In which of these are you moving for a mistrial on?
Moving for mistrial on all of it, Your Honor. The curative instruction, I think, is required by the wrongful information that giving him any illicit street drug is sufficient to support aggravated murder. That's just not true. And that's super important, because if they do believe that, there is evidence to make a finding that there was oxycodone. And there was no oxycodone found in his body. So that can't support a conviction. So that's what I think requires the curative instruction. The rest of it, I don't know any way you can cure it, Your Honor.
The Utah Court of Appeals disagrees with you regarding the prosecutor's comments. A long line of cases talk about the potential prejudicial effect of an improper comment by a prosecutor only being able to be measured after the defense gives its closing and the state gives its rebuttal, and we consider any curative instructions. What's your alternative position there? I could, for example, instruct the jury that Mr. Bloodworth's observations of Ms. Richens' demeanor are not evidence, and they are to rely on their observations of Ms. Richens, if any, only.
I just don't even think that her demeanor is proper to rely upon, because she didn't
Certainly
testify.
can be. I mean, she burst out in laughter during the showing of the decedent's body. I don't think it would be appropriate for me to tell the jury you can't possibly consider that.
I'm sorry, but I have no idea what you're talking about. I totally trust you, but I have no recollection of any laughter when his body was
No,
showing.
it was a hypothetical, Ms.
hypothetical.
Nestor.
Oh,
You
thank
probed
goodness.
the bounds of your categorical statement that the jury can never consider the defendant's demeanor. in
I'm
trial.
sorry. I thought you were saying she did that, and I was just horrified.
Please
so.
stay focused.
But I am focused. I just misheard you. Is what you're asking me is, do we want a curative instruction now? Do we want to wait until later? Is that what the court is asking?
Right.
Court's indulgence for just a moment.
The judge is not playing anymore. Just Ms. Eric not playing
I think
around.
we do want it now, if we can get one now.
Let's hash that out for a second. What I proposed was an instruction that the jury may rely on their own observations, if any, of Ms. Richens' demeanor in trial, but they cannot rely on counsel's statements regarding what Ms. Richens' demeanor was.
She doesn't think they should rely on their observations either.
I want to be clear, there were no comments regarding her silence.
Well, it's our position that when you comment on how she looked while she remained silent at counsel table, that is a comment on her silence, in our estimation. But I agree that he didn't say anything specifically about silence. That instruction would be preferable to no instruction, I think.
Okay. And then the Black Widow comment was connected to comments that were made by Chelsea Barney, correct?
Mm-hmm.
I I mean, they came out of his mouth in closing.
And he specifically referenced Chelsea Barney's testimony. Is it your position that Chelsea Barney never used that phrase or words?
I don't recall her saying that, but it's been a long trial, and I would not want to make that I 1,000% am sure, but I certainly don't recall that.
It was in the recorded phone call with Bryce Knutson.
And then everybody is speculating as to defendant's state of mind. It's one of the factual issues that the jury will have to determine according to circumstantial evidence, because as we instruct them, there's no direct evidence of what's in her mind. Why was anything that Mr. Bloodworth said regarding the inferences that can be drawn regarding her state of mind inappropriate?
Because they were made up out of whole cloth with no evidence to back it up.
You're going to have to be more specific.
So he went to great lengths to fantasize about what she was thinking about when there's been no evidence to that. He could have certainly said, look, she could have been thinking this, she could have been thinking that. He didn't. He gave them what was in her mind, which is just based on things he made up in his own head, not based on evidence.
Why aren't they all based on his view of the evidence that came in at trial? Was there any references to evidence that did not come in?
Well, first of all, calling her a narcissist, I mean, that didn't come in. There was no testimony that she's ever been diagnosed to have a narcissistic personality disorder. There's no evidence at all about her mental condition. And then when he talked about her putting the reasoning why she picked certain days to get more attention, nothing about that has ever come in to play, ever.
That's an inference.
I mean, that's just one of many. He went through lots of scenarios about what she was thinking as if it was a fact, and it wasn't. So, I mean, I think he can encourage the jury to use circumstantial evidence to try to reach their own conclusions, but he can't say this was in her mind when he doesn't know.
Okay. Anything else?
I think that's it, Your Honor.
Mr. Bloodworth, go ahead, sir.
Your Honor, were there any particular points that defense counsel raised that remain unresolved in the court's mind?
Any objection to the proposed instruction regarding the jury must rely on their own observations, if any, of defendant's demeanor, but cannot consider counsel's statements regarding her demeanor?
No objection.
Okay. And then the statement regarding giving any kind of illicit street drug is sufficient to show the murder count. Mm-hmm. Talk to me about that. I did catch that comment. They're not making that one up. Now, there was more, and in the total course of the state's initial opening, I think you made it clear that you were encouraging the jury to make specific findings beyond a reasonable doubt regarding each required element. Mm-hmm. There was that initial comment, though. I don't think an instruction regarding having trouble crafting a curative instruction that doesn't just give a theory of the case. What's your view of this?
Your Honor, I don't think anything needs to be cured. The state does not have to prove that the defendant intended to murder Eric Richins with fentanyl.
True.
The state only needs to prove that the defendant intended to murder him with the illicit street drugs that she purchased from Karm and Lauber.
And that they contained fentanyl. Yeah.
Well, on the second element or the aggravator? Because there's a distinction there.
I think on both. She has to actually knowingly or intentionally cause the death for count one. So if she buys something that she thinks is OxyContin.
Correct.
And intends the giving of the OxyContin to kill him. And it turns out that what she got was blue M30s that had fentanyl and it killed him. The difference between aggravated murder and murder is irrelevant. She has committed an aggravated murder. The distinction, I think, that I acknowledge is that she doesn't have to intend to kill him with fentanyl. She has to intend to kill him with poison. even if she thought she was getting one and got the other.
Correct.
As long as it worked,
Correct.
she committed the crime.
Right.
Correct. And I think that's what I said throughout.
I think that is the weight of the argument overall that you made.
If there's a particular sentence I said that is different than that, then I agree we should cure it. But I don't think I said anything different than that.
On this one, Ms. Nestor, I think the better course, rather than for the court to insert itself at this point, is to allow the rest of closing to play out, and we can readdress this issue at the end.
Okay.
I expect that this issue will get teased out in detail through Ms. Lewis's closing and the state's rebuttal.
The rebuttal, yep.
Give me a moment to collect my thoughts regarding the others. All right, thank you. Court will be in recess until... Oh, I'm sorry, go ahead.
I'm sorry, Your Honor, can I just maybe say one thing?
Yes, please.
The state did not refer to the defendant as a narcissist. The state said that that was a narcissistic injury.
Right, I got it.
Right. That's true. I liked that argument because the judge was right and the
Okay,
prosecutor
I'll be back.
was right.
11:40, please. We'll be in recess.
Not because they were right, but because it's a technical kind of argument, but it's a correct argument. He wasn't charged, she wasn't charged with intentionally causing the death of Eric by the giving of fentanyl. If that had been the charge, then they would have had to prove it was fentanyl. She was charged with causing the death of Eric, and I didn't write all the language down. It was, I've got it somewhere, I wrote some of it down, by getting him to ingest a substance, a poison. There was a whole list. And as long as if the jury finds that she gave him something that caused his death, that's fine, because that was the charge. The charge didn't say fentanyl in it. There used to be cases where a prosecutor might charge causing the death of X by the use of a firearm, and it turns out it was a rifle, not a pistol or a gun. Those used to be problematic, and now prosecutors are more careful to make the claim more general, so you're not obliged to prove the particular so long as you prove the general. In this case, poison of some sort, as compared to fentanyl particularly.
Yeah, this last part's been interesting. By the way, I mean, we keep talking about Kouri Richins, or at least I do. Noticeable difference in her demeanor today, making these faces. That even came up as one of the objections. And then you heard the judge talk about a hypothetical. She laughed out loud about his body. The counselor, Kathy Nestor, took that literally. The judge jumped down her throat. The judge is not having it today with the defense, and told her that she needs to, I forget the exact language, but basically focus. He told her that she needs to be more focused. Have you noticed that today, Joe?
Yes, and he said more than that, Joel. He said to the prosecutor when he was making her, he said, "This one is not their fantasy," something like that, which was pretty direct, a pretty direct, clear, and not flattering statement of how he's taking the arguments right now. But yeah, he's always been very firm and clear, but during the trial, he allowed the defense to spend a lot of time making the arguments, remaking the arguments. They would start in very general terms, trying to get them to be particular. He would provide them the language they needed at times. What he's not doing anymore is any of that. He's just being very firm and very quick.
Brian, I just saw in the chat, says verdict Wednesday. I'm going to say it's going to be before Wednesday. I think it won't be today because they're going to get it too late. But I think it'll be probably tomorrow. I think they're doing the government here did a fantastic job.
I do too.
Of laying it out. But so Kathy Nestor basically asked to speak with the judge. They ushered the jury out. She then basically states that they are asking for a mistrial because the government called her a black widow, a narcissist, which he just explained the term narcissist and didn't refer to her as a narcissist per se. Nestor went on to say it's improper to comment on demeanor because it implies her failure. The fact that he was, according to her, making comments about her facial expressions was undermining her Fifth Amendment right against self-incrimination. So, and also Nestor went on to say that there's wild speculation about what was going on in Kouri's mind. So, I mean, how did you see it overall here, this last bit where she objected and the judge, he took it, he takes everything seriously. So he took all of these things in mind and says he needs a few minutes. Is he going to come back and rule on this now? And then what?
No, what he's going to do is come back with that curative instruction on the one item. That is, it's the prosecutor's impression of what Kouri's facial expressions meant, and the jury is supposed to use its judgment. What the prosecutor says is not evidence. That's the one he's going to craft now. I think what he said is if the defense has any other objections, it will wait until after the defense closing and the rebuttal closing, because he thinks by that time it will all be straightened out. And if there is any misstatement, however slight, by the prosecutor, the defense will go after it. The prosecutor will go after it in rebuttal, and there won't be the need of any kind of curative instruction.
In other words, when the defense gets up there, they're going to undermine, or they're going to reply to the things that they disagreed with, and then Brad Bloodworth will get back and respond to that, and then he'll make a decision if need be after that.
And I don't think her claim that it was pure fantasy, in my view anyway, makes any sense at all. You've got the evidence in the record, and the prosecutor as well as the defense are entitled to draw inferences from the evidence in the record. And so I didn't hear anything I thought that was anything other than an inference from the evidence. So I don't think they'll prevail, but we'll see. On the question of the prosecutor referring to how she looked, you might remember, Joel, in the one of the Adelson trials, I think it was Donna, the defense argued that one of the jurors, remember they made the claim afterwards. It came up, I think, at sentencing, that one of the jurors who was interviewed talked about how she looked at counsel table, and that was inappropriate. And so, and that may turn out to be an issue on appeal for all we know when she finally files her appeal. But I was surprised that he did it, because I don't know that I've heard it done before. I certainly don't think it impacts the Fifth Amendment privilege not to testify.
Yeah. I mean, if I'm a juror, I feel like Bloodworth has really laid this out like airtight, and I don't see any reasonable doubt here, but I'm not a juror. So I don't know. I think this is going to be a fairly quick deliberation.
I agree with you, because the question is, and I thought he did a pretty good job. He may tie it up even tighter on the rebuttal. There are only two people in the house when the poison was ingested. I'm going to call it poison. The drug was ingested, and if it's not suicide, if you rule out if there's no reasonable doubt that it wasn't suicide, and you rule out that he's not a drug user, and so you rule that out, and then you have the evidence of her trying to obtain the drug and all the other things. You only have, Sherlock Holmes used to say, once you get rid of all the other possible ways, the one that's left has to be the right one. And I think that's where we are.
Interesting. There's some interesting comments going on here. One of which says that Kathy Nestor will go twice as long as Bloodworth. I can't see that. I don't think there's enough for them to go twice as long with. What are your thoughts, Joe?
Is it Nestor or is it going to be the lead lawyer who does it? I mean, she made the objection there, but I thought it was going to be Lewis.
No,
Well,
I
we'll
think
see.
it is. Well, I meant the defense is what I meant.
Okay. I think they're going to try to poke holes everywhere, and I don't know how much time they'll take to poke holes. But I will say that throughout this trial, they've taken a lot longer to do whatever it is they needed to do than, in my view, they needed to do.
231-500-139.
All right, we're back.
Counsel for State and the defendant are present. The defendant is present as well. Counsel, this is what I propose. Let me give you a ruling regarding defendant's motion for mistrial. Then I'd propose I give the jury the curative instruction related to evidence of defendant's demeanor. Then I'd propose we take a lunch break, Ms. Lewis, so we're not interrupting your closing.
I agree with that.
Okay. Any objection, Mr. Bloodworth?
No objection, Your Honor.
All right. The issue before the court is a motion for mistrial and request for curative instruction in the alternative made by defendant on the record this morning. The motion for mistrial is based upon several comments made by Mr. Bloodworth in the state's initial opening that, in defendant's view, are so improper as to require a mistrial. The court will address defendant's arguments one at a time. First, the defendant argues that Mr. Bloodworth's reference to Chelsea Barney using the phrase black widow during a recorded telephone conversation that was played for the jury, though Chelsea Barney's comment was not admitted for its truth, improperly compares defendant to some kind of terrible insect. The court listened to the comment in real time during the state's opening. That is not a fair characterization. Rather, that was a rhetorical flourish by Mr. Bloodworth comparing comments by one witness or the defendant herself to her becoming a widow to Chelsea Barney, referring to her being referred to or considered as a black widow. It's not a reference to an insect. Rather, it's a reference to, in the court's view of Chelsea Barney's comment, a spouse that kills another spouse. There's nothing so improper or improper at all about that comparison, which has a factual foundation in Chelsea Barney's statements that were played for the jury as to support a request for mistrial or require any other relief. Moreover, the defendant requests a mistrial based upon, in defendant's view, Mr. Bloodworth characterizing Ms. Richins as a narcissist. Defendant argues that that is unsupported and improper expert testimony from counsel that has no basis in the evidence. The actual phrase used by Mr. Bloodworth was narcissistic injury in relation to Ms. Richins' hearing from Brooke Carrington when she testified that, in the state's view, defendant's appearances of wealth and success were not accurate. That is permissible line of advocacy during closing argument. It is not testifying in any way by Mr. Bloodworth. It is not otherwise prejudicial or unfairly prejudicial. With respect to Mr. Bloodworth's argument related to defendant's demeanor, the court determines that in an abundance of caution it is appropriate to instruct the jury that they may consider their observations of defendant's demeanor in the courtroom, if any, but they may not consider counsel's statements regarding counsel's observations of defendant's demeanor, as counsel's statements and counsel's observations are not evidence.
Thank you, ma'am.
Moreover, the court notes that Mr. Bloodworth did not comment on Ms. Richens' silence or in otherwise implicate her protected right to choose not to testify. Mr. Bloodworth's statements regarding what the state believes it has proven regarding defendant's state of mind at various points in time is permissible advocacy based upon evidence in the record, and defendant's counsel will have ample opportunity to try to persuade the jury to draw different inferences from that same evidence regarding defendant's state of mind. There's no basis for a mistrial there. And regarding any misstatement by Mr. Bloodworth in his initial comments regarding count 1 that may have created confusion as to whether the state needed to show that regardless of her intent to purchase, secure, or otherwise administer fentanyl, all the state needs to show is that Kouri Richins intended to purchase, secure, and administer poison, and that it happened to contain fentanyl. That was, on the one hand, borne out in detail through the rest of the state's initial closing, and the court expects will be borne out in detail through defendant's closing and the state's rebuttal. The court determines that no curative instruction is necessary on that point at this time. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. All right. Are we ready for the jury, Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay. Can we bring the jury in, please?
Your Honor, I'm sorry to interrupt. My screen is still active, and I don't want anything to accidentally pop up during defense's closing. Thank you.
There you go. Bless you. Ms. Lewis, is 12:45 agreeable?
That's fine.
Okay. Folks, this time just stay standing. This will be a quick turnaround. Okay, thank you for your patience. A quick instruction and then a scheduling note. First, a quick instruction. You may consider your observations of defendant's demeanor during trial, but you may not consider counsel's statements regarding counsel's observations of defendant's demeanor because counsel's statements are not evidence. We're going to break now for lunch so that we do not interrupt defendant's counsel's closing argument for the lunch break. We will take a recess until 12:45. During the break, as always, please do not discuss the case. Please do not allow anyone to discuss it with you. Please do not do any research whatsoever about the case. We'll be in recess until 12:45. Thank you. Anything further, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis? We'll be in recess until 12:45. Thank you.
All right, so we're going to have about an hour break. If I'm right about that, it is 1:45 here, 2:45. Yes, so about an hour break, a little less than an hour break. Joe, that was interesting just from a law professor's perspective.
It was.
Basically gave he basically said, you can make any, sort of assumptions that you want from her body language and her facial expressions, but you can't do it based on what the lawyers tell you about that.
Right.
Am I right about that?
Absolutely. And that's the instruction he gave right at the beginning. What the lawyers say is not evidence. What did you think of his recitation of all the things defense said in their opening that turned out never to be in evidence.
By Bloodworth, you mean?
By Bloodworth,
Oh, I
yeah.
thought that was great. I thought that
did
was
too.
I thought that was really powerful. I think that they're going to try to come back, point counterpoint that. We have a little less than an hour. I've got to go drop something off for Karm, believe it or not. Well, I'm sure that's not hard to believe. By the way, Karm spoke to a classroom full of high schoolers today who are now required to read my book. So I kind of love it.
Do they have to buy it? This is what they should be
The
required to do.
the high school bought him the book. Yeah. So they're getting
good.
the book. Yeah. So I'm excited.
Will she
about
go
that.
back after they've read it? Are they going to have her back?
That's a great question. Probably she might. I don't know. That's a great question, Joe.
Seems to me they should.
Yeah, I didn't ask. But long story short, I got to race over and drop something off with her, and I'm going to be back. But I want to make sure I'm back for the defense closing.
Yeah, you don't want to miss that. That should be a show.
It's totally up to you, Joe. But if you want to stick around and take a few questions,
yeah, I will. As long as I can, I'll try to read them because on my screen they're very tiny. But now that I don't have to listen to the trial too, I'm in a better position to be able to do it. So I will.
I'm going to bounce myself out. Huge thanks to Prof. Joe Explains, and I'll see you guys in an hour. Bye-bye. Okay.
So if anybody has a question you want me to answer, could you put 3 or 4 or 5 cues? And if you could figure out how to do it in red, that would be better because the type is really tiny. And I need to be able to identify that something is being asked as a question, and then I'll have to squint to try to read it. So let me see. Okay. I'm not spotting any yes. Maybe you don't have any questions. You're all wanting to go to lunch, which I can understand. Okay, it's not quite a question, but just over it wonders why they chose Lewis for closing, and she thinks Ramos would have been the diplomatic choice. Lewis is the lead defense lawyer, and so typically the lead defense lawyer does the closings and typically the opening, although it doesn't have to happen that way. If you recall the Adelson trials, they had Sarah Dugan open, and then I just lost her name. God, I wish I didn't have so much trouble with names. I had it a minute ago. Anyway, the other lawyer, it will come to me in a second, do closing. So usually it's the lead defense lawyer, and the lead defense lawyer is typically the one who makes the call. He or she may take the advice of others, but it will be the lead defense lawyer that decides the way it should go. Okay. Does Kouri still have another case that would keep her in jail and if she's found not guilty? She's got all the except for the 3 that are charged here, she's got all the financial crimes yet to go. And I think there's 16, 18, 20 counts. I looked a while ago, and there are quite a bunch of them. Georgia Kappelman was the other defense lawyer. I knew sooner or later my brain would wrap around it. Okay. Patrick Thornton just has all questions and no question. The question, I can spot it. That's very helpful. But if you don't have a question, there isn't much I can do. Okay, let me see over here. Let me go back and look here. I think people want to go to lunch because I'm not seeing questions come up, but I'm going to keep looking. And then I will break also. Okay. I'm not seeing any question marks with a question after it. Let me keep going. Nope, I don't. Oh, here's Dr. JW33. I can't do questions in red. Did they do a mock jury for this case? Is that normal for a homicide or more civil case? I see 3 red questions there, Dr. JW33. I don't know if they did or not. In big cases, they lawyers often do. Certainly on the civil side, a big money case, they generally will do a mock jury. But I can't answer whether they did a mock jury in this case. My guess is, well, I don't want to guess. I don't know. Okay. Okay, Lay wants to know what my top 3 points in the prosecution closing are so far. That's kind of difficult because my top is the way that the prosecutor organized everything and interspersed the actual evidence in the trial, so that he had the text messages and he had the 9/11 call and he had the videos. I thought that was extraordinarily effective, independent of any argument that he made. I thought he did a very good job of corralling all the evidence on her doing the act of killing. And that's the one that I think is the one that the jury, if it's going to have a problem with, is that one. The issue as to whether she had actually administered what turned out to be fentanyl. I thought he did a really good job with that. Let me see if I thought there was another. Oh, and I thought his recitation at the end of here's all the things they said that they didn't prove was really extraordinarily effective for a couple of reasons. One, he said to the jury, he got out of the jury's head that any of that was evidence, which is helpful. The other thing is he kind of undermined the jury's credibility in the defense. He didn't say anything like that, but under all of that was, you shouldn't trust them when they say something because they don't get the evidence right. So I thought that was really very effective. Wyoming, thank you very, very much. You've given me things before. I really appreciate it. Very, very generous. Oh, here I see some questions now. Okay. Do I think the curative statement was helpful to the defense or just drew attention again to the fact that she's been making faces? I think it was pretty neutral. I don't think it helped or hurt, really. Okay, Ansley Cudd, would Kouri have been better served having her charges decided by the judge instead of a jury? I think not, because I think the judge would be less likely to be distracted by the claim that we don't know what the drug was that was actually administered. I think the judge would be able to focus on here's the legal standard and there's enough to prove beyond a reasonable doubt. What will be the theme of the defense argument? This is John Davis, R8N, or Rain. Is that supposed to be? No, it can't be Rain because it's an 8. Rayton? Anyway, they're going to say that there's no evidence. And of course, that's a complete overstatement, but they will say there's no evidence that she purchased fentanyl. And you've got to show that she purchased fentanyl and that she administered it to him in order to convict her. That's where I think they're going to spend their time. Initially, before the trial started, I would have guessed that they were going to spend time saying Eric was addicted to drugs and he went to Mexico to get the drugs, but there's very little, if anything at all, with regard to that in the evidence. And so, I think the only thing they had on real drug use was essentially Sudafed in high school. I don't think that Cody Wright said anything more than that. Oh, and the gummies with cannabis or whatever. I don't think there's anything that shows any other drug use by him. So I don't know that they'll spend much time trying to do that, because I think that would just open the rebuttal to say, here's the entirety of that evidence. So I'm pretty, my guess is they will just say the state didn't prove its case. And on the thefts, they will say on the one where she's alleged to have signed Eric's name, that she had authority, she had power of attorney, and that's all you need on that one. And on the 2 insurance claims, I'd have to go back and look at them. Yeah, I think they'll just go in to say she had no intent to deceive or defraud in both of those. But those are not, I mean, you're not really asking about that anyway. You're thinking about the murder and the attempted murder. On the attempted murder, I think they will say even more, there's really no evidence that he was poisoned at all, as compared to maybe it was I forget what the sandwich was, a bad egg or a bad piece of bacon in the sandwich. There's nothing to show that there was any drug in that sandwich, except for Carmen Lauber's statement that she had purchased drugs, been asked by Kouri to purchase drugs right before that Valentine's Day episode where Eric was ill. Some of the evidence that didn't come in was Eric thinking he had been poisoned by Kouri, and he had said something to a couple of his friends, and that didn't get into the evidence. Okay, let's see what's coming. What else we have? Let's see. Okay, let's see here. Did the state prove Kouri Richins is guilty of murdering her husband, Eric Richins? Oh, here we go. There's STS did a poll. Yes, enough to convict her, 81%. No, still too much reasonable doubt, 9%. Unsure, but closings are convincing. 8% unsure, closings not convincing me. So there are around 11% who are saying some version of no. So we will see. It's still, obviously heavily in favor of conviction. And what happens in jury deliberations is they will go in. There will likely be jurors who are not sure. There will be jurors who are convinced one way or the other, and then they'll talk it through, and they'll try to reach, and hopefully will reach, agreement. So, okay.
Joe, don't forget to take a lunch break.
Yeah, I will. I just hate these questions. Thanks a lot, but I just hate these questions.
Okay, I'll keep pulling up a few for a few minutes, but let me know whenever you want to.
Well, do you want to take a lunch break? I don't want to hold you up either.
No.
So, okay.
I'm here whether you're here or not.
Okay, let's take at least 3 or 4 or 5 more because I just hate to leave them. Okay. All right. Well, here we go. Are defense attorneys hired or state appointed? It's kind of between the two. They are not, they're not public defenders, but they were on a list of attorneys who are prepared and willing to take cases when the public defender cannot take a case for one reason or another. There was another lawyer on the case earlier, Skye Lazaro, sorry. And there were people in the chat who said they saw her in the courtroom today sitting behind Kouri with Kouri's friends and family. I don't know what she looks like, so I can't confirm it or not. So these lawyers are being paid by the state, and they were appointed, I think, by the judge. They would have to come forward and say they were willing to do it. Okay. Question, if they do not trust anything, the drug dealer said they would still have an ability to convict. I'm not sure what that means. I don't know what that means. There's some holes in the sentences. It's 5 a.m. in Australia, no lunch. Well, you say Joel says STS has viewers all over the world, and I guess Prof. Joe explains this too. What do I think the defense has to really focus on in their closing regarding her history of fraud? What do they have actually to counter that? Well, I think they're going to focus really on the murder and attempted murder charges, the aggravated murder and attempted aggravated murder. So what they're really going to focus on, I believe, is, even if you think she's done this other stuff and you don't think she's a nice person because of what happened to her friend, that doesn't make her a murderer. And I suspect that while they'll talk about the financial crimes, they're really interested in trying to get an acquittal or at least a hung jury on the murder counts. Why include any financial crimes in the murder trial when there's a separate case set to follow? Is that common? Well, in the murder, if you remember the Alex murder trial, they had all his financial crimes in. And not only that, they allowed witnesses to testify to things that were really far removed from his allegation that he had killed his wife and son. So here, the judge did not do that. Most of the financial crimes are out, but the state says that the financial crimes, the wheeling and dealing, are the motive for the murder. So it's relevant to the murder conviction, the murder prosecution. And so some of it had to come in if the state was going to be able to present its case and its theory of the case. And I think what the judge decided was the financial crimes that had some relationship to Eric, direct relationship, could come in. And so you have the two insurance policies and signing his name that had more direct relationship to Eric than some of the other financial crimes that she's been charged with. Do you think he should have brought, you know what he's going to do with the walk the dog letter? I think he'll do that on rebuttal. That would be my guess. If not, Jessica Rabbit, I do agree that he should have done more with it. Melinda Boyd said everyone could see facial expressions from Kouri. Do I think that will make a difference to the jury? I think the jury was noticing the facial expressions. I mentioned before Joel left that in Donna Adelson's trial, one of the jurors afterwards, it may have been one that Joel interviewed on STS, had said that he noticed how Donna looked, but it didn't have any impact on him. This judge said it's appropriate for the jury to notice how she looks. So what did the prosecutor say about evidence that wasn't admitted by the defense? He said, remember, that what the lawyers say is not evidence. And now let me give you a list of examples. The defense lawyer said you were going to hear evidence about this, no evidence. This, no evidence. There was a list about 8 or 10 items. Okay, I'll take one more and then we will all break for lunch. If there is one more, maybe we have emptied out all the questions. Okay. I think maybe that's it. So we're coming back. You see the notice up, 2:45 p.m. And I hope we'll all be here because I think some of us will find the defense closing irritating. That's just my prediction. Okay. All right. See you a little later. Ciao a tutti. I'm here. The judge is not. So what else is new? Okay, we're gonna start with the defense closings, or closing, I shouldn't say, make it a plural. And I'm gonna look and see if there are any other questions that have surfaced when you had time at lunch maybe to think about it. Don't see anything so far. I see a lot of chatting, but no questions. So good. We will wait for the judge to come out and hear the defense closing argument. I hope you had a lovely lunch. Got errands done if you had errands to do. Or just enjoyed the lunch if you didn't have any errands to do. I don't see anything, so I think we're okay. And hopefully the judge will come on the bench shortly. Did you have a favorite part of the morning? I did. My favorite part was the judge telling the defense lawyer to sit down. He didn't quite say sit down, but I enjoyed that. Although I do believe I've been going back and forth on it over the course of the trial, but I do believe that when they make these objections, they truly believe that the objections are warranted. I mean, some of them they're making for the record clearly, but I do believe that they think these objections that they're making are warranted. I don't know why. I mean, a lot of them I can't for the life of me see why they think the objection, might be sustained. But I don't think that when they make one of these impassioned objections, it's because they're just doing it to waste time or to see what they can get from the judge. I really think they believe it. Okay, here's a question over here from Scrambled Egg. Why doesn't the judge have the defense turn off their mic? The whispering is annoying. I have no idea. I guess it doesn't annoy him. Maybe he doesn't even hear it. I don't know whether we hear things that the judge on the bench doesn't hear. Okay, here's another. Do I think the defense objecting at the state when closing is appropriate? Will it sway the jury? I don't know whether it's going to sway the jury, and usually lawyers do not object during closing unless it's significant. But if they think it's significant, I mean, I don't know that I agree with regard to their assessment of some of the objections and how strong they are. But if they really feel that way, I mean, lawyers do object during closing, and it depends on the jury whether the jury is unhappy or not with it. It also depends on how the jury perceives the prosecutor and the defense lawyers. If it likes the prosecutor and the defense lawyers,
231-500-139. Counsel for the state and for defendant are present. Ms. Richins is present. Ms. Lewis, anything before we invite the jury in?
No, Your Honor.
Mr. Bloodworth.
No, Your Honor.
Ms. Lewis, would you tap that microphone for me? I don't know. I'm sorry. There you go. Great. That should be fine.
Conversely,
Brittany will let you know if it's not. We're ready for the jury, Cody.
if they don't like the prosecutor and they like the
Katie,
defense
is there
lawyer,
a
then
slide
they're
deck
going
that we're playing?
to be happy with the objections, and vice versa. If it's the prosecutor making the objection
I have
and
a
the
picture of a
defense
house
lawyer,
at the moment, right? Okay. You'll let me know when you want to publish,
Right.
Ms. Lewis?
I think Katie just has it ready to go. Yeah.
Oh, okay.
all right, someone
But it's
wants
not
to
up
know
yet. Okay.
what Kouri's mental illness based on medication. I have a JD degree, not an MD degree. So that question is way out of my expertise. Maybe someone in the chat has
Please have a
some
seat
hope
as
of
you come in.
answering it, but not I. Hopefully Joel will be back soon so he doesn't miss any of this.
All right, please have a seat.
And we don't miss him.
Thank you for your patience. We'll continue with closing argument. Ms. Lewis.
If you notice, he has a journalist's real way of summarizing what's happened. That comes from years of experience and, doing it well, I'm sure. Okay, here we go.
In the early, in the early morning hours of March 4th, 2022, the house was quiet. Kouri Richins fell asleep in her young son's room, like many parents do. At some point in the night, she gets up and walks back down the hallway to her bedroom. She slips back into bed beside her husband. She settles in next to him. She reaches over, and he feels cold. Eric Richins, the father of her children, the man that she has built a life with. Something feels wrong. She pulls the blanket up around him, but something still isn't right. He feels heavy. She turns on the light. And when she looks at her husband, really looks at him, she realizes something is terribly wrong. And in that instant, in that bedroom, in the quiet early of the morning, Kouri Richins' world collapsed. Reasonable doubt. It's not just a slogan, it's not just a suggestion, it's a constitutional shield that protects the innocent and prevents the state from punishing without truth. And it is the state that has that high burden, the highest burden under the law, to prove each and every single element of each and every charged offense beyond a reasonable doubt. The state stood up on day one and they told you they were going to prove that Kouri Richins had the means, the motive, and the opportunity to kill Eric Richins. And we're going to talk about each of these, but first, I want to talk a little more about reasonable doubt. I've told juries for a long time that one way to understand reasonable doubt is, are there other reasonable explanations as to what happened? As you look at the evidence, if there are other reasonable explanations, this is reasonable doubt. And you have to find Kouri not guilty. I put to you that every fact that the state has put forth to say that Ms. Richins is guilty has another reasonable explanation. Let's go back to March 3rd, 2022. From everything we've heard during this trial, Kouri and Eric were happy that night. They were celebrating. Kouri was just about to close on the Midway Mansion. Rightly or wrongly, she believed that this was going to be the deal that put her over the top. The deal that had made everything she'd done with her business, the good, the bad, and the ugly, all worth it. The night of March 3rd, they have a celebratory drink, they go to bed, and then Kouri hears one of her sons cry out. And like parents all over the world do, she goes in to lie down on the floor of her son's room. An alibi or the truth? She wasn't inconsistent when she told this story. She told everyone, I was lying in Ash's room, I was lying down with him. What does reason tell you? What does experience tell you? When she wakes up, she goes back to her room. Eric appears to be asleep. We don't know for sure what happens over the next 15 minutes or so. The state asks you to leap to conclusions about what she was doing during that time. Yet they have not shown you any evidence of this. They just tell you to believe it. But what does reason tell you? She gets up. She goes to the bathroom. She picks up her phone. We all pick up our phone all the time. Been away from it for an hour or two. She goes to the bathroom. Maybe she walks to the kitchen. Maybe she gets a drink of water. Maybe she lets out the dog. And then she goes back to her bedroom, phone probably in hand, gets into the bed next to her husband, again, realizes he's cold, pulls up the blanket, realizes something's wrong, and turns on the light. It probably takes a moment or two for her brain to register what she's seen. And then she makes that call that nobody ever wants to make. She calls 911. A big part of this state's case is that Ms. Richins is not grieving properly. You heard this from a couple of different witnesses, 2 or 3. What does that mean? I was unexpectedly widowed when I was not much older than Kouri, and I had 2 little boys. How do you judge someone in that moment? If I've learned one thing during this trial, I've learned I didn't grieve right. I didn't know that, but it's clear now that I didn't. They want you to look at a woman in the worst moment of her life and to judge her grief. There is no wrong way to grieve. They're asking you to judge how she is acting at that moment, and then use that moment of evidence of guilt. In the opening, we pointed out, and quick, go ahead and put it on that the state looks at facts one way and sees a witch. But if you look at those facts another way, you see a widow. Here's an example. Hands over her face, curled up. A witch, hiding because she's done something wrong, or a widow, hiding and blocking out what has just happened to her, what has just happened to her children, which has just happened to her family and to her life. Look familiar? Portrayals of women grieving in art. Portrayals of women in grief. The state tells you during evidence that, oh, she didn't immediately talk to Gene Richens when he came to the house because she felt so guilty she couldn't talk to him. Or was it because she didn't want to tell a father his son had died? Oh, she didn't tell the boys when she should have. It was weird. She didn't go talk to them. They were in the playroom. Again, because she felt guilty, or because she was dreading the most difficult conversation, the conversation nobody, no mother, ever wants to have with her young sons. Their father is dead. The father that everyone agrees was a wonderful father is gone, and she has to tell those little boys, you're never going to see him again. Believe me, that conversation may be the worst moment in a mother's life. How can a woman be judged on how she handles that moment? You heard her friend Allie staking. When Allie arrived at the home that day, she said Kouri was clearly upset. She said she was distraught. This is someone who's known her since junior high, not an officer who met her 5 minutes ago. She said Kouri was acting as you would expect. That night, friends came over to talk about Eric, to drink to Eric. Awake is what the Irish call it. The state wants you to leap to the conclusion that that night, Kouri was celebrating Eric's death. You heard Allie stalking. They were celebrating Eric's life. They kept it light for the boys. They were dancing, they were smiling. All of them were, even Eric's sister. Can we not smile in our grief? They want to tell you no. But reason and experience tells you differently. Let's talk about the investigation. The investigation in this matter was nothing but sloppy. It was driven by bias. Did you notice during the state's closing they didn't really even talk about the investigation? Instead, they speculated. What was in people's heads? What were they thinking? Speculation, conjecture, not proof. Instead of looking at the evidence to determine what happened, the state they determined what happened, and then they found the evidence to support it. This is confirmation bias. Confirmation bias is when you favor evidence that supports a belief and ignore evidence that contradicts it. That is how this entire case was investigated, working backwards from a conclusion. It started on March 4th. Detective Woody, before she's even entered the home, Amy Richins tells her they think Kouri is somehow involved. Then both Katie and Amy Richins tell Detective Woody they think this is because she recently found out about a trust Eric created. Immediately, this influenced this investigation. But what happened that first day? They found nothing to support foul play. Kouri tells them he was a user of THC gummies, that maybe he used one that night. They never ask where the gummies are. They do a cursory search of the bedroom and bathroom. They admit that they don't look in places where the gummies were found a month later, high up in the bathroom, high above the refrigerator, high up in the laundry room, somewhere in a pocket of either Kouri or Eric's jacket in a closet. All places where they would have been put out of reach of children. But they didn't find any of them that day. You know what else they didn't do? They didn't secure the scene. They moved things around. They told you they didn't have probable cause to search the whole house. We couldn't search the whole house. All we could do was look in the bedroom and the bathroom. But they could have asked for consent. Kouri gave them consent when they asked to search one place outside of the bedroom. The entire house could have been searched that day, but they didn't do it. They didn't even ask. What else happens that morning? Officer Nguyen, he does his death checklist. He says, did he have any history of prescription abuse? Did he have any history of illicit drug use? And what does Kouri tell him? No. How easy would it have been to just say yes? If she had just killed him with illicit drugs, why in the name of God did she just not say yes? Had she said yes, we probably wouldn't all be sitting here today. She didn't say yes because she did not know how he had died. Over the last 4 years, they've gone back to that house 10 more times. And they still can't tell you what happened the early morning of March 4th, 2022. 10 warrants, that's a lot. That's not typical. They were still searching for evidence on February 9th of this year, 2 weeks before trial. 4 years of investigation. And they are still trying to find evidence to make their case because they know they don't have enough. They're still trying to prove Kouri Richins guilty. So let's talk about Todd Gabler. In comes Todd Gabler, the private investigator. Jeff O'Driscoll told you, well, he was an investigator for the estate. Just the civil case. Seriously? He's putting trackers on the car of Kouri, her mother, her brother. He's trying to track Carmen Lauber's car. He's providing evidence to the police. Detective Woody testified that this information from the private investigator is what helped advance their investigation. He testified he was in the house alone numerous times, finding things the police didn't, not using gloves, calling law enforcement when he found things. He said he didn't need a babysitter while he did all these things, which is different than what Clint Benson told you. He said nobody was ever in that house without me being there. That wasn't true. What he told you wasn't true. Todd Gabler was in and out of that house numerous times by himself. He also told you that he was completely fair and unbiased, testing 2 hypotheses. His hypotheses: suicide and homicide.
3.
He ignored any others, including accident. And how did he handle this unbiased testing of hypotheses? You heard Josh Grossman. He said the first time he talked to Todd Gabler said right out of the gate, Kouri killed Eric. Josh told you that tainted what he thought of next. How does it not taint an interview when your opening line is, oh, Kouri killed Eric, so now let's tell me what you have, what you know. Josh told you he started looking back at things differently than he had before because of that. Like I said, He tracked Kouri's car. He tracked her family's car. He tracked Carmen's Lauber car. He didn't track Cody Wright's car. He had more to gain from Eric's death than anyone. He didn't track anyone involved in the civil case regarding the trust. He only tracked people that he thought might lead to information for law enforcement. Did he follow up on Eric's trip to Mexico shortly before the death? No. Did he go to Mexico? Did he try and figure out where Eric had been in Sonora, Mexico? No. Nothing about that investigation was unbiased. Nothing. He passed it all on to law enforcement. And then what he did is he said to law enforcement, you should talk to Carmen Lauber. She's on the ropes in drug court. This would be a really good time to interview her because she would be very likely to be compliant at this time. Everything about this investigation was led by the Richens family. They started on day one and they continued until trial. They are the ones who initially hired and paid for experts. Their private investigator gave the information to the police. And by the way, Gabler testified that he followed all the rules of being a private investigator. And that may very well be true. But he doesn't have to operate under the Constitution. There's a reason that we have rights under the Constitution. There is a reason that law enforcement has to get warrants to enter your home, to take electronics, to search your house. It is to protect the citizens of our country. It is to protect the innocent. Sidestepping these important constitutional rights by hiring a private investigator who then let law enforcement know what to do taints this entire investigation. And you know what? That is terrifying. It's terrifying. If someone has enough money to hire a PI, they can circumvent our constitutional rights, dig into every aspect of our rights, of our lives, and turn it over to police. We have a constitution for a reason. It's to protect us all. I want to talk about the lead investigator, Jeff O'Driscoll. Here's what he testified that his investigation consisted of. He got assigned to the case sometime in March of 2023. He got a search warrant for some medical records. He thinks he got a search warrant for a couple of cell phones. He interviewed Chelsea Barney, where they discovered that they were wrong about some text messages. Law enforcement was wrong with what they thought they were looking for. He interviewed someone named Jake Sorensen, who must not have had anything important to say because we never heard from him. Then he interviews Carmen Lauber because he was told to by the private investigator. That's it. That was the investigation. He didn't investigate any other leads. He didn't attempt to corroborate information, particularly in the letter that we saw that Kouri wrote to her mother, the walk the dog letter. Now, he told you he didn't need to corroborate that because he didn't get that letter till after Kouri was arrested. So, I guess the state was done. You wouldn't want to start looking for things that might show her innocent. You've arrested her. Interestingly, they were still executing search warrants. They were still trying to find evidence for guilt, but they weren't looking at any evidence that might show innocence. It is absolutely possible that everything she said in that letter was true. In fact, at least 3 things in that letter were corroborated by the state's own witnesses. But they didn't investigate it. Again, ignore what might contradict your theory. Confirmation bias. Reasonable doubt. Also remember that letter never went to anyone. So it was nothing more than thoughts on paper. That's all that letter was. What else didn't he do? He didn't interview the person Eric was talking to in Mexico the night of his death, and we'll come back to that, but he didn't follow up on that. He said that. He didn't follow up on where Eric went in Mexico or who he was communicating with in Mexico when he was there. He didn't investigate what Eric did or where he went on February 14th, 2022. He didn't follow up to see did Eric go to the hospital that day. In fact, he did nothing regarding that day. Nothing. What else? He didn't find fentanyl anywhere. Allegedly, there were 90 to 120 pills of something. At least oxycodone. Where were they? I guess somebody took them, but they didn't have them. So whatever pills Carmen may or may not have provided to Kouri were gone. They no longer existed. They couldn't find or test those pills. And we do know that she bought oxycodone, but you know what? There was no oxycodone in Eric's stomach that night. So instead, Detective O'Driscoll says, well, we wanted to corroborate Carmen's story. I mean, we were going to corroborate it. We weren't just going to go by it. The story that they fed her, they want to corroborate the truth. They wanted to corroborate a story. Again, let's find what confirms our theory. Let's ignore what doesn't. Confirmation bias. Reasonable doubt. Sitting here in this courtroom after 4 years of investigation, there was an awful lot that O'Driscoll just could not tell you. Things he couldn't remember. He couldn't remember what people had told him in interviews. For example, he was asked, did you interview Eric's allergy doctor? Well, yes, but I can't remember what he said. Well, that might have been important because he testified the EpiPens in the house belonged to the children. Well, maybe because Eric had recently used his a couple of weeks earlier when he had an allergic reaction. He said, well, if I could have a few minutes, I could find out what was said. I could give you more information. We were in trial. He was on the stand 4 years after Eric had died. 3 years after he'd been appointed as lead investigator. And either he wasn't prepared to testify or he just didn't know. He is the lead investigator. Now the state elicited testimony from him that how could he possibly know the entire case is just too much. I couldn't know all of that information.
That's O'Driscoll.
But he's the one they put on. He's the one they relied on to testify about this investigation. You didn't hear from anyone else about the last 3 years of that investigation. They chose him. You know what else he couldn't testify to? He couldn't testify how the fentanyl got into Eric's system. He said, well, he ingested it. There was no evidence, none, that fentanyl was put in a drink. That was argument. Argument is not evidence, and they waited until closing to tell you, oh, she put it in a drink, without any evidence to back that up. Okay, she made him a drink that night, but that's it. She made him a drink. There's no evidence that fentanyl was in that drink. And the lead detective who couldn't tell you anything, he sat through this entire trial. He heard every witness testify. He had an opportunity to form his answers or reform his answers based on what he knew other people had said. And yet, he still didn't know the evidence. I want to talk a minute about deleted texts and the phone searches just quickly. Deleted texts. They said there were deleted texts off Kouri's phone, and that it looks like that probably was true. Why would you delete texts off your phone? Maybe because you were having an affair over the last 2 years? You might want to delete that off your phone before your whole husband's family finds out about it. Maybe because she was buying oxycodone. I mean, she asked Carmen for pain pills. Doesn't mean she killed her husband, but you probably want that off of your phone. The phone searches. So the evidence showed that Kouri found out on April 13th that Eric died of a fentanyl overdose. And that's the day they took her phone and she gets a new phone. These searches are all done on that new phone. Searches of how much fentanyl does it take to kill someone, or how much fentanyl is a lethal overdose? I don't remember exactly. Yeah, because she just found out her husband died of a lethal overdose of fentanyl. You might want to know what that means. And she texted other things. They said, oh, she texted about women's prisons. Of course she's worried. An innocent person would be worried. Anyone would be worried if they just found out that they are a suspect in a homicide investigation. She would have been scared to death. She was looking for information based on what she found out after Eric died. All right, what do we know about those last few hours before Eric's death? It's not a lot, but we do know some things from the autopsy and the toxicology reports. We know that he had fentanyl in both his blood and his stomach. We know he had quetiapine and alcohol only in his stomach and not his blood. So this means the quetiapine had to be taken after the fentanyl. Had they been taken together, they would have both been in his blood. We know there was no histamine response, no anaphylaxis, so he had not had an allergic reaction to anything in his body that night, including fentanyl. The state wants you to believe that the allergic reaction he had on February 14th was to fentanyl. If he had an allergic reaction on February 14th, he would have had one again 3 weeks later. Now, I know the toxicologist testified, well, you don't have an allergic reaction every time, and you can look at her testimony, but it was a little bit hard to understand, but I believe she was talking about, you might eat peanuts for a lot of times and then have an allergic reaction, and then it starts. Once you have an allergic reaction to something, it doesn't typically go away. We know he had norfentanyl in his body, and this is because his body had started to metabolize the fentanyl. The state's toxicologist told you that the fentanyl could have been left over from a previous use. That was a possibility. Another reasonable possibility. The fentanyl was there from a previous use. That was the evidence. That is reasonable doubt. What else do we know from the Emmy and the toxicologist? Well, we know that the fentanyl was not put in a drink. And how do we know this? There was only fentanyl in the blood and not alcohol. The state's toxicologist leaned toward the fact that maybe Eric didn't even drink alcohol, that the alcohol in his stomach was post-mortem decomposition. But the other scenario that she said that was possible was that Eric took the fentanyl, then took the quetiapine, had a small amount of alcohol. She testified that it would take 15 to 60 minutes for fentanyl to make its way into the blood. That alcohol takes 15 to 30 minutes to make its way into the blood. So if the alcohol and fentanyl were taken together, they both would have been there at the same time in the blood. But just the fact that one reasonable possibility is that the fentanyl was taken before the quetiapine and the alcohol gives you reasonable doubt that it was placed in a drink an hour earlier. Now the state's saying, well, maybe she put it in a non-alcoholic drink. So their celebratory drink maybe didn't have alcohol in it. There's no evidence of that, but they're throwing around a lot of theories. Why is that? Because they don't have one. They don't know what happened. Dr. Christensen and Dr. Ulmer testified that the manner of death could not be determined. This is really important. Dr. Christensen testified the ME's office didn't know enough about Eric's history to determine if it was an accident. They also didn't have enough information to determine it was a homicide. The ME had at least a reasonable doubt as to the cause of death. And the ME isn't held to the high standard that the state is. And there was no evidence that the autopsy couldn't have been amended at a later date if additional information was received. The ME testified, excuse me, the ME didn't tell you that they couldn't amend the autopsy. He just told you they didn't. What else didn't they do? Why didn't they do a hair follicle test? Dr. Christensen said, well, we don't do that unless we're asked to. Who would you be asked to do that by? Law enforcement. Again, Summit County was only looking for evidence to confirm their theory. Evidence to support that Kouri was behind Eric's death. They did not want to look for evidence that contradicted that theory. Had they done that test, we might have our answer. Confirmation bias. All right, let's start with the means. The state did not and cannot prove that Kouri ever purchased fentanyl. Carmen Lauber, interestingly, they barely mention Carmen Lauber in their closing. The only witness who can put fentanyl into Kouri's hand. Let's talk about her testimony. Admittedly, a lot of it was painful to watch. And in some ways, she's sympathetic. But she is looking at multiple long prison sentences. And her only way out, her only way was to testify at this trial. But what she could not do was put fentanyl in Kouri Richins' hands. She told you that she had no memory of what actually took place in 2022. During those interviews, she told detectives over and over again, my brain is fried. I've been using drugs since 6th grade. My memory is gone. So what she testified to you wasn't what she remembered. She admitted on the stand that what she testified to was what she had been shown, what she had been told. Detective O'Driscoll told you that Carmen Lauber could not remember the purchase of drugs after Eric had died. When asked by Ms. Nestor if at least one of the times that Carmen allegedly purchased drugs from Mr. Crozier and brought them to Kouri was after Eric's death, his response was, her testimony was not that. She didn't remember it that way. We found digital evidence that supported that. But you know what? She did testify to that. She testified at length and in detail about something that even Detective O'Driscoll said she didn't remember. Carmen Lauber was not able to tell you that she bought fentanyl. She agreed on the stand that it was the detectives that first put the word fentanyl in her mouth, in her head. She was told by detectives in this case that she bought fentanyl. Eric died of fentanyl, you bought drugs, you bought fentanyl. She took that story and she ran with it because she had everything to lose. And Detectives O'Driscoll and Detective Maynard told her, you are getting a big, giant get-out-of-jail-free card. And what do you have to do to get that big, giant get-out-of-jail-free card? Give them the details that will ensure Kouri gets convicted of murder. You heard that from O'Driscoll's own mouth. He tried to explain it away. But he went in and he told this woman, get out of jail free card, give us the details to ensure Kouri gets convicted of murder. She had to tell them that. She had to tell you that. She had to say she purchased fentanyl. The detectives walked into those interviews not to find out what happened, but to get Ms. Lauber to confirm what they already had decided happened. Again, confirmation bias. She told them at that first interview, I literally never dealt with fentanyl. And she had reason not to deal with fentanyl. She told you that. She had a daughter who had overdosed from fentanyl. She was afraid of fentanyl. She told them that Kouri asked for something for an investor's bad back. Maybe it was for Eric. But she told them that Kouri asked for an investor's bad back. And that later she asked for something stronger. She asked for the Michael Jackson drug. She told them Kouri never asked for fentanyl. She admitted that she got the word fentanyl from Detectives O'Driscoll and Maynard. She told them she couldn't remember. She asked them to lay it out for her, to put the pieces of the puzzle together, to write it down and I'll sign it. They argued that was because, well, she didn't want to write it in her cell. That's why they wanted us to write it. Well, she could have written it right there at the table, I suppose. But you know what else? Remember? She also told the Assistant United States Attorney basically the same thing. Put it together for me. And the U.S. Attorney or the Assistant U.S. Attorney said, oh, we don't do it that way. You have to tell us what you remember. They literally offered a big, giant get-out-of-jail-free card. In the state's last question to Detective O'Driscoll, they brought up the TV show The House of Cards, but who held all of the cards in this case? Jeff O'Driscoll told you. Carmen Lauber held all of the cards. Their entire house of cards is being held up by her. And now at trial 3 years later, She comes in here and says she bought oxycodone once and fentanyl 3 times. Oh, she had her story down. She told it very nicely on direct. But when pressed, she couldn't remember anything. Not from 2022, not from 2023. She couldn't remember on Friday what she testified to on Thursday. And I didn't ask her about her mental health or her learning disability to be mean. I asked her because it explains why she was so easily convinced by law enforcement as to what she needed to do and what she needed to say. She described her learning disability as low education. Well, you can decide what that means for yourself, but one possibility is she has an intellectual disability. And if that is the case, she is more vulnerable to suggestibility than most people. Easy to manipulate. And they took advantage of this. We all saw it. They did too, but they had to find someone who would confirm their theory. But you know what? Through all of this, there were a handful of things that Carmen Lauber was consistent about. There were a few. Kouri asked for some pain medication. Kouri said that in the Walk the Dog letter. Then she told you, I brought oxycodone from Susan Kohler on February 11th. Prescription oxycodone. Now that's important because if Kouri had any pain pills before February 14th, these were likely what she had. She said Kouri never asked for fentanyl. She said that in all of her interviews. Carmen never asked Robert Crozier for fentanyl. She said that. She was consistent with that. That she bought pills from Robert Crozier. That the pills she got from him were light green. 15 to 20 milligram oxycodone pills. When she bought from him again, she asked for more of the same. Those are the things she said throughout. Everything she said, every other thing she said has changed multiple times. It changed again while she was on the stand. Now she says the number of purchases were more. That changed. The date changed. For the first time, she says that Crozier was the first one to say the word fentanyl. It's the first time we've heard that. Wasn't in the interviews. She's not a truthful person. There were a couple of little things she lied on the stand about. Not super important, but I'm going to point them out because they were just untruths. When I asked her if she was on any medication for her anxiety or any other illnesses, she said no. But then later, when Mr. Bloodworth asked her, she said yes, she was on medications. They were in her car in her purse. She told you Nancy Peterson drove to buy the drugs because she didn't have a driver's license. When we showed her that photo was reversed and that she was driving, did you notice how smoothly that story changed? Oh, well, yeah, I drove one way, she drove the other. By the way, where's Nancy Peterson? There was someone who might have been able to confirm Carmen's story, but we didn't hear from her. What else did Carmen lie about? She sat on that stand and she told you, I never violated drug court after I got out, my get out of jail free card in May of 2023. But then when confronted, she had to admit, oh yeah, I did. That's right. She told you, well, I was holding a can of alcohol, but I didn't drink it. When confronted, though, she had to admit that wasn't true. She sat on the stand and she told you that. Oh, I just held it. Oh, but you told your probation officer you drank it. Oh, yeah, I guess I drank it. But what's the most important thing she admitted to lying to? She lied to a judge. She lied to a judge by writing a letter saying that she had been 100% compliant with drug court. And why did she lie to that judge? She wanted to go to Vegas. And she told you on the stand, she admitted it. Yeah, I was untruthful with the judge to get something that I wanted. She was untruthful because she wanted to go to Vegas. There is a lot more at stake here than going to Vegas. She is, again, being untruthful to get what she wants. And what she wants this time is to stay out of prison. And she will say whatever she needs to make that happen. You know what else she got by telling that story, in addition to her get out of jail free card? She also got an advance straight to go and pass drug court on the way card. No more showing up at drug court. And she told you drug court's tough, but she didn't have to go anymore. No regular check-ins. She just had to text hi or lobber to Detective Maynard. And most importantly, no more drug tests. She's still on probation, still waiting to go to court to see if her charges will be dismissed. And she's not being drug tested. Is she telling you the truth about being clean? We have absolutely no way to know. She got everything she wanted by testifying to things that she admitted she had no memory of. Can you feel for Carmen Lauber? You can. Can you believe her beyond a reasonable doubt? You cannot. And if you can't believe her beyond a reasonable doubt, you have to find Kouri Richins not guilty.
That's not the jury instruction.
I don't want to talk about Robert Crozier, because he's also an addict, and he also changed his story. But what makes him different? First, his original story was given in a 13-minute interview while he was coming down from drugs. Not in 10 hours of interviews over multiple days. Detectives came in, and they told him he sold fentanyl. They said, we already know. We know you sold fentanyl. You just need to confirm it. We won't jam you up. Just tell us you sold fentanyl. And he agreed with them. And they asked, did Carmen Lauber know she got fentanyl? And he said, absolutely. But what did he explain to you on the stand? Now that he's been through rehab, now that we know he's sober, he gave people what they asked for when he was selling drugs. He always gave them what they asked for. So when detectives came in and said, well, you sold Carmen fentanyl, Carmen asked for fentanyl, he said yes. He said, what I meant is, if that's what she asked for, that's what I gave her. What else makes him different, though, from Carmen Lauber? He changed his story from what the prosecution wanted him to say to what they didn't want him to say. Not the other way around. Why do this? Why would he risk his immunity? It would have been so much easier for him just to stick with his original story. Let's go back. So he gives that original story in April of 23. He sobers up. He meets with the state. He meets with Mr. Bloodworth in April of 25, before he ever spoke to me or to Mr. Berman. And he tells them at that time that he got it wrong. He says, no, I sold Carmen oxycodone, not fentanyl. And how does he know this? He told you. Because he didn't start selling fentanyl until late 2022. And he sold to Carmen Lauber in early 2022. Also, his source gave him fentanyl that was so dark it was almost purple. It wasn't light green. It wasn't light blue. Okay, so then he meets with our team in October of 25. He says the same thing. He signed an affidavit swearing it to be true. He testified to the same thing at trial. I was only selling oxy in 2022. And not only that, he told you it was prescription oxy from a pharmacy. So not fake oxy that was actually fentanyl, but real oxy. And he was a bit of an expert on the topic. I think he knew more than the drug expert did. He told you, light green pills, those were 15 to 20 milligram pills. Light blue pills, those were 30 milligram pills. His prescription was 10 milligram pills. He knew his stuff. He was a pretty successful drug dealer. And he told you when I sold fentanyl, those pills were almost purple. What did he have to gain by testifying to this? He's never met Kouri Richins. He'd never met Eric Richins. He didn't know Carmen. He isn't getting anything from anyone. It's for these reasons that his testimony is more credible than Carmen's. Her freedom is at stake, so she had to say fentanyl. She has to give them Kouri. He has nothing to gain. He just told you the truth. The state told you in closing that they traced the fentanyl. It's absolutely not true. Carmen never even looked at those pills. She didn't test those pills. She didn't take any of them, according to her. And we don't know where any of them are. Where are these some odd 90 to 120 pills? They didn't trace that fentanyl. We have no idea where that is. They didn't trace any fentanyl. So how did Eric end up ingesting fentanyl? What other reasonable explanation might there be? You know, I'm not going to stand here and say to you that Eric Richins was a drug addict. He wasn't a Carmen Lauber. He wasn't a Robert Crozier. I don't think the evidence shows that. But that doesn't mean he didn't use. That doesn't mean he didn't ask Kouri to get him pain pills. He probably did. So what do we know? We know Eric was in pain. He had Lyme disease, which can be very painful. He had back pain. He had knee pain. We know he'd been in Mexico not long before his death. Look at what he was doing right before his death. So right before his death, he's texting Pedro Sonora, back and forth, back and forth. Did they interview him? Like we said, no. He texts his friend Scott Wagner, more, Pedro Sonora, from 8:30, between 8:30 and 8:36, he texts him 1, 2, 3, well, these are back and forth. But between them, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 texts. He gets a call from Scott Wagner. What's his last Google search? How far is it from Scottsdale to Nogales? And then he gets a text from Raul. We also don't know anything about Raul. Maybe he made other calls. The state said maybe Kouri was calling on the Wi-Fi. Maybe so was he. We don't know who else he talked to, but this is what we do know. Oh, which this is a good place to bring up, I think, that the state did stand up here and they told you that we said things in opening that didn't come in during trial, and that's true. Strategies change during trial. But remember, we are not the ones under an obligation to put on any evidence. It's not us. We're not under an obligation to prove anything. It's them. Okay, so what else do we find on that first day that Eric died? What else do they find? The hydrocodone bottle. Whatever happened to that bottle? Why wasn't it tested? What was kept in that bottle? The bottle's sitting right by the bed on Eric's nightstand, right next to his phone and watch that were placed neatly in his charger. An expired prescription bottle with nothing in it but residue. And you can see the residue there. Why would that be sitting out? A 6-year-old prescription bottle. What might be the best way to bring illegal pills back from Mexico? Put them in a prescription bottle? Put them in your suitcase? What might be the best way to store your illicit oxycodone? Stick them in a prescription bottle? Put them by your bed? And now that bottle's gone, and nobody knows where it is, and nobody tested it. And you saw that white powder, and you can look back when you go back, but you saw that white powdery residue on the nightstand next to Eric. Nobody tested that either. So what's another explanation? What could have happened? Eric was about to take his last pain pill out of that bottle that he kept by the side of his bed. He's on the phone with people in Mexico. He's checking how long it takes to drive from Scottsdale to Nogales. Maybe he knew he was getting fentanyl in Mexico. Maybe he thought it was something else, and he accidentally got fentanyl. Maybe had they tested that bottle, we would know. But they didn't. You know what else we know, though? We know he had a prescription for naltrexone. And it appears he wasn't taking it. A drug used to help people control craving for drugs and alcohol. It's not a drug used to treat Lyme disease. There's a reasonable alternative. Reasonable doubt. All right, I'm going to move to motive. The state absolutely did not prove that Kouri's relationship with Josh Grossman was a motive to kill her husband. Josh and Kouri had been seeing each other on and off for about 2 years. You heard from Josh. He testified that their future together was a fantasy, At no time did Kouri ever lead him to believe that she was going to leave Eric for him. It was clear that Josh loved Kouri more than she loved him. You could see it in his face. You could see it in his demeanor. You can look at the text shortly before Eric died where Kouri was trying to break up with him. The state wants you to find that the conversation Kouri had with Josh about his time in Iraq is somehow evidence or proof of murder. But Josh told you she was grieving, that conversation was about life and death and Eric and bow hunting and the supernatural, that it really didn't even seem that unusual at the time. He only thought it seemed unusual when the private investigator told him Kouri killed Eric. It's not evidence of a homicide. It isn't proof of anything. Yes, they were having an affair. Eric was also having an affair, possibly more than one. You heard there was a text about an open relationship, and they can laugh about that, but that's what the text said. And you know what? We do not bring this up to make Eric out to be a bad person. It doesn't matter what he was doing in his personal life. That's not the point. The point is that there were parts of Eric's life that he didn't share with people. Just like he didn't share with Cody that he used marijuana, or even that he took prescriptions. The point is we all have secrets, and Eric had secrets. But back to Josh, the best evidence that Josh was not a motive for Kouri to kill her husband is that after Eric died, she never did get together with Josh. She didn't show up at the brunch that they'd planned to celebrate the closing on the Midway Mansion. She didn't go on a vacation with him in April. She never even finished paying for that vacation. Josh told you that Kouri changed after Eric's death, that she was grieving, that he saw less and less of her, and ultimately she broke things off. And by the way, if Kouri was as motivated by money as they would have you think, would she really have killed her wealthy husband to run off with the handyman who lived for free in one of her houses? That doesn't fit with the state's theory. The state says, look at texts. Replace the words in them with different words. They stood here and made up what was inside people's heads, what they were thinking. The state has to rely on evidence. They have to prove their case, and they can't do that. The state did not prove that Kouri killed Eric in order to be with Josh. All right, money. Money's a motive for a lot of things for a lot of people. Was Kouri a brilliant businesswoman? No. Was her business struggling? Yes, it was. Was there fake it till you make it? There seemed to be a lot of that going on. Brooke Carrington testified that money was not a priority to Kouri Richins. She could have used an accountant, she said. She didn't even use QuickBooks. And this is all true. A young mother trying to run a business, like most young mothers, young working mothers, did her accounting take a back seat to her family? Probably. The state also wants you to believe that Kouri was cheating her best friend, but that's not what the evidence showed. The evidence showed that the $45,000 that Chelsea gave to Kouri was not earmarked for closing. Kouri could do whatever she wanted with that money. All that mattered was that when she went to that closing on that house, that she showed up with $45,000. It didn't have to be that $45,000. It could have been $45,000 she expected to come in from another flip. But then Kouri was arrested and never got the opportunity to do that. That's why that house foreclosed. But you know what the evidence has shown? That Kouri, rightly or wrongly, truly believed that that Midway Mansion was going to turn everything around. They were celebrating that night. If Kouri was going to kill Eric for money, she certainly would not have done it on the night that she believed she had just secured a multi-million-dollar property. And if you look at the state's exhibit 624D, you will see that Kouri actually made a profit on every single home that she flipped. She had reason to believe that she was going to make a profit on this one too. All the foreclosures, those were all after her arrest. And something else, they say it would have cost way more money than she had to rehab the mansion to live in it with Josh, which again, Josh said was fantasy, that wasn't going to happen. But if you don't believe him, look at text, look at State's Exhibit 2-17D on page 33. This is where she and Eric are going back and forth on how much it would cost to rehab the mansion. And he says, we can't afford that. We don't even have time for that. What does she tell him? And you can look at it. I don't have it word for word. She tells them, no, we're not doing that. I just need money. I just need to give the numbers, to the investors. She didn't intend to rehab that. She intended to flip it after a little cleanup. All right, I want to talk about the gifts that the state talked about in their opening and throughout trial. They made such a fuss about these. They were accessed on Kouri's phone on March 4th, the morning of March 4th. They were tied to the celebration. That's what those were about. If you look at that exhibit, I think it's 3-40, you can see that the orphan gifts were accessed at the same time, down to the second, as a picture of the Midway Mansion. So what do we know about these gifts? We know that some photos were stored in a cache on the phone, not connected to any particular text. We know that they were accessed the morning of the 4th. We know that at least one of the pictures, the one of the mansion, was sent by Eric the evening before, which likely means all of these photos were sent prior to the morning of the 4th. These were not about Eric's death. She wasn't celebrating death. These gifts were sent earlier, and she was celebrating closing on that mansion. It just doesn't follow she would kill him for money. She received less from life insurance than she thought she was going to make on that mansion. Josh Grossman told you that she was surprised when she found out about the $1 million life insurance policy from auto insurance. It appears she didn't even know that. And if you take Brooke Carrington's testimony as true, and by the way, she was a good witness. She is a professional, expert witness. First hired by the family, and then paid $200,000 by the state. A prosecution witness, sitting right here today behind the prosecution. Very different than the MEs, who are just here to tell you their findings. But anyway, if you accept her testimony, the life insurance wasn't going to fix the problem anyway. Kouri spent that life insurance within a matter of weeks and was still in debt. And you know what you heard on that phone call between Bryce and Chelsea and Kouri? All I want's the home. It's all I want. They can have everything else. They can have the money. I don't care. I just want my house where I've raised my boys. And you know what? Eric was making good money. In 2020, he told Christina Miller, the attorney he went to about talking about a divorce, that he was making, his income that year was over $33,000 a month. Cody Wright testified that they made $500,000 each the last year that Eric was alive. I believe there was testimony that there were other years he made even more. Not sure about that, but I think that was in there. So if this case was about money, Eric was worth so much more to Kouri alive than dead. Opportunity. Well, I guess her opportunity was she was the only one in the house. Who else was in the house, though? Who else had an opportunity to take those pills? Eric. 4 years later, 10,000 searches, over $300,000 worth of expert witnesses, 3 weeks of trial, the FBI, the DEA, Homeland Security, the Summit County Sheriff's Office. They cannot tell you how Eric ingested that fentanyl. They haven't done their job, and now they want you to make inferences based on paper-thin evidence. They speculated on a number of things during closing, and they want to tell you, they want you to do their job for them. Tell them no. Tell them if they're going to charge a person in your community with the most serious crime there is, they better have the facts. They better have the proof. They better have more than speculation and conjecture, because that's their job. It's not your job. All right, I want to talk about the elements. The first one, aggravated murder. Okay, so they have to prove that that Kouri Richins intentionally or knowingly caused the death of Eric Richins. The state has not proven this. They haven't even proven that she obtained fentanyl They have not proven where the pills ended up or how Eric took them. The state stood up here and argued, well, it really doesn't matter what drug she purchased. As long as it was an illicit street drug, it absolutely matters. Because what did he die of? He died of fentanyl. There was no oxycodone in his system. There was no other drug in his system. They must prove that she purchased and gave him fentanyl. Oh, and let me talk about Becky Lloyd for 1 minute. She said that she had a conversation after a drink or two where Kouri allegedly said, oh, things would be easier, I'd be better off if Eric was dead. But what else did you hear? You heard Becky in a recording tell officers and investigators, I don't think I can testify to that on the stand. I'm not sure that that's true. But then she testified to it. Well, maybe they threatened to bring a catch pole for her dog too. One thing I want to point out here, though, is if after looking at all the evidence, you believe that Ms. Richins accidentally obtained fentanyl when she thought she was getting oxycodone, and then Eric took those pills voluntarily and died, that is not intentionally and knowingly. That is not aggravated murder. And if you conclude that, you must find Kouri Richins not guilty. All right, attempted murder. What is the evidence of this? And again, it has to be intentionally or knowingly, and it has the rest of the elements there. She had to take a substantial step. So here's the evidence. Kouri bought an omelet and an egg sandwich at 9 o'clock the morning of February 14th. There was no evidence that she left that sandwich in the truck. To the contrary, there was a conversation with her mother saying, they think I left some sandwich in a truck. That didn't happen. Eric said he wasn't feeling well. He took a nap between 11:30 and 2. He called a couple of friends and sounded upset. He joked a few days later with Kouri and friends that his wife had tried to poison him, that he'd had an allergic reaction and used an EpiPen. Alex Staking told you that, Ollie Staking. She never said that Kouri got defensive. She didn't say that. She said they were all laughing. She said that Eric didn't seem upset or scared. It was a joke. Wouldn't be the first time a spouse ate something and said, oh my God, my wife tried to poison me. But that's it, that's their entire case. He didn't go to the hospital. He didn't do anything that day but take a nap. Eating an egg sandwich, having an allergic reaction to something, and taking a nap. There is no world in which that is attempted murder beyond a reasonable doubt. Oh, they point out that months later in text to Chelsea, her friend, that she gets some details wrong about that day. Maybe because she didn't try to kill him, and in her memory that day really wasn't all that important. She said, I bought him lunch. Well, it was breakfast. Again, they stood here and said, Eric was thinking this, Kouri was thinking this. She was, off with Josh thinking all these things. None of this was evidence, not any of it. None of it is proof. They talked about some IRS calls that she made on those days. No evidence as to what was in those calls. No witnesses from the IRS. Speculation, conjecture, not proof, reasonable doubt. Okay, I'm going to jump quickly. The other 3 counts I'm going to go through quickly, but I'm going to go to count 5, which is the forgery count. Now remember what we're talking about here. This is one of those life insurance policies that any of us who belong to a credit union get, where you don't have to do anything. You sign here for $100,000 free life insurance. And this was filled out for both Kouri and Eric. Matthew Throckmorton, the handwriting expert, all he could tell you is that Eric probably did not sign the True Stage insurance policy. Probably is reasonable doubt. And he could not tell you that Kouri did sign it. They have not proven that Kouri forged Eric's signature. And there was no evidence either way if Kouri had permission to sign Eric's name on that True Stage life insurance. I mean, let's be serious. It's the rare married couple who doesn't occasionally say, hey, honey, I'm going to sign this for you. Is that okay? But there was no evidence either way. She's not guilty of forgery. All right, jumping to the insurance fraud counts, count 3. Count 3 is directly connected to count 5. because this count alleges that Kouri fraudulently obtained that insurance policy, and the fraud was forging Eric's signature. They said there was a reversed social security number on there, but the fraud's the signature. So if the state hasn't proven to you count 5, it automatically follows they haven't proven count 3, and you must find her guilty, not guilty on count 3. Count 4 says that alleges that Kouri fraudulently collected the true stage insurance policy. All that means is if she did kill her husband and then represented something different to collect that insurance, that would be fraud. But if you find Kouri Richins not guilty on count 1, you have to find her not guilty on count 4. The state has not proven their case. They don't have the evidence that Kouri Richins killed her husband. So instead, they have tried to show you as much evidence as they possibly can to convince you that she's the sort of person who would. Getting close to the end. I'm sure you would like me to stop talking. But I have to tell you, I'm afraid to stop talking. Because as I stand here right now, Kouri Richins is still cloaked in a presumption of innocence. I don't ever want to walk back to that table. As a defense attorney, that is one of the longest walks a lawyer can make. This entire case is going to flash before my eyes. And all I will be able to think about once I sit down is, what did I miss? What did we miss? What didn't we tell you that you wanted to hear? Did I focus on what you wanted to know? Did we do enough? You're about to go through those doors and into the jury room and start deliberations. Everyone in this courtroom, everyone watching around the world, we all wish we could follow you and listen in. But that room, that jury room is yours. It's sacrosanct. In that room, you get to decide. And when you get in that room and you look at the evidence, if you think that Kouri Richins might have killed her husband, that she likely killed her husband, that she probably killed her husband, you must find her not guilty. Because maybe, probably, likely, very likely, none of these reach that extraordinary burden of proof beyond a reasonable doubt. I'm going to ask you to do a couple of things when you go into that room. First, you might be tempted to go around the room and take a vote for guilty or not guilty to see where you all stand. We ask that you refrain from this. Instead, we ask, talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us and not against Kouri. Now, the state's going to get up and talk to you again because they get the last word. And the reason they have that last word is because of that heavy burden. But when you filled out that jury questionnaire, we asked you if you would be comfortable making your voice heard in that jury room. Would you stand by your convictions, by what you believe? And each and every one of you said yes. So here's my final ask of you. When you're deliberating and something comes up that we didn't respond to, will you be courageous? Courageous enough to raise your hand and talk about what our response would be. Raise your hand for Kouri, because you are the last line between an innocent woman and the state. Be courageous. Courage is what this moment demands. The courage to stand between a member of your community and the state and demand that they comply with the Constitution, that they comply with their burden. Do not let them fool you. Do not fall for red herrings. Kouri Richins did not kill Eric Richens. The state did not prove this case beyond a reasonable doubt, and you have the courage to tell them this and find Kouri Richins not guilty.
Well, she went about an
Your
hour.
Honor, 15 minutes now will save me 30 minutes later.
Understood. Folks, let's just stretch your legs.
That went for about an hour, 10, hour and 15 minutes. There will be a government rebuttal. They're just stretching their legs here. Joe Potuto, real quick, before they unstretch their legs, Wendy Lewis gave an impassioned closing. She seemed to be much more all over the place to me than Brad Bloodworth was. She said it was all driven by bias, confirmation bias. The entire house was not searched, and basically said in so many words that there was tunnel vision by everyone from law enforcement.
I genuinely couldn't tell if you wanted to do something on the record or just needed a break.
No, so just a break to, well,
Collect your thoughts.
collect my thoughts.
We'll be in recess until 2:15. Thank you.
15-minute break, which is good, so we can discuss this. I mean, Joe, what was your overall thought? A lot of people were saying, please stop talking to Wendy Lewis. I mean, she's doing what she has to do, but what she presented, I thought, was fairly thin in term, or at least in contrast to what the government presented.
Yeah, but she's got a different, she doesn't have this high
burden,
sort of a bar to reach either. All she's got to do is say there's enough here that there's reasonable doubt, period. She doesn't have to make a whole case that Kouri didn't do it, and she certainly didn't make that case. But I think she didn't do a bad job saying here's reasonable doubt. She went after of course, they always do this, they go after the investigation. But I think there was more in terms of the failings of the investigation here than in a lot of trials. I mean, it is true that that pill bottle never, disappeared. The defense on Friday tried to get a special instruction saying if it's gone, you're entitled to infer that it would have helped us if they found it. I think she did about as good a job as it was possible to do to show reasonable doubt. She did a couple of things, they're loosey-goosey in Utah on some of these rules because she injected personal information. I was about Kouri's age when my husband died and I was left with 2 small kids. That's improper. Mm-hmm. And at the end, she did the same sort of thing about saying, we'll worry, I'll go back. And you're not supposed to be able to do it. But boy, do they let things like that in, at least this judge in this court. I think we'll have to hear what the state does to respond. He's got to bring the jury back to the evidence that shows she did it and not the failings of the investigation and not, gee, it could have been something else. She misstated the law a couple of times. One time she did it when she said, if you can't believe Carmen Lauber beyond a reasonable doubt, then you can't convict. And that's not what the instruction said. The instruction said, if there's no evidence corroborating, then you have to believe her beyond a reasonable doubt. But there is corroborating evidence. She said that she met the drug dealer at a particular location. I don't remember the location in Utah, but it was sort of between where she lived and where he lived. And there's all the sort of the phone pinging that shows that they met there. And he corroborates some of what she says. And she's, so I don't like it when they do that. I think they should state the law accurately. But what did you think?
Well, I thought that they for a while, it seemed like they had the private eye on trial, and not Kouri Richins, because they were going really hard at the private eye, saying that not even, regular law enforcement, but the private eye who didn't investigate alternative leads, that they put trackers on cars,
right?
Didn't go to got to the walk the dog letter and didn't prove the veracity or not the veracity of it. All these different things that came up. But they did a good job of avoiding Kouri herself.
They did.
They did. What I mean? They kept her name. They kept her name out of it. And
it's frustrating. I sat here being frustrated for the state because some of the things they said, he cannot respond to. He can't say, well, if you thought all these things were wrong, why didn't you call these people and ask them? What they say is, gee, the state didn't do everything it could have done, but the defense didn't do anything it could have done to rebut any of it. And it's frustrating because the state can't go there. And the state can't say there was a witness who died who could have said she asked for fentanyl. I mean, it was bringing back bad memories to me of doing trials, prosecuting.
It sounds, if I heard Brad Bloodworth correctly, that he only plans to rebut for like 15 minutes. So it sounds like he's going to be, tight and right and just on the money to just rebut some of the things that were mentioned here. I don't think he has much to say. I mean, I felt like this year was a lot of to use the expression that some people in the chat use, a lot of word salad just to sew up some reasonable doubt. But I think when they get in the deliberation room, the evidence is strongly weighted against Kouri. So I think it's going to be rather quick. I thought one of obviously the stronger points that they have is that manner of death could not be determined as to whether.
And that was
accident or
another
homicide.
that was another misstatement, Joel.
Yeah.
The fact that the ME said they couldn't determine doesn't mean that the ME said he had a reasonable doubt.
Mhm.
They don't have all the evidence that the jury has when you finally go to trial. They didn't have all the context.
Right.
So
Well-
I just don't like it when they do that.
Well, Wendy Lewis said at that point, she says, if the medical examiner has reasonable doubt, how could you not have reasonable
Exactly.
doubt? So I'm wondering if Bloodworth's going to bring that up, because I mean, to me, that was for the defense one of the more powerful things that they could have
I
done.
hope he does, and I hope he goes through some of the walk the dog letter, because he didn't do much on the first part. But I think what he's going to do and what he has to do is say, they want you to go down all these frolicking detours, but let's look at the evidence that proves guilt and not their claim that the state, that the investigators could have done more. I mean, some of it is kind of, they should have done, I mean, I agree, they should have done more at the house. They should have gotten her consent and searched everywhere, and they would have found nothing. And then the defense would have had a different argument here. It would have been they didn't find anything, so of course she didn't do it. I mean, there's no winning on those arguments.
Yeah.
But,
she brought up Carmen Lauber, saying that you barely heard the defense bring up Carmen Lauber because the implication was she wasn't a good witness, and then went on to basically bash Carmen Lauber, saying that she couldn't remember anything. She said that Kouri never asked for fentanyl, so you have to ask what else did Carmen lie about, and then she mentions drug court. So they basically, character assassinate her. And then subtly they pivot to, we don't want to, she said something like, Eric Richins might not have been a user to the level that this Rob Crozier was or Carmen Lauber, but you don't share everything about your private life with everyone. So the implication is that he had a drug issue.
Right.
And that he was the one getting it. And why didn't they chase down this lead in Mexico? I don't know, Joe. I mean, it only takes one, as the old adage goes.
That's right.
But again,
That's
I think I think the evidence is pretty overwhelming. And if you go back and you look at both closings that were presented today, without a doubt, Brad Bloodworth is much more cogent, cohesive, much easier to follow. I felt like Wendy Lewis was kind of jumping around quite a bit and was kind of personally angry at times. Do you get that sense?
I did too. Well, I think I don't want to say I think that what he will do is to say, I'm not going to go chasing down all these rabbit holes of what could have, what they say. If you looked here, you would have found something. If you looked there, you would have found something. Let's stick to what the evidence actually shows and then go through and do it.
Yeah,
because if he starts responding, he's going to cause more confusion, not less. He wants to be direct and straight and say, here's the evidence. Let's go through it again.
A lot of people are asking, we touched base with Skye Lazaro, who's, as you guys know, in the gallery today on the prosecution side. She was representing Kouri. I don't think she's going to comment at all on this. If she does, she will do it, I think, with us. But I think she told Steve Cohen, and I'll double check, that she just
I think that's right.
Yeah.
Because she can't. She still has under law client confidentiality rules with her client.
Yeah. Now, on the flip side, though, Greg Skordas, who's a well-known, prominent criminal defense attorney out of this part of Utah, he was the Richins family spokesperson and still sort of acts in that capacity. He said he will talk to us once there's a verdict.
Right,
and
right.
Who knows?
He said the same thing to me. But, think about it. You have been working so hard, with the family in Philadelphia of the woman
Greenberg.
That's right. That would be, if that ever goes to trial, that defense will be the same thing. The police did it, and it's only because the family was pushing, and you can't believe it because they had an interest. But in a lot of these cases, and that would also be the case that Tim Jansen did. The defendant Williams, who was claimed to, he disappears and it's
Mike
his
Williams,
best
yeah.
friend, right, that he was eaten by alligators or crocodiles. If that mother hadn't kept pushing, I mean, in a lot of these cases, it's the family that keeps pushing that gets the case reopened, another look, finds the evidence that's important. So it's and it doesn't mean that because that private investigator did some of the investigation that there's anything wrong with the police did. What she was trying to do indirectly is they made a motion pre-trial that said the private investigator was actually acting as an agent for the state, and therefore he should have been held to the same rules that the state would, and therefore everything should be suppressed that came through him. And that's not the law. If I'm the private investigator and I find things and I hand it over to you as the police, you have every right to take it. You can't tell me to do it. You can't tell me to do things you can't do yourself, but you can sit there and receive like crazy. It would be insane if the system didn't allow you to take evidence that someone else found.
Shout out to Matt Breff with a super chat here. Appreciate this. Let me know, Judge, impromptu poll because the COE is running around, but let me know what you think. When do we get a verdict here? This is going to go to the jury this afternoon, just in a short time after after the government comes back and delivers its rebuttal. But let me know when you think we get a verdict in this case. I think we're going to get one tomorrow. What do you think, Joe?
I don't like to predict, and I do think if there's one case that I have heard where there's where you can make this argument about reasonable doubt, this is the strongest reasonable doubt case I have heard. I still think it will be a conviction, but I don't know how long it will take to get there. They've got the 5 counts, and the other 3 maybe are sort of, the jury is not going to be as maybe not as focused on them, but they still have to make a decision as to them.
So, Joe, why do you think that this is? Are you saying of the trials that you've watched recently that this has the most reasonable doubt? Is that what you're saying?
Yeah, of any that I've seen, I think.
Why do you say that?
Well, because I think for a jury, it's the poison is different from the bullet in the gun, and you've got 2 addicts. And both have sort of changed their stories. The dealer said it was fentanyl originally and then flipped. Carmen Lauer has been all over the place. And I think that will be difficult. The jury's going to have to wrestle with whether they can believe anything she said. Now, Kouri is not denying that she asked Carmen Lauer to get drugs. I mean, the defense lawyer didn't deny it. And so I think once the jury gets there, he ingested fentanyl, and no matter what it was, and of Kouri, if they believe that Kouri asked for, whether it's the Michael Jackson drug or something else, she wanted a drug that would kill, and it turns out to be fentanyl. It doesn't matter that it turns out to be fentanyl if she wanted a drug that would kill. Wouldn't matter with fentanyl or anything else. She got a drug that would kill. But I don't know that that's the easiest concept, would that be the word, for at least, let's say, one juror to get to.
Yeah. I mean, this is the moment where you're always, I think, thinking back and second guessing whether or not.
Oh, it's terrible.
Oh yeah. I think
I didn't do a whole lot of trials, but I'm telling you, once the jury goes in to deliberate, you cannot do anything else. I mean, I have never encountered anything so all-consuming. You cannot. You might as well just sit there and, you can't read. You can't do anything. All you can do is, in that respect, Lewis was right. All you do is saying, well, I should have done this. Why did I say that? I wonder what they're going to think about this. You cannot do anything else. It's terrible.
Simone says 3 hours tops. If that's the case, it could come back today, but they've got quite a bit to go through.
I don't even know how long this judge will let them go. I mean, were I a judge, I would say, you're in charge now. Stay as long as you want.
Yeah, it's 2:15 out in Utah right now. They're going to get this case in about, I don't know, the next half hour, I imagine.
Probably
maybe
because
minutes.
He already did the instructions. He's not going to go through all of them again.
Yeah,
and
by the way,
did that right. I do think the jury should hear the instructions before the closings. so they know what it is they're supposed to be, applying the facts to.
Yeah, I think they're going to be coming back any minute. One of the more sort of laughable parts I thought of the closing by the defense was money was not a priority for Kouri Richins. She said, and she just could have used an accountant, and then said, like most young moms running around, accounting took a back seat. But I think it was a little deeper than that. So it's just funny what
that was a bridge too far. I don't think there'll be a juror that doesn't believe that money didn't matter to her.
Yeah. And then look, there's people here who are saying Carmen was very believable, and that goes back to Luis Rivera in the Adelson trial, who's very credible despite being the admitted hitman in that case. So we're going to see. What do you think Brad Bloodworth has to do here, Joe?
I think he's got to bring the jury back to the evidence that shows she did it, and away from all these, side tours that Lewis took them on. And I think to the extent, and there were a couple of times where I think she misstated the law or misstated what the jury has to do. And you're right, the Emmy is one of them. And the other of them, again, is what is it if they believe that Kouri paid to get a drug that would kill? It doesn't matter that she didn't know it was fentanyl that she was getting. And I think he needs to make that point again with them, because I think that would be confusing to some jurors.
Quick programming note. We're coming back at 7. We're back on. There's some developments, albeit nothing earth-shattering, but some interesting developments in Nancy Guthrie, and we're going to update that at least once a week. So that'll be tonight. You've got homicide detective Phil Ramos, retired SWAT commander out of Pima County, Bob Krieger, coming on, along with retired homicide detective Kurt Dabb out of Pima County. So we've got 2 Tucson people coming on tonight at 7, and Phil Ramos to discuss that. If for some reason there is a verdict tonight, which I highly doubt just because of the timing of the day, we will bring you the verdict as soon as we get it. The next 2 nights, my middle daughter, is starring in Aladdin. So I will be at her play in the evening. So we're going to be doing noon shows Tuesday and Wednesday. And we have Gigi McKelvey, who's in this courtroom as we speak. She's willing to come on and do a lunch live with us tomorrow. Gia and TJ's mom, that's a great question. Are we staying on for verdict watch? Look, Roger's saying verdict is tonight, 100%. Interesting. I'm going to have to touch base with the COE before I roll out, and then I'll let you guys know, because, as you know, she's the boss, not me. I just work here. She makes the decision. So I will let you know as soon as I talk to her. But Joe, we'll be here as soon as there's a verdict. Yeah. Look at this.
There's a question here, Joel. Does the rebuttal only go over what the defense did in closing? I mean, technically that's true, but she went over the whole case in her on her closing, so everything is available to him.
Does anyone else get nervous when their spouse says, "Please call me" in all caps? Let me do that right now.
Please have a seat as you come in. Please have a seat. Mr. Bloodworth, please proceed.
Thank you, Your Honor. Next, guys. Parlor tricks are not legal standards. Legal standards are what matter. Let's review a couple of the important ones. You'll have them in your instructions when you go back to deliberate. Reasonable doubt. I come back to this one again and again. Evidence usually consists of testimony and exhibits presented at trial. What the lawyers say is not evidence. I've come back to this slide in rebuttal precisely because of defense's closing. There is a reason the state provided you in its slides with the cite to every single piece of evidence it argued. We told you what transcript page and line number. We told you what exhibit number. Because what the attorneys say doesn't matter. The evidence is what matters. And there's a reason defense counsel didn't cite you to the evidence. Next slide, Scott. A lot of the evidence is circumstantial. It is. People do not video themselves poisoning their spouse. But circumstantial evidence is just as good as direct evidence. You can use circumstantial evidence to conclude facts just as you can use direct evidence. The instruction gives the example of it is wet outside and people are closing up their umbrellas. That makes sense. Let me put it to you a different way. Does everybody know what happened here? Kouri Richins chose Carmen Lauber. The state didn't. Hold on, let me check something. Go back one. Kouri Richins chose Carmen Lauber, not the state. Go ahead, Skye. Thanks. Kouri Richins chose Carmen Lauber because she was the drug dealer she knew. The state granted Carmen Lauber immunity because it cares more about a murder case than a drug deal. That should surprise nobody. Kouri Richins chose Carmen Lauber in part because she had control over her. She could help her out. She employed her to some measure. She could help her out. A little quid pro quo. You give me some drugs, I can help you out with your drug court. Kouri Richins chose Carmen Lauber, not me. Her testimony is corroborated. If you only believe Carmen Lauber's testimony that is corroborated, that is plenty of proof to convict. She was only at that Maverick in Draper 3 times. That's what the digital evidence shows. Each of the 3 times she was there, so was Robert Crozier. Those were the only 3 times he was there. Their testimony corroborates each other in the relevant manner. It corroborates that they met, that he sold her drugs, illicit street drugs, that it had fentanyl. Blues had fentanyl. Corroborates that they weren't prescription drugs. He got them from a plug, not a pharmacy. They were packaged in a little clear baggie, not a prescription bottle. All the testimony of Carmen Lauber and Robert Crozier that matters corroborates each other.
So with these transactions, when Karm hit
Go
you
ahead.
up,
We've
what did she
seen this
tell
one
you?
again. Crozier was at the gas station 3 times. Carmen Lauber was there every time. The March drug deal. Timing of this is very interesting. Shortly after Eric's death, Carmen Lauber spoke with Kouri Richins and asked, "Please tell me these pills were not for him." Of course she denied it. No. But then, a few days later, she asked for more pills. It's curious as to why. perhaps to cover up that the pills were indeed for Eric. If I ask for more, she'll know they weren't for Eric. It's also interesting that she said she needed something to get her mind. What? I don't know. Maybe she wanted the pills for herself. This suggests she wanted the pills for herself to calm her mind, which tells you she knows that a pill that she buys from Karm and Lauber is not bad. It's a whole bunch of pills that kill. Consciousness of guilt is evidence of guilt. Kouri had a guilty conscience. She couldn't talk to her father that night, not because she was overcome by grief, because she could not face the man whose son she had just murdered. We're going to play these clips right here now. This is when Kouri Richins is asked whether she's going to tell her children, whether she's going to talk to her children. Notice Kouri Richins' reaction in the moment. To this will be Katie Richins' reaction in the moment. Go ahead, Skye.
Where are your children now?
Asleep in that room, 2 are awake with their ear to the door. They go on the door. Please don't make them come out. He's gonna help her. Where are my boys?
The kids are in
This is where's my brother?
He's in this room.
No. Do I see my brother? Baby.
Kouri, is there a way you could relocate your boys upstairs?
Yeah.
Because there's going to be a lot of traffic.
Yeah, I'll tell her now. Wait, okay. Come on. Come on.
Kouri Richins walks away.
Bob. Bob.
Katie then takes the boys upstairs. In moments of tragedy and profound sorrow, you not only comfort your children, they comfort you. Kouri Richins hides her face because she doesn't know how to react because she is not grieving. She doesn't want to see other people see her non-reaction. She's not grieving because she feels no grief. She just murdered Eric. You heard Deputy Wynn testify. She wasn't crying. Deputy Wynn's body camera did catch a moment of surprise. That's the moment he informed her that Deputy Wynn, was sending Eric's body for an autopsy. That's her surprise. She didn't tell anybody that night that Eric used fentanyl because she thought she would get away with it. She didn't think anybody would find out that Eric used fentanyl. And the minute Deputy Wynn said, "We're sending his body for an autopsy," that's her reaction. The 2016 empty hydrocodone bottle is immaterial. Eric had no hydrocodone in his toxicology results. The only other hydrocodone reference in the entire body of evidence before you is that investigators recovered on the first search warrant a bag, like a Ziploc type bag, full of hydrocodone pills in the laundry room and the mudroom of the house. Perhaps Kouri Richins removed them from that bottle and staged the crime scene. This is also inconsistent with the notion, having those hydrocodone bottles in the house, pills in the house, is inconsistent with the notion that Eric had a secret drug habit and was going to the street for illicit pain pills, and there's a baggie of hydrocodone in the house. Okay, there is no good reason these images were accessed the same exact minute that deputies departed the house the morning that Eric died. None. And there is, by the way, despite what defense counsel just told you, there is no evidence that Eric Richins sent these images. He sent an image of the Midway Mansion the night before that was accessed at the same time as these images. Sorry, he sent an image of the Midway Mansion the night before, but it was not the image that was accessed at the same time. The image that was accessed at the same time is the distance full view of the Midway Mansion, which makes sense in this context, not the image that Eric sent of the pile of rocks in front of the Midway Mansion. Details matter. We don't know who sent these images, but we do know that they were accessed on Kouri's phone at 8:29, the exact minute that deputies signed the log out of the house, and that whoever accessed them turned the phone this way to view them better. They also viewed the distant image of the Midway Mansion. Maybe she was celebrating the Midway Mansion. Maybe she was celebrating Eric's death. Either way, there is no good reason these images were accessed at 8:29. Kouri Richins minimized how Eric died because she needed to cover up her involvement in Eric's death. The worst minimization was the one to his father. After speaking on March 17th with the medical examiner's office, Kouri Richins told Eric's father, knowing this was not true, that Eric Richins died in part of COVID and in part of the same lung fungus that Jean's wife Linda died of. That is not only covering up her involvement, that is cruel. She covered up with the medical examiner. She pretended she didn't know what quetiapine was, even though she was prescribed it. She pretended she didn't know what acetaminophen was, even though it's Tylenol, and there is probably not a mother in the United States that does not know what Tylenol is. She pretended she didn't understand the word illicit. She has a master's degree. In feigning ignorance with Dr. Christensen, she was fishing for information to craft her defense. She was asking, was it injected? Did he eat it? She wanted to know what the medical examiners knew so that she could craft around it. She was really worried about the amount of alcohol. On April the 13th, Detective Woody told Kouri Richins that Eric died of fentanyl intoxication. Right after that, she tells Josh, oh, it was just a trace. Chelsea, it was just a trace. It It was his lungs that were shot to shit. She is minimizing, deflecting, covering up. She is distancing herself from her murder. Manner of death on the death certificate is immaterial. It's a box we check. It's used for statistical purposes. They turn the information over to the Bureau of Vital Statistics. It's immaterial for this case. You determine the manner of death. It's murder, aggravated murder. Perhaps in a perfect world, the medical examiner would amend the death certificate, but you heard Dr. Ulmer. She signed it on June the 6th, 2022, when the investigation was really in its infancy. And she had one foot out the door. It was her best solution to finish her report before she retired. It is what it is. Bureaucrats. Eric did not ingest the THC gummy laced with fentanyl. When asked if she ate one that night by Deputy Wynn, it didn't seem like he did. Toxicology, there was no measurable THC in the toxicology analysis of Eric's blood or gastric. The THC that they collected on the April 13th, 2022 search warrant, right, the first search warrant, it was found in the cabinet above the toilet in the master bathroom. Wasn't there the night before. You heard Deputy David Pimentel talk about how he searched it. You could see his search on the body cam. It wasn't there. It was put there after Eric died. That's where most of the gummies were. There was also a package in the kitchen, which was never searched the night he died. But all the gummies were sent to the lab for testing. In fact, the gummies, lots of stuff was sent to the lab for testing. None of it confirmed any fentanyl. Brian Holden, he was the state crime lab tech that testified.
Thank you, Holly. I have no idea.
Detective Haskell works the streets of Salt Lake City, drugs his whole career. Never seen fentanyl-laced marijuana. That's that's cover-up. That's misdirection. Kouri Richins' plan, if it was a plan, to make money on the Midway mansion is not tethered to reality. Across her portfolio, she lost money, and she lost money on nearly every individual project. She even admitted, it's out of my league, but the margins are so insane that I had to pick it up and then figure it out. Ha, 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 help. That's ha, ha, ha with $3.2 million of other people's money. She is intensely ambitious. Her plan was not tethered to reality because she could not, with more money than she could even imagine, overcome the Corps of Engineers holds on this property. Not going to happen. She asked Eric Richens for input on how much it would cost to rehab the house. That's the text string right there. Read the whole thing. You'll see that she sold the Midway Mansion to him not as a project they were doing, but as just a sale that she was brokering.
Okay, you clean that one, right?
Okay, ready?
Okay, I'm getting all three.
Cheers, boys.
Yep, come back in the corner with us. There we go.
Richard.
Richard.
Richard, yep.
Richard.
Look, Chachi's still going.
Oh! You're an Afghanistan warrior.
You are an Afghanistan warrior.
People grieve differently. There's no ancient artwork of that photograph. This book provides kind of three pieces of insight into Kouri Richins. The first is she wrote it, had it written, and published it in early 2023 when she knew that investigators were investigating her for the murder of Eric Richins. She promoted it. Her mother sent a book to investigators, all to deflect attention away from Kouri Richins. She also wrote it to make money. You see the emails, they're in evidence. She thought she would sell 100,000 copies in 10 months at $5 profit a copy. That is not tethered to reality. But it does provide insight in how desperate she was for money. That she would trade on her sons and the death of her father to make money. The final things it tells you about Kouri Richins is that she wanted, as part of her facade, as part of her appearance of success, privilege, and affluence, she wanted to be an author. But she didn't write it, and you can see from her writings and text messages, Orange Notebook, the notes, the Walk the Dog letter, not only did she not write it, she's not a good writer. But she wanted to appear as one. The appearance was what was important to her. In defense's closing, when you strip out rhetoric that could be argued at any closing, any time, anywhere, on any case, when you strip that out of defense's closing and you hone in on substance, the entire substance of the defense's argument is based around trying to explain the Walk the Dog letter. Kouri Richins is saddled with this letter and needed to craft the defense around this letter. It's obvious that the letter was written to get her brother to testify to a narrative that would explain everything. Let's unpack the letter in about 15 or so sentences, not with what Kouri Richins wrote, but with what the evidence shows. It's a translation from what Kouri Richins wrote to what the evidence shows. First part, here's what I'm thinking, but you have to talk to Ronnie. He would potentially have to testify to this, but it's super short. What the evidence shows is this says, I'm thinking that if you tell Ronnie to testify to what I'm about to write, it will explain everything and I will not get convicted. Ronnie will need to tell this to my lawyer because I just made it up and it will have to come from him. Never mind that I was arrested 4 months ago. I need an excuse for Ronnie and Eric to be hanging out. Never mind that football season ended a month earlier. I need to explain the fentanyl, and fentanyl must be everywhere in Mexico. Never mind that Eric would have to fly with the fentanyl, and I later say that Eric would not fly with drugs for fear of getting caught. Never mind that I know this story despite Ronnie never telling me. I need to explain why everyone will testify that Eric never used drugs. This kind of happened once with THC gummies on a trip to Hawaii. Hopefully this is enough to corroborate my entire walk the dog story.
Thank you, Carolyn.
I need to distance myself from fentanyl. These are my made-up words, but Ronnie can make up his own words. If Ronnie does not say these things, I'm convicted. I need to explain why investigators never found a trace of fentanyl in my home. Never mind that it doesn't make sense that Eric hid the fentanyl after asking me to buy it. Don't get caught passing this made-up story along to Ronnie. That would be horrible. Tell Ronnie to keep the story short so that he does not mess it up. Since his conversation with Eric never happened, tell him that it was only 2 minutes long. Ronnie needs to do this so that I do not get convicted. I can then extract revenge on Eric's sisters. Remember, I just made this story up, so my lawyer does not know it yet. All the evidence in this case proves that Kouri Richins murdered her husband and the father of her 3 children, Eric Richins. There is no other rational explanation for the evidence. And despite all the evidence, Kouri Richins clings to the facade that has enabled her to get away with so much for so long. And despite all the evidence, Kouri Richins doubles down and blames Eric. She is intensely ambitious. See through her facade, check her ambition, do not let her get away with murder.
All right. Next step. Brittany, if you would please swear in the bailiffs that will watch over the jury during deliberations.
Y'all raise your right hand.
Do you affirm that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered, subject to the pains and penalties of perjury? Thank you.
Thank you. Ladies and gentlemen, a few additional instructions. If you want to read along, you can fast forward to instruction number 46. Foreperson selection and duties. Among the first thing you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into several sections, one section for each count charged. Each count has separate instructions. When rendering your verdicts, you need to make sure only one verdict for each count is marked. You may be asked additional questions about the basis of your verdicts. Remember, any response you give on the verdict form must be unanimous. Regarding jury questions during deliberations, these instructions should contain all the information you need to decide this case based upon the evidence. However, if you have a question or need clarification during deliberations, please write a note and give it to the bailiff. I will review it with the lawyers. We will answer your question as appropriate. This brings us to one of the more difficult parts of the trial for me personally. A jury in the state of Utah is 8 jurors, and there are 12 of you. We intentionally impanel alternate jurors to ensure against the unforeseen because things happen. Jurors fall ill, they suffer a personal or family tragedy during the length of the trial. Sometimes they simply don't follow my instructions and they get exposed to information that it's not appropriate for them to have. Because we can't see around every corner, we impanel alternate jurors to ensure that an emergency or other unexpected circumstance does not cause a mistrial. We simply can't try a multi-week trial without the help of alternate jurors, and for these reasons, the service and sacrifice of alternate jurors is just as valuable and just as deserving of respect as the remaining jurors. Moreover, the service of alternate jurors does not end when they leave the courthouse today. Rather, the alternate jurors are still subject to all of the court's instructions and restrictions, because if an emergency arises during deliberations, one or more of the alternate jurors may be called back to join deliberations at that point. We could not have expected that all of you would be so hardy and so diligent in following the court's instructions, and so we impaneled 4 alternate jurors. The alternate jurors in this case are jurors 9, 10, 11, and 12. If jurors 9 through 12 would please stand. An important instruction. This case isn't over. You're still impaneled. Please do not talk about the case. Please do not let anyone else talk about it to you. Please do not read, watch, or listen to anything about
What happened? We want to hear.
We just lost
you
audio.
for your ongoing service in this case. Please rise for the alternate jurors.
I would hate to sit through a trial and then find out I'm an alternate.
Greg, I can't see who's over there. Yeah, Greg, if you would let them out, I have a couple of extra instructions for 8 remaining. Thank you.
I hate 8-person juries. I think they should be 12.
Yeah, I agree.
Please have a seat, folks.
I don't think it's the way to save money.
Members of the jury, as you deliberate, you may have questions. If you do, please remember, you can write a note, give it to the bailiff. I'll review it with the lawyers, and we'll answer your questions as appropriate. Please remember, though, that the bailiff cannot answer any trial questions for you. Just as you have not been allowed to research or investigate matters on your own during the trial, you may not use any outside source to research or investigate any matter as you deliberate. No online dictionaries, no online maps, nothing outside the evidence presented in this case. We will provide for you in the deliberation room the exhibits. You may take your notes with you. You may take your copy of the jury instructions with you. We'll provide a copy of the verdict form. This case is now submitted to you for deliberation and determination of your verdict. Please rise for the jury.
He didn't tell them how long they could sit, did he?
Not today. I mean, yeah, he didn't set any parameters. Look at Space Coast ready to go with the verdict clock here.
Right on the ball.
Yeah.
It looks like eyes, doesn't it, in a cartoon?
This is coming back very
Folks, have a
quickly.
seat. Thank you.
We'll see. I hope you're right.
Ms. Nestor, Ms. Lewis, anything else on the record?
No, Your Honor.
Okay. Mr. Bloodworth, Ms. Sherbanet?
No, Your Honor.
All right. Let's make sure Brittany has your contact information. Regarding scheduling,
Okay, here we go.
my normal practice would be to check in with the jury around 4:30 and just ask them what they would like to do regarding continue working into the evening or retire for the day and come back tomorrow morning. Any objection, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. I need one member of your respective teams at least to begin confirming with Brittany after we go off the record that we have consensus regarding the exhibits that have been admitted and will be going back into the jury room. If any disagreement comes up, let me know. We can handle it on the record. Ms. Nestor, anything further at this time?
Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. The court will be in recess. Thank you for your patience.
All right. So we are officially under jury deliberations. Verdict watch. Correct. We are at 56 seconds, minute 5 seconds of verdict watch. We're going to bring it to you here just so everyone knows. Just some housekeeping notes. I spoke to the COE. We are going to keep this link going today. This link will not go down. This link will be the link if there is a verdict today. Thank you to Jeremy for the super chat there. Appreciate it. This link will stay up all day today. And I don't know if it'll come back today, but I personally think it's going to be very quick. We'll get Joe's take in just a moment. So again, it is 3:00 Utah time, 1 minute to 3. And the judge said he will check in with the jurors in about an hour and a half, 4:30 their time. So that's probably the next time I'll check in with you all prior to our 7 p.m. show. Obviously, if a verdict comes back, we will take it live. Joe will be here. We'll get some people to weigh in if there is a verdict, but they've got a lot to go through here. Joe Potuto, I thought that rebuttal was insanely good because he used her words to basically implicate her with that walk the dog letter. She is going to be wishing the rest of her life that she never wrote that, but it's always one thing too much that gets people in trouble. And that's going to be what I don't know. That is going to be the factor that dooms her, in my opinion.
The thing that impressed me most about the rebuttal was how well he anticipated what the main points were going to be in the defense, because he was ready not simply with the argument, but with the exhibits. And not only that, they were in order. Now, they could have fiddled a little with the order in the half hour that they had, but that had to be pretty much ready to go. And so He did a great, I mean, some of it was easy to anticipate, but it seemed to me he had everything anticipated.
And I got to tell you, that video of them celebrating doing shots the day after he is dead is, I mean, I just don't know how you get around that. And you've seen that before, right?
Yeah, but that one, I mean, I'm going to have to respectfully disagree here because, I mean, that's like an Irish wake in part. And also, one of the sisters was there, doing the shots also. I think one of the sisters was there.
Let us know if one of the sisters was there. I didn't know
Somebody
that.
tell us?
Yeah.
Okay.
Well, we'll have
I hope
someone
I'm wrong.
fill us in. I don't know. To me, that was. I know they played it earlier in the trial, or I had seen it before. Someone here agreeing with me. I didn't see the sister there.
Okay,
But yeah, but it didn't. Here we go. A lot of people are just saying it was disrespectful. It was that was, and the kids were there.
Yeah, that was terrible.
I don't know. That's just for me a very tough visual. But let's talk about another thing here. 4 jurors, I think it's 9, 10, 11, and 12, ended up being alternate jurors. They were asked not to speak, but they're basically being held back in case they have to slide back in. But Joe Potuto, I've asked attorneys and people of your ilk about an 8-person jury versus 12, and most defense attorneys hate an 8-person jury because it's easier for the government to persuade 8 people than it is to persuade 12 people.
Yeah,
it could go vice versa, I suppose.
Yeah. Until the, I think, 70s, it was always thought that you had to have a 12-person jury to be constitutional in a criminal case. And then the Supreme Court said, no, you can go down to 10, you can go down to 9. Now it's 8. I don't like it. And I don't know whether it helps the defense or not to have more jurors. But I do think that the larger number gives the opportunity for more people with different perspectives to talk about things. And the smaller the number, I think the less diverse, sort of points of view that are there. And I really think it's important that you get a full deliberation with a lot of people with different views. Now, I will say the research is, and that's why I'm not sure how much it helps the defense, that once a jury gets to the point where most of them agree, you don't really get holdouts for very long. It's the unusual case where you end up with somebody or 2 people who don't ultimately go with the majority. So maybe it doesn't make a difference, but I don't like it. I think particularly what surprises me in Utah, some states do it for lesser crimes, but they're doing this here for an aggravated murder. And I think at least for the more serious crimes, you should impanel 12.
I agree 100%. By the way, a lot of people are saying that it was Amy who was there for the shot video, taking the shots. I don't know. Look, different religions, different people.
Well, they're Mormons, aren't they? I mean, they're not supposed to be drinking at all, so the whole thing doesn't work for them.
Irish, not Irish. It's it just, when they played it, it was difficult with the kids there.
Yeah, it's
to see
terrible.
that soon after.
I mean, it's one thing to say you don't want to be visibly grieving maybe in front of young kids. It's another thing to say you want to be partying in front of them when they're told their father is gone and they're never going to see him again.
Yeah.
I don't like it.
So Lisa Darden was there. That is Kouri's mother. For those who do not know, Kouri's mother had a significant other, a woman who died under suspicious circumstances. Let's put it that way. Some people are saying the apple doesn't fall far from the tree. Just another interesting facet of the trial. But now, Joe Potuto, I don't know. I just found that rebuttal very powerful because it was literally predominantly in Kouri's words. And she herself says, to make sure I'm not convicted. It's like she has got a guilty conscience. Otherwise,
Yeah.
she wouldn't be speaking that way. I mean, do you think that the jurors are going to find it that powerful?
I hope so. I think so. You know, a lot of the things in this trial really underscore how much a prosecution can be limited by the evidence that's kept out. I mean, I talked about this before, but here's another example. The defense was allowed to say, you know, the letter wasn't even mailed. Well, and the state couldn't say, well, it wasn't mailed because they found it and seized it, and that's why it was not mailed. So, I mean, it's just the evidence that couldn't get in, which would have made this case so much more powerful for the state. And, you know, you get limited in some of them. So
what would you say right now is the most powerful evidence for the state?
let me think about that a little, because I think there's a lot of evidence in here.
And you heard, I mean...
Yeah, you know what I would say? And it may be something that nobody else would say. I think the 15 minutes in the bedroom where the phone is moving around after the time she said she went back to find him is really powerful. Because, and I heard the defense try to make an explanation, but the explanation was kind of silly to me. I mean, in the first place, I thought what the forensics people were able to show was where the phone was. And the prosecutor said, and, you know, we know phone calls were made, but I think that's what he said, or texts were made, but they've all been deleted. So we don't know, we don't know what they said. I think that's pretty powerful, because she said she went back from the boys' bedroom and then
Mr. Ramos
immediately
with defendant Kouri Richins.
And that evidence
as the 8 jurors were walking out and making their way, to the jury room, juror number 2 pulled Deputy Zag aside and handed him this note, and as she was handing it to him said, "I thought we were supposed to receive a factual stipulation before we got the case," or words to that effect. And the note says, "Factual stipulation, ?" How would you like to respond, if at all?
Yeah, it was an exhibit. When you were going to
865
is the exhibit.
It's regarding, I believe, the Burmester stipulation of fact that we had introduced to Your Honor.
But not read?
But not read.
Yeah.
May I direct them to it by number?
Yes.
I think that might be best.
Can we have a consensus about what the number is?
-65.
Can we confirm? We'll look at it together.
this is going to be a good jury. You can see.
Well, they're already taking it seriously.
And already remembered.
Katie, are you able to pull it up?
They were supposed to get something.
Joe, do we know what this is?
I don't recall what it is.
If you would mind plugging in, we'll look at it together.
I don't know if I have a digital copy of that. I think it was
Scott, if you wouldn't mind plugging in, we'll look at it together.
There you go. Maybe they'll put it up on the screen. They had a few factual stipulations over the course of the trial.
And we marked it with.
By the way, I think the judge's wife watches STS because he's wearing his wedding band today after I called him out.
Yeah. Let's see. It's among the things we're sending back. Yes, Brittany?
Yes.
Okay, so I will just do my usual question, factual stipulation, ? Answer. Please see State's Exhibit 8-65. Any objection, counsel?
No, Your Honor.
No objection. I had another question. Just in the event they want to view a physical piece of evidence.
Like the gummies?
Yeah, any of it. A phone. I don't know.
Yeah.
Miss Gibson has custody and control of them. She knows that we may need to alert her.
Okay.
If they need it. So
Got it.
if that's a question that comes up, we would just have to get to Chelsea and she can bring it over.
We'll keep you posted. Ms. Lewis, Ms. Nestor, Mr. Ramos, any objection?
No.
Okay, that's what we'll do. Now, I'm about to go off the record, but I need a lawyer from each side to stay with the Scott and Katie of your respective sides and reach consensus with Brittany about what's going into the jury room before you leave the courtroom.
Yes, sir.
Even if the lawyer doesn't do any talking, I just need you to stick
Thanks
around.
to Rhonda, this
Thank
first show.
Very good. We're off the record. Thank you.
It looked like that was simply a chain of custody issue.
It was regarding Megan Phillips,
Yeah.
who I'm not sure who that is, but it was, yeah, I don't know. I mean,
It sounded
Joe?
like it was labels and they wanted to show that it went into the evidence locker. Didn't seem like it was anything substantive.
It
but
seems
they were-
very, I mean, I don't want to downplay it. It seems like something rather minor for this one juror to be sort of obsessed about that. Or
Well, but the
it could-
jury didn't know what it was. She just knew she was, or he, that there was supposed to be a stipulation of fact that they would get.
Okay, so that
Right?
makes more sense. And
Yeah.
they don't know what it was. She just okay.
They don't know what
so-
it was.
Yeah, so then here you go, Lee, Tennessee. The jurors on the ball sure is.
Yeah.
For catching that, because I can assure you I would not have. But you can see now there is 13 minutes in here, and the judge said that he's going to let them go till it is 3:11 in Utah till 4:30. He'll let them go later, he said, but he wants to check in with them at 4:30. So that's in about an hour and 21 minutes.
Well, they're going to have to elect a jury foreman before they do anything else.
Yeah.
And that shouldn't take too long, but that's going to be their first step. I find it interesting that the defense frequently tells the jury, do us a favor and don't take an initial vote. Talk about it first. And it's interesting because I've heard defense lawyers say that frequently. And it always sounds to me as though they think if the initial vote is taken, it's going to go against them strongly. That they need the jury to talk.
Yeah. I'm looking at primetime KCL here. We now have 6 men,
And
2 women. This has been whittled down to an 8-person jury. And Joe, I don't know. I have a feeling that women, and STS Nation, feel free to chime in here, but I feel like women would be tougher on Kouri than men would be. What do you think, Joe?
Yeah, I do too, but I don't know whether that's simply a bias. But I do agree with you. I don't like, this is what Florida does also. 9, 10, 11, 12 here were the alternates, and in Florida, they know where you sit, or at least in Leon County, so that lawyers would know who the alternates are by where they sit. In New Jersey, they pull out of a hat to get the alternates, and I think that's a better way to do it because there's a risk that the jurors who are alternates will know because it's,
Yeah.
9, 10, 11, 12, so.
That's a good point. That's a good point. Maybe they need to just pick out of a hat. But you're saying it went according to a seating chart, but how did they figure out?
He said jurors 9, 10, 11, 12, and that's usually done by seats. Juror number 1 is usually the front. I can't do it because I can't do left and right without being in, it's usually the one closest to the judge in the first row turns out to be 1, and they do it that way. Sometimes they do it in terms of your preliminary, the number you got when you were first in the venere, so you could be juror 310. But that sounded like they renumbered them when they were in the box and gave them 1, 2, because it seems extraordinary that it's 9, 10, 11, 12. It just seems
Prime Time, who usually knows her thing, says it's the last
let's
4
see.
jurors chosen were the alternates.
Right. Right. But it does sound as though they renumber them because it's extraordinary that the last 4 jurors happen to be 9, 10, 11, 12.
Yeah.
Yeah.
Man, I'd be bummed to sit for 5. How many weeks was it? 3 weeks? 4 weeks?
Well, not only that, all the breaks and all the lengthy lawyer arguments when you weren't even hearing any testimony, and then you're bumped at the end. I wouldn't like it at all.
Now, Joe, when you hear a juror ask for that, fact sheet, whatever they were asking for, what is that?
Stipulation?
That obviously signals that they're really serious. Do really serious jurors generally favor a prosecution or favor a defense? What do you think? Or is there no?
I tend to think they're going to favor a defense because they're going to pay very close attention to the evidence. What that question demonstrated was that juror, at least, was paying very close attention to what happened at the trial. Yeah. So remembered that he or she was supposed to get a stipulation of facts and didn't know whether he or she got it. I mean, that's really extraordinary in terms of paying attention.
Oh, look at this. The Queen Anna here, men will vote not guilty. I don't know about that. But I don't know.
Well, but this case has a lot of money, finagling going on. And, if we're going to just go on stereotypes, it seems to me men might be more inclined to be critical of someone who is fiddling around with money, signing a wife that signs her husband's name. I mean, they may find her very, sympathetic for the murder, but on the other stuff, signing his name to, and effectively taking money from him, I think men might find that pretty offensive.
Yeah, Andrew agrees with you here. Is that Andrew? Yes. I think this is going to come back much sooner than later. Let's see here. One of the jurors is a lawyer. Can anyone confirm? I don't know how we would know that. I don't know that. I don't know if that is somehow gotten out there. Joe, have you heard that?
No, I have not. But I haven't heard any bios on any of the jurors. So.
Me neither. But lawyers get picked occasionally. Were you ever picked as a law professor for a jury?
No,
Joe?
I would have loved to have served on a jury, but I think the chances would have been less than zero.
I never get called. The only time I got called was when I lived in Washington, D.C., where there's no people and a lot of crime. So there's they call you constantly. And I still get jury summons, but I obviously don't live there anymore.
Well, I spent a whole day about a year and a half ago sitting down in Newark waiting and I didn't even get to the veneering. I mean, they went through all kinds of jurors. And so I never even got a chance to get up and tell them what I did and be struck. I never got that far.
Yeah. Well, we've been at it gavel to gavel. Now it is verdict watch. You're seeing here 20 minutes in. The jury's obviously, as Joe just said, they're going to go back. They're going to stretch their legs. They're going to have to vote on a jury four-person, and then they're probably going to take some sort of initial vote. We'll see how far apart, for them to see how far apart they are. And then they're going to get down to business.
Let me ask you, Joe. You asked me what I thought the most important piece of evidence it was. How about you?
I think, honestly, for me, being a broadcast news guy, I just feel like, and people are going to disagree with me on this, just because it's not, I mean, it's sort of prejudicial, but I would say like the 911 call and some of that body cam video to me really stood out as inauthentic and bordering on deceitful. So I think that's, I think that a lot of times it's what people can see, like what's tactile. I think that's going to be a problem. But I think there's, going back to Brad Bloodworth, when he brought up that, first of all, he brought this up in closings. He said, there is a ton of circumstantial evidence, not direct evidence, but he said generally people do not film themselves poisoning somebody. I thought that was a good point to make because for a jury, it brings it back home. But then he put up that, I don't know if you caught it, Joe, the graphic of the elephant.
The elephant, yeah.
Yeah, so that was a
Having
good graphic.
slammed the man into the wall.
So that was good, good circumstantial evidence.
And you notice that he did what you thought he needed to do. He confronted the idea that the Emmy hadn't, just said that the cause of death was undetermined. So he took care of that.
And then when you go to the financial side of it, with money being a motive and Eric sort of starting to catch on and taxes, tax season was coming up, all of these things combined. The fact that she deceived her best friend and basically,
and I don't know why the defense, I would not have denied that she was in money trouble. I mean, I would have conceded it and said, but that doesn't mean she's going to kill someone. And I don't know how it rang with you, but I don't think they're saying she would have had the money if a closing ever happened is going to resonate with any of the jurors. That's just a terrible story. She takes the money. She says, I'll hold the loan because you can't pay the entire deposit. She never registers the deed. So her friend has no way to confront creditors because they don't see any kind of prior interest in the real property. And then she takes a second loan on the house, and that's the one that ends up in the bankruptcy. I can't believe there's a juror that's going to accept the defense argument about that.
Yeah, look, Jeremy is a good example of a male juror from Minnesota, assuming Jeremy is male and not, like we have Ned Smith, who is a woman, but young, healthy man, kids, business, not depressed. And it's basically, what else is there to see here other than Kouri's guilty? I think some of the other men on this panel might be thinking the same thing. So, but we don't know. We don't know.
Well, you'll be able to interview them after the verdict.
Here's a great, Joe, here's a great point. If I can find it, wasn't thinking about this at all, but Joel, I think that the jury is going to take it very serious because it's 3 children involved. Now that, even though it's not an official burden of any sort, what about that, Joe Potuto, that there's 3 kids here? So the father is obviously dead. You convict the mother, you've taken away the mom now. So
yeah, but if I were on that jury, that would cut the other way with me.
Yeah,
because there's so much evidence that she's uncaring. Look at how she treated her lover.
Yeah,
her best friend, lying to everybody. All of that. I would say to myself, if I'm on the fence here, do I want to have these 3 kids go back to her to raise?
Yeah. And she took out insurance policies on the children, correct?
She did, which people in the chat think is a very kind of worrisome thing that she did.
Yeah, that's in the realm of a psychologist there. Would this woman have done this again? I'm no psychologist, but I'm starting to think maybe. I think because 3 kids are involved, they will take it extra seriously. Great point. That is what, Kelly, I think it was you who put that comment in. So thank you to Kelly for that. But I agree. It cuts both ways, because if the mother is a horrible person that shouldn't be around these kids, that's more reason to convict, which is maybe exactly the conversation that they're having. But what do you make in general? I mean, today Kouri was much more animated. She was making a lot of faces during closings. But what do you think of Kouri's kind of demeanor in general from beginning to end of this trial, Joe?
She did a lot. That's why I said I think Utah, or at least this judge, allow things in a courtroom that I haven't seen other judges do. She did a lot of making faces and indicating whether she thought whether she approved of what she was hearing or didn't. She stared down one witness. What I see of her is she can't not be the center of attention. And so she's sitting there and she wants everybody to know what she's thinking.
Yeah. This should have been called the mutton dressed up as lamb trial. Keep the comments coming. Thank you for that. Lots of faces today. Yeah, lots of faces. For the life of me, Joe Potuto, we have this conversation every single time. I just don't know what these people are thinking. She's not convicted yet, but assuming what the government laid out is the truth, and assuming that she's guilty for a moment, what are you thinking doing this? You're going to get caught.
Well, you don't think you're going to get caught. If you really thought you were going to get caught, presumably you'd do something else. I mean, I don't understand it, but I don't think you're going to get caught.
Yeah.
She apparently didn't think there'd be an autopsy. And if that's true, I don't know what world she lives in. A young, healthy man who's not under doctor's care dies suddenly.
And she wanted him cremated, and that was a whole issue. I mean, there's so many things here. I mean, the amount of circumstantial, there's a mountain of there's a Mount Everest of circumstantial evidence here. But
I thought Nestor looked like she was nearly in tears at the end.
Yeah.
Did you see her face at the end? I mean,
she and Wendy Lewis just have a very odd, to me, especially Wendy Lewis, just the delivery. It's almost like they're whining, coming from a guy that is known to whine here and there, but it's almost like they're whining and not speaking. It's hard for me to articulate more than that, but it's just an odd delivery.
Well, I think they are very, very committed defense lawyers who take their jobs very seriously.
Yeah.
I mean, I didn't like their styles. I didn't like a lot of what they did, but I think they really did a good job on the merits with the defense. But I do think that and I don't know, but it appears as though they get too close to a client, because it seemed to me that they really were a little more than just professionally representing somebody. It just sounded as though they, like Tara Kawas with Magbanoa, too close.
Yeah.
And I think maybe it's hard not to sometime, but I really think lawyers need to maintain a professional distance always.
Yeah. I personally, if I'm on trial, I want someone like a Tim Jansen. I want someone who's very persuasive, who's like a character, like an animated human being who can also really. I thought Bloodworth did a pretty good job, especially for a prosecutor, of connecting. I felt like he was connecting with the jurors.
Yeah.
I did not feel that way, the defense. But if I was ever in trouble, I would want someone who's not a storyteller in the sense of making things up, but someone who can really relate
Yes.
and communicate well with a jury.
Absolutely. I would tell students that their first job, if they were going to do trials, is to make the jury like them. Everything else comes after that. Obviously, you've got to put on a good case. You've got to know what the law is. You have to know how to organize facts, but you've got to make the jury like you. And it doesn't have to be, I mean, there are lots of different ways to do it. And I don't think anybody should do something that doesn't come naturally to them, because it comes off as insincere. And so Bloodworth, I don't think Bloodworth could be, sort of a sort of a companionable, he's somebody you'd want to go have a drink with. I don't think he could convey that to a jury, but I think you're absolutely right. His interactions and relationship with the jury was really very, very good.
Yeah, someone right here, Wendy Adelson, by the way. Next question mark. We're going to come back and do an Adelson show. It's been a long time. It has been very quiet. I don't think anyone really knows what is happening there or what is going to happen. I think it is anybody's guess at this point. I think the only real people who might know could be Jack Campbell, Sarah Dugan, and Georgia Kappelman. But we're going to come back and do a show about what could potentially break that case back open in order for a prosecution to maybe come sooner than later. Someone mentioned Joey Jackson as a defense attorney. If you know him, he's a CNN commentator. He's fantastic. That's the kind of person I'm talking about, who's just universally likable. That's who I want as a defense attorney.
Well, I want somebody who's likable, but I want somebody who really knows the law, really prepares well, and knows how to weave an argument, asks good questions, and listens to the answers.
Yeah, I agree 100%. So the big question now is, do they come back today? That seems very unlikely. It is.
Do you think they're going to leave at 4:30? My guess is they'll ask to stay a little longer.
I think they will too. I think that they definitely might ask.
You could come back with a verdict. Yeah, okay.
So,
I thought you meant they would want to go home.
No, it's 3:30 now. We're going to leave the stream up here. Joe, I just need to touch base with the COE for the 7 o'clock show. We are going to have a 7 p.m. show on Nancy Guthrie unless there's a verdict back, in which case Joe will be here. Joe, I don't know if you want to take some questions or if you want to take a break.
Yeah, if there are any, I'll do a few before I.
Okay, so Joe will take a few questions. I will pop back in here at 4:30, which is an hour from now, just to touch base with everyone prior to the 7 p.m. show here on the East Coast. So I'll pop back in 1 hour and check up on everybody. Joe, thank you as always. And I'll pop myself out and you can pop yourself out. But we'll leave the stream up. This is where we're going to hang for Verdict Watch, at least for today.
Yeah, okay. All right. Are there any questions? Because if not, I will go do my Italian homework, which I need to get done. But I'll stay and take questions if there are any. Okay. No, I don't want to go to sleep. I have work to do. Blue River. Okay. It's actually not that late here. It's only, what time is it here? Hang on. Oh, it's only 10:30 here. Oh, here's one. Lay Tien. In 2024, the Supreme Court justices requested the 6 states that have less than 12 criminal trial juries go back to 12 jurors. As explains they agree with me per Reuters. Well, I don't know what that means that the Supreme Court requested, because either the Supreme Court ordered and then the states have to do it, or there wasn't a majority. I'll have to see if I can figure out what that is. When the Supreme Court says the Constitution requires that you do X, then you have to do X, whether you're a state court or a federal court. Let me see if I can find out what that case is about. But thank you for letting me know, Leanne. Okay. Leo Wren. What part do I wish the prosecution emphasized more? Me, it was Eric's change of the state. You mean changing the setting up, putting his sister on the trust and that sort of thing? I think that was important. Let me think about this a little. I think I might have done more to demonstrate that there's nothing to show that he was using drugs before. I might have done a little more with that. I might have made fun of, they have to go back 20 years to when he was in high school and then he was using Sudafed. I would have done it on rebuttal so they wouldn't have had a chance to come back and say, well, there was a little more evidence than that. But I think, I just think they did a great job. So we're really nitpicking, or at least I feel I am. Okay, let's see. Let me see, is there anything over here? No, I don't see any questions. Okay, let's look. Is it grounds for appeal if a jury comes back very soon? No, it is not grounds for appeal if a jury comes back very soon. I had an aggravated assault case that was only not a murder because the bullet was a little to the left of where it would have needed to be to kill the person, but he was left a paraplegic. And that jury went in. I didn't have a chance to get back to the prosecutor's office, which was only across the street from the court. Well, actually, it was, it's a bridge, an enclosed bridge, and I had to get right back. They were only in the jury room for 4 minutes before they came back with a guilty verdict. So there's no grounds for appeal if they come back very quickly. And I ran into a few of them at lunch that day, and they wanted to know, they had some questions about what happened in the evidence. And they told me that what they did was they decided to take a preliminary vote before they started to deliberate. We're surprised to find at the preliminary vote that everybody said guilty. And they didn't do it this way. They did it with a paper ballot. So they was very surprised. And then they thought, well, we're done. So you can have a quick verdict on occasion. Well, Leo Wren wants to know the record. I don't know if anybody's recorded a record, but I think my 4 minutes has got to be up there. Looper said a whole 4 minutes. Yep, 4 minutes. And I don't know I don't remember if they had to elect a foreman or whether the first person, juror number 1, automatically became a foreman. I don't remember now how they did it. But yeah, 4 minutes and they were done. They stayed for lunch because they got a lunch voucher. So they decided they might as well have a free lunch on Essex County in New Jersey. But yeah, didn't take any time at all. Okay, anything else? I don't see any more questions. Let me see. No, and I'm going back quite a ways. And see over here. Nope, there's nothing. Okay, I'm going to turn this off and I will be back at 4:30 also to see what the jury wants to do. They may not even come out. They may just the judge may just send in a question. And so we won't even see them. That's what I would do. Here's a question. I'll take this one before we stop. If I were on the jury, what would you discuss the most with the rest of the day? Well, nothing insightful. I would start with murder 1 and go through the elements and see on a preliminary vote where people felt with regard to each of the elements. And then I do element by element of murder one. And then move on. Okay. I see yays and cheers, and I don't even know what they refer to. And I see blue hearts, and I don't know what blue hearts are either. Okay, that's it. For those of you who are going to come back to see if the jury wants to stay later or what's going on, I see you. Otherwise, I guess the next time I'll see you is if there's a jury question or a verdict. So long.
Hey, all, just checking in. It's Joel. It is 6:31 Eastern Standard Time, 4:31 Mountain Time, and the judge was going to give some sort of indication around now whether or not the jurors were planning to continue to deliberate or not. We have no way to know until we get some sort of word from the courtroom. Joe is back with us. Prop Joe explains, but I'm taking a live look behind us at the courtroom, or behind in the backstage area. I can see the courtroom. No sign of the judge yet. So, Joe, you're working on your Italian homework, which we should continue to probably work on. We're just gonna hang here for a little bit and see if we get some indication from the judge. Meanwhile, at 7:00, I'm going to be doing just more on Nancy Guthrie. There's some developments. We haven't done that story in a few days, and things change with that story from day to day. So we'll get you caught up on that. And then just so you know as well, Gigi McKelvey of Pretty Lies and Alibis, she is was in the courtroom today, and we will have her tomorrow at some point during the day. I'm going to be doing day shows, just so you all know, tomorrow and the next day, because my daughter is going to play at night. So I will be doing that. But we are continuing to monitor here, and going to stay here. I'm actually going to, let me check in here, which I should have done before coming on. Should have checked in with the COE to see if anything is shaken. Joe, how are you? Anything on your end?
In the last, hour? No.
Last
nothing
hour.
happened.
No, nothing. Yeah. Well, why don't we hang here? I'm going to hang here for a little while till the 7 p.m. show starts. Joe, feel free to do your homework as soon as the judge jumps in here, which he's supposed to do.
Right.
Any moment 3 minutes ago now.
Oh, well, no, we're just looking at the seal.
We're just looking at the seal here, but you can see the verdict clock's at 1 hour, 36 minutes and 5 seconds. So
I love verdict clocks. Maybe that's my favorite thing.
Yeah, verdict clocks.
I could find myself just sitting and watching it.
Yeah, they're mesmerizing.
Yes.
So here we are. I will.
I don't know why they're not done. I mean, then we can go on and do other things with our lives. They're not very cooperative. They're actually working.
They are working. They're going through the evidence, and there's a lot to go through. I'm gonna.
Yeah, there is.
Yeah. Joe, I don't think there's. I mean, I don't. How do we know when the jury goes home? Well, that's a question here, and that's what we're exactly what we're waiting on. The judge was supposed to come on right around now to let everyone know whether or not they're going to stay late. He said that he would give them, he'd give them the choice. If they want to work late, they could work late tonight. I don't know how late that means. But if there is a verdict tonight, it will be on this link. And keep in mind, we're on the East Coast. I'm on the East Coast. Joe's on the far East coast of Italy, far East. But here we are going by Mountain Time, which is in Utah. So there it is, only 4:35 in the afternoon.
Yeah, I don't know how. There was a question about how late the judge would let them go.
Yeah.
I don't know. I mean, they're court personnel and people who want to go home from work. So I think that might be the outside time limit that the judge would want to give. It isn't as though the jury can just sit there. They've got to keep the courthouse open. They've got to have bailiffs there and other kinds of personnel.
Yeah. If let's see here, if the judge says the jury wants to stay later, is that a sign that they're getting close? What do you think, Joe?
Well, often it is, but I doubt it since it's only been an hour or so, and it's the first day. But once a jury deliberates for a while, if they say they want to stay later, that's often a sign that they think they're close and they can be done. But I would be really surprised if that's the case here.
All right. Well, let's. I need to touch base with the COE about the next show. So I'm gonna have this up. I'm just gonna bounce myself out. If I hear the judge come in before the show starts, either way, I'll pop back in. But we're just waiting on the judge now.
And I'll wait a little.
Okay.
Just to see. Okay.
Oh, okay. Sounds good. Thanks, Joe. And if we do get word from the judge.
Hey, but before you go off, did you see Gigi? She posted the outside of the courthouse.
No, I did not see that.
It's really very small.
Oh, really?
I was surprised, yeah. She showed the background of, the mountains, the snow-covered mountains, but boy, the courthouse is not very big.
Yeah, it's tiny. It's a small, rural county, but all righty. So here we are. We're still on Verdict Watch, and Joe, stick around. I'll be back in a few minutes. I think.
Okay. So I don't see any questions from anybody either. So I will sit here for a little while, but if you have questions, post them. Let me see what's over here. But please put 5 or 6 question marks because there's a question about what Joel and my verdicts would be. Joel said clearly that he thinks it's guilty, and it would come in quickly. Let's see. Here's one from, I can see McClellan, but it's hard for me to see the first name. Kelly McClellan. Okay, you already answered that. If they're getting close, if they want to stay, does that mean that the jury's getting close? So we already really talked about that. Let's see if there are any others. I see there's a gift to STS. I think it is because it's blue, but I can't see what it is. I'm sorry. This is just too tiny. Why was the police officer? Oh, it wait a minute. See if I can get this out of the way so I can read it. Nope, it won't go out of the way. Sorry, I can't get here. Maybe I can find it. Here it is. Why was the police officer allowed to view the court case when other witnesses were not? He already knew the case because he was the lead investigator, and I think he had reviewed the files and the testimony of most of the people who testified, so there wasn't going to be anything that was a surprise to him. And I believe that the defense agreed that he could sit in the courtroom and watch the testimony. Okay, let's see. I don't know what that is. Let's see. These questions just go by so fast. Let's see. Why is it okay for the defense to use statements out of context? Well, the prosecutor can also, but it doesn't usually help the prosecutor. It can help the defense. The jury has to decide what the facts are, and if a lawyer wants to get up there and take statements out of context, the jury has its memory, and the prosecutor may well correct. Do I think the prosecutor was better in the initial or the rebuttal? He was doing different things, but I like the initial better because it was so well organized and it was so interspersed with, the evidence that I really thought it went really well. What did you think, PKYCSEN? All right, let's see what else is over here. What did I think about the defense attorney's closing argument? I thought it was good. I mean, as I said earlier today, she had a different role than the prosecutor. The prosecutor had to show, hey, here's the evidence that proves the guilt. And I'm going to organize it so you can see that we met our burden on every count and on every element in every count. The defense didn't have any, that wasn't the defense's job at all. The defense was trying to say the state did not meet its burden, and it did not want to go through it in a consistent, logical order, because that might not have helped. That might have helped the state actually, and certainly probably wouldn't have helped the defense. She wanted to do what she did, go after a lot of different things and more of a scattershot approach. But it was tactical. I think she's perfectly capable of doing an organized recitation. But on the defense side, that was tactical to say, I'm going to show you what all these witnesses said and why you shouldn't believe them and why there isn't enough evidence. So, let me see what else. So if you haven't seen Gigi Pretty Lies and Alibis, who's in Utah, you heard Joel say that earlier, and she's going to be on with him at sometime tomorrow. She took up, you probably heard me say to him, a shot of the courthouse and the background, the Utah, the mountains. And the courthouse is really small. I'm surprised how small it is. I wonder if it's got more than one courtroom in there. Okay, let's see. An educated guess on what evidence they could have been seeking as recently as February. That was odd to me. I think there were, what happens sometimes is they get some evidence and then they want to go back and relook. And so I don't know what they would be looking at in February. I can't give you an educated guess. I don't know what might have sent them back, but it's probably more likely forensics, something like that. Let's see. When the defense asked for, let's see, I had that in a minute. When the defense asked for, it keeps jumping on me, sorry. When the defense, I can't do it, it keeps jumping, sorry. I was trying to read it, but it's jumping on my screen and I can't keep it going. Okay, here's a question over here. Okay, Susan D78 said her favorite witnesses were the private investigator, the forensic accountant, Chelsea, and the boyfriend, and asked me what mine were. I really liked the forensic accountant a lot. I really thought she was just really well prepared and did a really fine job. I thought the Emmy who didn't actually he was the Emmy and then he retired, and the Emmy who actually was responsible for this autopsy took over. I thought he was very good also. I agree with you that Chelsea was a really good witness. She really brought to, put a lot of light on how really cruel Kouri had been. And I think maybe Cody Wright, because I thought he came across as so honest that I really appreciated his testimony. Okay. I don't know that those were the most important witnesses, but those are the ones that I really liked. Why did the defense attorneys try so adamantly to keep Kouri's incarceration from the jury? Mostly defense lawyers don't want that information known. The feeling is that if you know somebody's been incarcerated prior to trial, it might affect the jury's ability to evaluate guilt based on the evidence at trial. It may prejudice them to be inclined to find the defendant guilty. So you're not permitted to talk about a defendant being incarcerated. I mean, some of them are not. Not everybody's incarcerated pre-trial. That's why they come in regular street clothes. They don't come in prison garb. So why were the jurors not allowed? Oh, that was the question I just answered. So if Kouri is found guilty, how would she what for an appeal? How would she pay for an appeal, attorney? Well, she's entitled to the state paying for a defense lawyer for her on her first appeal as of right. So that would be the appeal to the appellate court in Utah. There's no constitutional obligation that the state pay for a second appeal. That is, if she loses at the intermediate appellate court, and she wants to try with the Supreme Court of Utah, there's no constitutional obligation that a lawyer be paid for her that second time. Utah may do it as a matter of state law, but there's no federal constitutional right to it. Thank you, C. Baby. Oh, cappuccino. So it's not gelato or espresso or even Prosecco. We're now on to cappuccino. We're going to run through all the food in the Italian world. And that's a lot of food. Okay. Okay, Leo Wren wants to know if the defense stated reasonable doubt correctly. Yeah, she was right about reasonable doubt. She used it a couple of times incorrectly with regard to particular witnesses. But the general reasonable doubt standard she was right about. Is it normal to bring a defendant's parents' character into a trial? I thought it a bit odd. You know, nothing is necessarily normal in a criminal trial. It depends on what the particular prosecutor believes will be helpful and what the defense believes will be helpful. But you don't normally hear about parents. But you don't typically have a parent who defense lawyers thought needed a defense lawyer for this trial. Measy 1991, what do I think about Kouri's mom? She never consoled her daughter the night of Eric's death, just acted weird. Well, if you recall what the defense lawyer, what Lewis started out saying about Kouri, she talked about her childhood and talked about her mother spending more time, I think, gambling and not really paying attention to her daughter. Okay. Kathy Slocum. Are juries ever sequestered after instructions and closing arguments? They are in Canada. I don't know that it would be impossible, but no. Juries are sometimes sequestered for the whole trial in the United States. But if they haven't been sequestered during the trial, it would be really exceptional for them to then be sequestered when they deliberate. It would have to be something, really unusual that was brought to the judge's attention, in terms of what might be occurring outside the courtroom that might lead to it, but certainly not routine. K-Tail wants to know if I think Nestor would have been better at closing. I don't know. I wasn't paying enough attention to the differences between them to be able to answer that. If this is a mistrial, would Nestor and Lewis be obligated to defend her again? I assume you mean if this goes to a hung jury, because I don't know that anything that could happen. Well, something could happen with maybe juror misbehavior, juror tampering that comes to light. But what's much more likely, if anything, is it would be a hung jury or even an appeal, a conviction, an appeal, and a retrial. There's no obligation that the same lawyers represent a defendant the next time around, or even that the prosecutor who did this case would do it again. Okay, how much time is she looking at for the financial crimes? I don't know. I haven't looked at Utah law to see what the maximum sentence for each of those crimes is. Brendib, thank you. $20. Very, very nice. You lived in Sicily for 5 years. If you get a chance, go down to Noto and have the best gelato ever. In fact, I've been to Noto. I spent 6 weeks in Cefalo, and I have been to Noto. So I have sampled the gelato there. Would Kouri have to fight to get custody if found not guilty? That's family law. And so I am hardly the one, an expert on family law, much less family law in Utah. So I would just be guessing. But she's got the other trial in front of her for all the financial crimes. So I don't know whether the family court would want to move custody of the children back to her when she's facing another big trial and may have a custodial sentence if she's found guilty. And that one. Okay. There's another question, I don't know, Denise M. I don't even know if Utah has sentencing guidelines or it's discretionary in the judge. I'm guessing maybe Utah does, but I don't know Utah law and I haven't looked, so I can't answer that. Okay. We don't know. Well, California avocado, we don't know whether the jury decided to stay late. What I'm guessing is since it's 10 to 5 New York, no, 10 to 6 New York time, and 10 to 4 in Utah, that the judge may have just inquired of the jury without coming out on the bench to do it. So we're not going to see anything at all. So I'll wait another 5 or 10 minutes, but my guess is there's been a decision. We just don't know what it is because it wasn't done in open court on the bench. if somebody is there in the courtroom, that person could ask one of the bailiffs or someone what happened, but we don't know. Okay. How long am I staying in Italy? For another 3 weeks. Okay. Do I think she has any appellate issues to overturn if convicted? Well, I don't know whether it would be reversed, but I know there are appellate issues she will bring. She's going to challenge the fact that any of the financial crimes were introduced into evidence at this trial. She had raised the issue of the private investigator acting as an agent for the state, and therefore evidence should have been suppressed. I don't know if they tried to do that before trial. You can do what's called an interlocutory appeal and get some pretrial, very, very small number might be heard pretrial, and I don't know if that happened, but if not, she'll certainly raise that. Let's see. She may raise the issue that she tried to get in after the defense closed, and that is that she should have been entitled to a jury instruction about that pill bottle that wasn't available anymore, that would say that the jury could infer from that the pill bottle, if it had not been lost, would have been evidence favorable to the defense. So that may be another one that she raises. Would I like to share any Italian words that I learned from homework today? I didn't learn any from homework today. At least I don't think so. We're doing verbs. You don't want to hear verb endings. Okay. Okay, so I saw that one already. Is it already 4:52 in Utah? Utah is 2 hours earlier than New York time. So what time is it in New York right now? Is it 11:53? Is it 6:53 in New York? Yeah, then it would be 4:53 in Utah. Thank you. I think it's the COE, but somebody is doing math faster than I. But my defense is first I have to translate it Italy time into New York time, and then New York time into Utah time. So I had to do one more calculation. That's my defense for being slow.
I'm back for a sec here, Joe. So I know you're just trying to calculate 4:53, and no word yet from the judge. So
my guess is they didn't go into open court, that he asked the jury and got an answer. So there's an answer, but he didn't come out in front and do it on the record, because there wouldn't really be any need to do that. So I think he knows, we don't.
Yeah, I think if they ended deliberations, he probably would have come and told us that.
You think so?
You know what? I think maybe. Let me. I'm gonna try to shoot Gigi a text.
Yeah, she would. She's still there. She would be able to answer, and she may know what the answer was from the jury, because they're going to be court personnel and bailiffs around. Somebody around the courtroom knows the answer to this, in addition to the judge.
Yeah. My issue is we're going to start a Nancy Guthrie show in 5 minutes. Okay, so Gigi says, as far as they know, as far as anyone knows, they are still deliberating.
Okay. Well, you better go do your show.
Yeah. The COE knows. I'm going to leave this up, and I'm going to leave this running. Anyone who cares to get an update on Nancy Guthrie, we're doing that on a separate stream. We're going to start that momentarily. If there's a verdict, I'll cut into that and come back here. So
I'm guessing that the sheriff is being the sheriff again.
Yes, there's some of that going on. Yes, some of that is happening. So, Joe, it's the world is your oyster. Feel free to hang, whatever you want to do.
I'll stay a couple more minutes, and then I've got it on, and so I'll listen. If anything happens, I can get back on right away.
Okay, sounds great. Okay. Appreciate it. The COE letting us know the stream is staying up until jurors go home for the night. So the COE will be monitoring this. I'll be doing the Nancy Guthrie show. If we get a verdict, I'll be back. Thank you
Okay.
all for being here, and Joe, thank you.
Sure. Okay, I don't see any more questions either. No, I don't see anything. So I think probably everybody is questioned out. Oh, here's one. How much is an espresso these days in Italy? 2.5 euro, 3.5 euro, somewhere in there. At a cafe, at a cafe. Might be a little more in a restaurant, but 2.5 to 3.5 euro, I think is about right. Okay. When does court, what is that question? Close tonight. We don't know. That's the $1 million question. We don't know because it's up to the jury and the judge didn't come out and tell us what was decided. I think I got everything unless something comes up. I don't see anything else. Okay, I'm going to turn off the screen here too. If I hear something in the next while, I'll come back on. But I don't think the judge is going to come out and tell us what the jury decided. And I'm guessing no one will come out and say, hey, no more tonight, they'll be back tomorrow. But that's pure guess.
Hi, everyone. It's the COE. I just want to remind you guys that we are going to keep this stream up tonight until jurors go home for the evening. And once they do that, then we'll end the stream. We also have another stream going live right now in a couple of minutes. It's at 7 p.m. Eastern time. So that's, again, in 2 minutes with Joel and Best Guests. And they are going to be discussing Nancy Guthrie. We're going to split up our team, and we're both going to be watching both streams. So if you happen to watch the other show, you won't miss anything since we're also watching this. We're also in touch with Gigi McKelvey, who is there in Utah on the ground in the courtroom. So we'll keep you guys updated as information comes in. Thanks so much for being here. Please remember to hit like, subscribe. And if you need me, flag me. I'll be monitoring both behind the scenes. Thanks, everyone.
for somebody or something. But who knows? Verdict is in. All we need to do is wait for the judge, wait for the lawyers to get over there. A quick verdict usually means a guilty verdict. For somebody or something. Well, Joel should be very pleased with himself for being able to call this one so well. But I had Donna Adelson. I didn't think Donna Adelson's was going to go very long, and I think everyone that time thought it was going to go longer. But this one, I really thought they were going to have to wrestle with the reasonable doubt piece, at least for a little while. But I guess they were able to, I know they were able to just get right through. And if it's as guilty verdict as I suspect, in some ways, it's a real tribute to the prosecutor in the closing and the rebuttal, because he did a really terrific job. Any questions on the chats? I don't see anything up over here. Let me put comments up over here and see. Okay, now I see they're still tiny, but I see them. Let's see. Okay. I don't see any questions. Well, if it's a guilty verdict, I wonder if they will set the sentence. They should set the sentencing date right now. Usually there's a pre-sentence report that's ordered, and I should have looked and I didn't, so I apologize as to what the maximum sentence is for aggravated murder in Utah. I believe it's life without parole, but I didn't double check, so don't hold me to that. Somebody may know who's on the chat. Is anybody in Utah and can tell us? So Pretty Lies and Alibis picked the right day to get out to Utah, because she's there to hear. She heard the closings, but she's also going to be there to hear the verdict. Okay. How long was deliberation? Well, we don't have the clock up right now. I know when we started, I didn't write it down because Space Coke had the clock going. I hope they put the clock up again. I love that clock. But it wasn't very long, because what time is it now? They came in a few minutes ago, and it's so it was about maybe at the latest 6 o'clock Utah time, and they went out at what? Well, we're going to have to wait for our clock to come in. All right. 2 hours, 57 minutes, and 44 seconds, we believe. Thank you. Who gave me that? It was Clove, and also Ike WLU said the same thing. Official verdict from Amber. Thank you very much, Amber. 2 hours, 56 minutes, and 24 seconds. Every trial I've done commenting on, none of them have gone 3 hours to get to a verdict. I really do think I must be a good luck talisman of some sort, that the juries come in right away. Okay, what's the next trial? I'm going to have to think about that a little. There are several coming up, but I don't know what the scheduling is on them. So I'm going to have to look. Which one would you like to see covered? The one I would really like to do, it looks like either will end up settling, or the judge will dismiss most of it. But in any event, it's not being televised, and that's the civil trial of Blake Lively and Justin Baldoni. That is really one that I would like to, not criminal, but would be nice to take a break from all these people who think the way to solve things is to kill their spouse or their children. Stella Isabella thinks I am a good luck charm. Let's not get ahead of ourselves. This might be an acquittal for all we know, although I really doubt it. So now the question that I have actually is, whether they will go ahead and prosecute her for the financial crimes. I mean, in one sense, it seems to be, not needed now because they've got the conviction of the graders. On the other hand, if by any chance these verdicts, assuming it's a guilty verdict and we don't know for sure, are reversed on appeal, the statute of limitations on the others may run, and it may be something that we really do need to say, to have in the, sort of in the background. So they may go ahead with the financial crimes trials. So Nate said 420. Yeah, that's right. That's what we have up on the screen. If you've got the screen that STS is running, that I'm joining in on, it says verdict reach will be read at 6:20 Mountain Time, which is 8:20 Eastern Time. So here we are. So those of you who stuck around and decided not to go off and do something else have been rewarded. So interesting. Okay, here's a question. While we wait, would I recommend a couple cases to go back and watch? She's been following since Donna's trial, just watched Sarah Boone. I've done both parents' re-school shooting. If you didn't watch Charlie Adelson's trial, if you did Donna's and not Charlie's, you may well want to go back and look at Charlie's. That was a very interesting trial. And his appeals are coming. His appeals should be, the oral argument was heard. So I don't know how much longer before there will be, where there'll be a decision, appellate decision, but there's a conflict of interest in that case. So they're going to be going on to federal collateral attack. So you might want to watch that. And if you watch Donna's, you already have some great background on it. I've only been covering them for, a much shorter period of time, but I think Donna's would be worth watching. Trying to think of, if you didn't watch Canero was interesting, I thought, but Canero, like this one, had a lot of, sort of delays in it, and so it's it's harder to watch, I would say. Then I don't know that anybody have any suggestions about cases that were tried? I didn't watch Karen Reed. I deliberately didn't watch it, so I can't say yes or no about the Karen Reed trial. So that's my best effort to you. You did this. Okay, Joel's coming on now, and he's going to be justly proud of himself because he called it. Although he didn't say tonight, but on the other hand, we didn't know that the jury was going to decide not to go home to stay after dinner. So, okay, so the 7 p.m. show is over. Great. He's going to have to remember which trial he's coming back to. This switching back and forth can't be easy.
Joe Potuto.
So it looked like you called it.
9 minutes, and I hate to say I called it, but I called it. We'll see.
Yeah.
It would obviously be the shock of all shocks if it came back at any sort of acquittal here.
I've been patting myself on the back because I said ever since I've commented on these trials, none of the verdicts have taken more than 3 hours. They've all come in quickly. So I mean, I should do all these. We could get them done quickly.
It's funny. There was a trial that we just had that was a couple of days. Now I can't even remember what it was, but I don't think we covered it. But it was a big case. Maybe we did. The COE might remember, but I can't even remember.
I don't know. The one that I did that you were doing, I think the other one was Canero, which didn't take very long.
What were we doing? You did Canero, and you
did Brandon. What started with a B?
Oh yeah, Banfield, but they took a day or two, I think.
Well, I'm the good luck charm. They come in right away.
Yeah, Canero though was pretty. That was a pretty obvious one. Didn't take much.
That's right.
Thank you to Kelly, by the way. Thank you for the super chats here and the super stickers. So, as you guys all know by now, and thank you if you're joining us from. We just did a quick show on Nancy Guthrie to update everybody. Yeah, it's hard to believe, but it is day 44 there the search for Nancy Guthrie, or the recovery. But here in exactly 7 minutes, apparently, they're going to read the verdict.
Yeah.
Joe Potuto, we have only been on verdict watch for how long? Do you know?
2 hours, about 46 minutes and a few seconds.
Yeah, 2 hours and 4. That would be shorter than the Charlie Adelson verdict or the Don Adelson verdict, just to put it into perspective.
That's true. You're right.
You
And they
know?
had a meal here too. I was going to say, but the other two had a meal, but they had a meal here too. So
Yeah, and that's with the meal. So this is really quick. I think, Joe, you know, when we are covering the cases, you start to analyze, and then you start to,
Too much,
you start to think a little bit too much. But I think the
Right.
jurors really saw this, and this is going to be a big credit if we are assuming it is going to be a guilty here, which is what it sure smells like. But this
Right.
will be huge credit to Brad Bloodworth, who
Bloodworth.
he did a great job.
I agree
thought,
with you.
laying out the closing here. I mean, he did a great job overall. He's not the most charismatic figure, but he was definitely good in terms of putting it all together at the end. Do you think that's part of what's sealing the deal here, maybe?
I think so. I mean, I think he really tied what could have been a lot of, I mean, there was so much information that came in. I think he did a great job of tying it all together. And I liked his style. It was clear, it was crisp. You know, there was no, it was really, what was he, Navy, Marine, whatever? I mean, it was the military that seemed to come out. It was really, you know, no playing around. Let's just get to it.
Here we go from Nana KC. I forgot to bring this up earlier, I think, but when the defense insinuated Eric was a druggie due to taking naltrexone, that was so dishonest. It's also for autoimmune, and he had Lyme disease. And just the way she put that out there was also, I don't know, you know, she's like, I'm not going to say he's a drug addict, but and I think jurors, you know, they read through that. They're not going to convict on that alone, but I certainly don't think that helped in terms of likability points.
No, well, they also did that where they insinuated that he and his best friend were having a, you know, a love affair, which, you know, seemed to me to go, you know, it not only was going after a victim, but was going after a victim purposelessly because it had nothing to do with any of the elements of any of the crimes. It was just gratuitous.
Thank you to Marianne Nardozzi here. Appreciate that. And again, we are time is crawling now because we're waiting a verdict in just about 5 minutes. Joe Potuto, what do you think, if anything, is going on in the mind of Kouri Richins right now?
I don't know. I mean, your mother might be better at putting her head into the mind of somebody who's did what she did. I don't know. If anything, I think she feels she's being victimized.
Yeah, you're probably right about that. And she'll convince herself, and that'll be a real feeling. I doubt he was having an affair with his best friend. She really.
It was, and that's not to say. I mean, I wasn't making any, you know, any claims about gay, but to introduce something like that when there's no evidence at all, it's just really, you know.
And I think Bloodworth's stock went up quite a bit. There are people here who are
now like him,
appreciating it. Yeah, I absolutely expected a verdict this evening, Cindy Beach, and you are getting one. People are asking already what our next trial is. I'm going to cover Courtney Clenny because it's here in Miami. That is toward the mid to end of April, so it gives us a little bit of breathing room. We've been going pretty much steady since the Nick Reiner story in December. It seems like nonstop since then. But one of the interesting things, Joe, is I was just doing a show with 2 retired Pima County law enforcement officers.
One of them I know, Bob Prager.
Oh yeah. So Bob was on, and then Phil Ramos, but they were talking about sort of the agony it is, which you don't think about, but the agony that they experienced as detectives waiting for verdicts.
Yeah. Well, you saw O'Driscoll in court when the defense lawyer was going after how bad the job was. the camera at least panned him a couple of times, and he was not a happy camper there. Well, if you care about your job, then you're invested in what happens.
Yeah, for sure. Space Coast, I think, is just refreshing the feed here. We are expecting a verdict in about 2 minutes. Judge Richard Mrazek will come out, and every little jurisdiction does things their own way. I don't know if he's reading it, if there's a court officer, if there's a jury foreperson. You have any idea how it's done here in Summit County?
No, I don't. I
Yeah.
don't.
And it's late in Italy. Joe is joining us from Italy, so thank you, Joe. For did you get your homework done by any chance?
I did. I never don't do my homework. So
does your teacher know you were a law professor?
Yes.
Yes.
My teacher spent a few years being an actress in Italy, but before that, her in Europe, the law degree is an undergraduate degree, unlike the States.
Yeah.
And her undergraduate baccalaureate was law.
Ah, so you have that in common. Does she take it easy on you, or is she tougher on you?
I don't like teachers who take it easy on students, and so I have been very clear. And I don't like anybody, I'm not, you get an award for participation. I don't want anybody to say, gee, you did so well with this assignment when I know I didn't.
Are you learning? Are you learning Italian now, or are you going beyond that? Are you like doing
No, I'm learning it. I'm never going to be good at it. I'm learning it.
Okay. So you're like, because you've gone, I mean, you're going up in classes? Like what level are you at right now?
Level 3. And I thought that wasn't bad, but then, YouTube, you can go on and look at those language classes. And I looked at what level 1 English is, if you were learning English, and level 2 English and level 3 English. And I'm telling you, level 3 English, I think a 4th grader could do. So that's where I am in Italian, and I'm not even good at level 3.
Well, I'll tell you, my kids are in 1st grade, 4th grade, and 6th grade, and I'm barely able to help them with their homework, and it's just going to go downhill from here. Someone's asking if the COE thought the verdict would be this quick. Now, they're supposed to be back right now, everyone, at 20 after the hour.
Well, this judge has never been quite on time. He's always 2 or 3 minutes late, 5 minutes late, 8 minutes late.
Well, he's definitely not going to be right on time. STS poll closing in 30 seconds. COE, how do we know what the poll is? I want to be
what
involved.
are we voting for? Oh, what the verdict will be? Okay.
Quick verdict leaning towards any prediction. I'm leaning towards 1,000% guilty in a record time.
Me too.
If this was an acquittal this fast, I would be
shocked.
Stunned. Yeah.
Yeah, I agree.
Any of those things. They're always bittersweet. I mean, you don't get Eric back, and now these kids are losing their mother likely forever. It is hard to conceive.
Yeah, I don't, you know what? If it's guilty, so she did what they say she did. I know it's terrible to lose a mother, but I think in the long run, they are better off being raised by one of their aunts.
Joe, love that you're learning a language. I'm doing Korean right now.
Oh, wow.
That's a whole other level.
That's right.
Good day from Australia. We are the future. It is Tuesday morning there. Justice for Eric, the boys, and the family. And thank you, Debbie. I would just like to learn Spanish since I live in Miami and my wife speaks it. My kids should speak it, but they don't. But it's tough. I'm not good with language. My mother speaks 6 languages, Joe.
Yeah, I don't have any ear for it. But I learned the other day that I think Italian is the 6th most studied language in the world, which is really extraordinary because it's a small country and it isn't like Spanish where there are lots of countries that speak Spanish.
Yeah. Joe, by the way, this just back to the kids for a minute. In general, will she lose like visitation rights to her children?
Yeah, that's family law, and I'm not an expert by any means in family law. And then family law, like other subjects law, varies state by state. So I don't know whether she'll lose visitation. She certainly can't have custody, but they may require that the children be taken to see her. I don't think that would be extraordinary.
Hmm.
But I don't know. Somebody in the chat may know family law.
That would not be me.
Certainly
I know.
not me.
Yeah. Again, we are waiting for the judge. There has been a verdict reached in the Kouri Richins trial. It's supposed to be read 3 minutes ago. So we are a little bit behind schedule here, but we will bring you the verdict as soon as we get it live here on Surviving the Survivor. Bear with us as we wait with you for the judge to appear, for the jurors to enter the courtroom, and that should happen relatively quickly. The jurors asked, there was a check-in at 4:30 local time. It's now 6:30 local time, and at that point at 4:30, they asked to stay a little bit longer. Apparently they had dinner, and after dinner said that they have already arrived at a verdict. Again, Joe, what's interesting, this is an 8-panel jury, not the traditional 12-panel jury. And I think it's easier, or so I've been told from attorneys, to persuade 8, obviously, than it is to persuade 12. So let's say if you had a single holdout, those 7 people have a better shot, I guess, of coaxing that other holdout, the lone holdout, into voting in their direction. So I don't know your thoughts on that.
Yeah, my guess is they didn't have a holdout. If I had to guess what happened, well, it's only a guess, but my guess would be they took an initial vote and found they were pretty much all in the same place.
I would have to agree. I think that is likely what happened, and we're continuing to wait here. I'm just trying to simultaneously, a lot of times people say, hey, this guy is not paying attention. I am paying attention. I'm just doing a couple different things, like trying to get with the COE here just to make sure we are good. COE, give me a sign of life. Are we good here, COE? We're just waiting, correct?
This verdict in some ways was even faster than the Adelsons, because they had to go through the financial crimes also.
Yeah.
Which were different. I mean, if you think of Adelson, it was murder, conspiracy to commit murder, solicitation of murder, but essentially they were all the same thing. Here, they had to jump over and evaluate the financial crimes. So in a way, this is even faster than those verdicts.
Yeah. This is a harrowing time for the attorneys on both sides. I'm sure, and this is pun intended, Brad Bloodworth is smelling blood out there, and he's probably salivating, waiting to get in. But what about the flip side here with Kathy Nestor and company? They've got to know that they're probably coming in for a pretty big defeat, and that can't be too. Do you think they're counseling Kouri right now, and maybe preparing
I
her
was
for
just
that?
wondering. Yeah, I was just wondering whether they were meeting with her right now to get her ready.
How does that generally work? Will the judge allow? Is that the sort of thing where the judge will allow counsel to maybe speak to her and say, "Hey, this happened really quick. This is probably not looking great for us," just to give some sort of advance warning? Because we saw with Donna Adelson, she just lost her marbles. She was basically unable to get through the reading of the verdict, and the judge had to admonish her not to. Not to have any outbursts. Obviously, this judge is a different sort of judge, much more patient. But do you think that they're maybe preparing her for a soft landing here?
I think it varies with the judge, but I would not at all be surprised if they are sitting and talking to her now. It's I don't know that I would say humane, but it's a kind thing to do, to let them have a chance to talk to their client when they're coming in for the verdict.
Joe, I know I bring this up all the time, and I'm a broken record, but and I've asked you this, and I'm a broken record with you also. But how do you prepare for prison for the rest of your life, Joe Potuto?
I hope to never know.
I hope. To
I don't know.
either.
I'm sure that the first maybe month, 6 weeks, somewhere in there is extraordinarily difficult. And I don't know how you prepare for it. I mean, there's nothing like it on the outside. Now, on the other hand, she's been in jail for the last, year and a half. So the routine of being, not having any autonomy, and having to meet somebody else's schedule and being in a small cell and having to interact with people that you maybe have nothing in common with except they committed a crime too, that she's already inured herself to because she's been living it for a year and a half. So I suppose that makes it a little easier. Yes. But I don't know what you say to yourself. For the rest of my life, I'm never going to be in charge of my own life.
Yeah, whatever you've done in your life, you'll never be able to. I mean, from the smallest things like running out to get a ice cold bottle of Coca-Cola, you'll never do that. You will never run to 7-Eleven. Gigi says Kouri is visibly shaken. This is Gigi McKelvey. Shout out to Pretty Lies and Alibis. She says Kouri is visibly shaking. They're waiting on Richens' family to arrive. Everyone is supposed to be within, close proximity.
That's kind of the judge to wait until Eric's family gets there.
Now, Joe, you see where my brain goes. I'm thinking about Coca-Cola. You'll never have a Reese's peanut butter cup ever. Well, maybe in commissary you will.
You're never going to have a pizza, a gelato.
You're never going to walk on a beach and feel the sand between your toes again, Joe Potuto.
No. Well, worse than all of that, you're never going to have autonomy. You're never going to be able to make your own choices. You're always going to have to be at the orders or at the decisions of someone else. I mean, I can't imagine anything worse.
And she is young. Here's the judge. We see
Here's
his head.
Judge.
She's only 35 years old. This is a literal lifetime ahead of her of this. No Twizzlers.
Back on the record in 231-500-139, State of Utah versus Kouri Richins.
She's got a
counsel for the state and the defendant are present. Ms. Richins is present as well. The court is informed that the jury has reached a verdict. I do not know what it is. We'll invite the jury in a moment.
Thank you, Matthew.
When I do, I'll ask the foreperson a simple yes or no question. Have you reached a unanimous verdict? I expect that person will say yes. I'll ask them to hand the verdict to the bailiff, hand it to me. I will read the verdict. This brings me to important instruction number 1.
Can't leave the court.
There can be no outward reactions whatsoever to the verdict. These folks are here against their will. They, all the lawyers, Ms. Richins, every attendee, my court staff, the bailiffs, everybody deserves your respect. There simply cannot be any outward reactions. You have to keep your hands folded in your lap. If you feel overcome with emotion, just look down. We cannot have any outward reaction. Second, once the verdict is read and the jury is discharged, you need to stay seated and follow the deputy's instructions about how we will leave the courtroom in an orderly fashion. If anybody in here can't follow these instructions, this is your chance to leave. All right. Fair warning, counsel, Ms. Richins. It is my practice to ask all the lawyers and the defendant to stand in respect for the jury as I read the verdict. I just don't want you to be surprised. Okay. Mr. Bloodworth, are we ready for the jury?
Yes, Your Honor.
Ms. Lewis.
We are.
All right.
We have arrived at the moment of truth. Kouri Richins is about to find out her fate in the alleged murder of her husband, Eric Richens. Her attorney, Kathy Nestor, appears to be trying to comfort her a bit. No one be too concerned. This will pop right back up. We are refreshing the feed as the jury walks in. What a time. Here we are. We are back. Bated breath.
Now we've lost the sound.
That will come back in. Here we go. Kouri Richins looking very stoic, looking down. The judge just advised that you look down if you cannot control your emotions. And it underscored that there can be no outward outbursts. And this point forward, I'll just listen in.
Mr. Ramos's tie is all the way over to the side.
Yeah, he needs that fixed.
Okay. Folks, please have a seat as you come in. Please have a seat. Ladies and gentlemen, would the foreperson you've selected please stand? May I ask you a yes or no question? Has the jury reached a unanimous verdict? Would you please hand the verdict form to the deputy, and you can have a seat. Thank you. I'll take that. All right. Counsel, Ms. Richins, please stand. Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of aggravated murder. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count 1 beyond a reasonable doubt. The homicide was committed for pecuniary gain, and the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Count 2, attempted aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of attempted aggravated murder. We, the jury, unanimously agree the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt. The attempted homicide was committed for pecuniary gain. Count 3, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 4, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 5, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery. It's signed by the foreperson. Please have his seat. Madam Foreperson, is this the verdict that the jury reached unanimously?
Yes, it is.
Okay, you may have a seat. Ms. Lewis, Ms. Nestor, do you wish the jury to be polled?
Yes, please.
All right. Folks, I'll ask you the same yes or no question, one at a time, starting on my left, working this way. front row first. If you could show me your lanyard number as I ask you. Juror number 5, is this the verdict you voted in favor of?
Yes.
Juror number 4, is this a verdict you voted in favor of? Juror number 3. I can't see your number, I'm so sorry. The 4th person, I just need to ask you again, I'm sorry. Juror number 2.
Yes, it is.
Juror number 1.
Yes, Your Honor.
Sir. Juror number 8.
Yes.
Juror number 7.
Yes.
Juror number 6.
Yes.
All right. Counsel, is there anything further on this case before the jury is discharged? Mr. Bloodworth.
No, Your Honor. Thank you.
Ms. Lewis?
No, Your Honor.
All right. Ladies and gentlemen of the jury, this trial is now finished. Thank you for your service. The American system of justice relies on your time and your sound judgment, and you have been generous with both. You serve justice by your fair and impartial decision. All of my previous admonitions are now lifted. You may speak about this case with anyone or with no one at all. It is entirely up to you. You might be contacted in the future by the press or by the lawyers. You do not have to talk with them or with anyone else, but you may if you would like. The choice is yours entirely. I'm now turning to the attorneys and instructing them to honor your wishes as officers of the court if you indicate that you do not want to talk about this case. If you do talk about the case, please respect the privacy of your fellow jurors. The confidences they may have shared with you during deliberation are not yours to share with others. Thank you, all of you, for your service. Please rise for the jury. All right, please have a seat. Ms. Lewis, we need to get a pre-sentence investigation report, and we need to set sentencing. I imagine, Mr. Bloodworth, that the state would request that that be special set.
Yes, Your Honor.
Okay. Ms. Lewis, does defendant waive the 45-day limit for sentencing?
Yes, we will.
All right. Let me call up my calendar.
Such a somber moment.
Should we be looking in May, Ms. Lewis?
That's fine.
Do you have a sense of it, Mr. Bloodworth? April is not possible. In May, do you have a sense of when would be appropriate?
Your Honor, can I step back and talk to the victim's family?
Sure. And Ms. Lewis, if you need a moment to confer with anyone.
That's really, he wants to find out what works for them for sentencing.
Yeah. COE, I know many are relieved. All I can think about are the 3 little boys. One decision, they lost both parents, no words.
Your Honor, any day in May works.
They lost both parents the day she killed their father.
Without having to move something, which I am, of course, willing to do, I could do it during the week of May 25 or the morning of May 13. But if those times don't work, or if the week of May 25 is too far out, I'll move something to accommodate council schedules. Ms. Lewis, why don't I begin with you?
Either of those days would work for the defense.
Is a morning enough time?
Yes, sir.
Ms. Lewis?
Yes.
Okay. We'll set sentencing for 9:30 a.m. Wednesday, May 13. We're hereby referring Ms. Richins for the preparation of a pre-sentence investigation report. Ms. Lewis, anything else on the record today?
No, Your Honor.
Mr. Bloodworth.
No, Your Honor.
Ms. Richins, I'll see you again, May 13, 9:30 a.m. I need everyone to stay seated, follow the instructions of the Summit County deputies. The court is in recess. Travel safely.
And that is a wrap on the pool cam for Kouri Richins. The verdict, if you are just joining us for a trial that lasted over 3 weeks, was guilty on all 5 counts, including murder, attempted murder, and the fraud and financial crimes. Joe Potuto, it was a clean sweep, all going the way of the government, and little to no emotion shown by Kouri Richins. Any surprise from you?
I guess I am a little surprised that she was as stoic as she was. And with regard to the verdict, I thought the one the jury would have the most trouble with would be the attempted murder, but they seem to not have any difficulty with that either. So I think the state did a really great job of getting the evidence in. Some of the evidence that would have been most helpful, the judge ruled was not admissible, and probably rightly so. And that takes out a lot of what would be the appealable issues in the case. Yeah. So it's just a shame, just a shame.
A few people are saying this. I can't confirm it, but apparently it is Eric Richens' birthday on May 13th, which is when sentencing has been set, talking about ironic, but she will be sentenced likely to, I imagine, Joe Potuto, she's going to get life in prison without the possibility of parole. Does that sound about right?
I think so, but I meant to check to see what Utah law is, but since this is aggravated murder 1, I think that's right.
Yeah, it is aggravated murder 1. Yep. And Yvonne, a lot of people are confirming it is Eric Richens' birthday on that day. You saw the family there, and they looked how you'd expect them to look, worn out, tired. But I did notice the father kind of breathed a sigh of relief quietly when the sentence was read, and they panned over to him. But the family's got to be relieved at the very least, just to get justice for Eric. But it's a super difficult situation because now I think the sister is raising, I think it is Amy who is raising the 3 boys now, Joe. So it's,
it's really terrible. You don't bring the person back. Those boys are never going to have their father back in their lives, but it's the best the system can do, which is to get justice for him, at least by punishing the person who's responsible. But, it doesn't bring their father back. It doesn't bring, the son or the brother back. So, justice system does what the justice system can do, but it's, truly not enough.
Yeah. By the way, the COE just told us on the chat that Skye Lazaro might show up here any moment. She is Kouri Richens' original attorney. I did not think she was going to speak, but apparently she might be willing to comment now. So stand by for
and
that.
She was in court all day.
Yeah, she was in court. I didn't see her for sentencing, but that doesn't mean that she wasn't there. She may have been there. But Joe, just talk about they were very easy to and forthcoming in terms of waiving the 45-day limit for sentencing. Mm-hmm. Is that just kind of a clerical thing? I mean, it's
at this point, it's really anticlimactic. I mean, there's no sense, unless you've got a really, really strong reason why. There's no reason to fight this anymore. There's nothing, she's going to be sentenced, and that's inevitable. So why fight it?
Yeah, and I'm being corrected. I guess Katie, not Amy, but Katie has the boys. But either
That's what I thought.
case, yeah, they're
Yeah.
being raised by people who are, you know, family, and that's a good thing. But obviously, they're going to be dealing with all the sorrow and the grief from all of this. Dan Schorr joins us now. He is also a criminal defense attorney. We had him on during the Alexander brothers case because he also at one point prosecuted sex crimes. Here it's the murder of a spouse, Dan, with 5 times the lethal dose of fentanyl. How unusual is it from your experience doing trial work for a jury to come back and this is just a little, 2 hours, 30 minutes to change after a 3.5-week trial? What's that tell you?
I would say in general, it's very unusual. Usually as a prosecutor, we see quick verdicts as good for the defense because usually if you're going to convict someone, especially of a serious charge like murder, you take a lot of time in doing it. But I think in this case, there was just overwhelming evidence showing not 1, but 2 attempts on the life of the husband. There's the electronic communication, the internet search history looking for lethal doses of fentanyl. There's the insurance policies that she took out without her husband's knowledge. There's so much circumstantial and direct evidence here. And the defense doesn't have a burden. They don't have to put on a case, but they didn't really offer any other explanation. And legally, they don't have to. But there was really nothing, I think, for a jury to find reasonable doubt on here.
Yeah. And Dan, just so you know, you're on with Joe Potuto, who's a retired professor emerita at University of Nebraska School of Law, and she's taught all over. But Joe Potuto, it is kind of shocking considering all the scenarios that you and I were coming up with earlier, and we were saying, well, maybe they'll have a verdict by Wednesday. I kind of went out on a limb, Joe, and said it's going to happen much quicker because I do think, like, holistically, there was just a Mount Everest of circumstantial evidence, Joe, but there was no like actual, there is no video of her putting fentanyl into the Moscow Mule. So you've got to take that leap of faith and you've got to be comfortable with it, Joe.
Yeah, that's right. It's true.
It's
but the prosecutor said he was right. You don't video somebody who shoots somebody in the head either. I mean, you never get that sort of or rarely get that sort of evidence in a case. So I'll ask you a question, Dan, if I might. Were you surprised that they came back with a guilty verdict on the attempted murder?
I was not, because I think that if you're going to find guilty for murder, you're probably going to find guilty for attempted murder. I mean, if the jury thinks that she's capable of using fentanyl, trying to poison her husband, kill him, that's the only verdicts that make sense. And I would also add that I think there's this general notion in society that circumstantial evidence is not powerful evidence. Sometimes people will say, oh, that's just circumstantial evidence. But as a prosecutor, I could say sometimes circumstantial evidence is the most powerful evidence because it doesn't lead to any other conclusion than the one that led to a guilty verdict here, because circumstantial evidence can really show that there's no other explanation for all the information, the insurance policy, the online searches, her other comments. Who's looking into lethal doses of fentanyl online just as her husband dies from that? And then, there's so much here for the jury to work with. So I think it was an overwhelmingly powerful case. It was a quick verdict. I thought it would take a little more time just because there's a lot to sift through here, but apparently the jury was convinced in a unanimous way, and they reached a verdict.
Yeah. Did you see the closings?
Oh, Dan just froze up on us for a second. He'll be back. The Richins family announcing that they will not be speaking to the media right now. I can see backstage the COE's and Space Coast have a shot up. I'm just going to bounce Dan out because he's obviously frozen, and he'll unfreeze and come back in. But the Richins family announced that they're not going to be speaking publicly right now. The person who has been speaking for them has been Greg Skordas, who's a friend of ours that survived the Survivor. He's a best guest, and we will get him on. Either it'll be in a few minutes or likely tomorrow, but we will get Greg on. I think, Dan, you're back, Dan.
Yes.
And I think Joe had a question for you, Joe.
I did. Did you see the closings? Did you have a chance to see the closings?
I read the accounts, but I didn't get to see them actually being delivered.
Yeah, they were very meticulous on the side of the government, a little more scattered by, in my opinion, by the defense. But just on a technical level, Dan, the judge obviously he said a pre-sentence investigation. What goes in? We always hear about that, but I don't think most people know what that's all about.
Sure. So before any sentencing, you have a pre-sentence investigation. Usually it's done by a probation department or some equivalent organization, and they will talk with the victims. There might be victim impact statements that are added. They'll look at the criminal history of the person, and depending on how serious the conviction is, they'll make a recommendation, which could be incarceratory time, could be probation. Obviously here with the conviction of murder and other charges, you're looking at possibly life in prison, certainly substantial prison time, but there's always a requirement that there's a pre-sentence investigation. It guides the judge, although it doesn't bind the judge on what they can give in a sentence. And then the prosecution gets to weigh in, the victims get to weigh in, and the defense gets to weigh in on sentencing. So that's all how the sentence comes together.
Just want to thank everyone at STS, the COE, the chief of everything, AKA my wife. You've got Space Coast on the West Coast, who's switching the feeds and constantly getting us the best audio that there is out there. Steve Cohen getting us the guests like Joe Potuto and Dan Schorr, and the list goes on for miles. And then you've got the mods who are lifesavers for us. So the mods do not go unnoticed by us. We appreciate all their hard work, and it takes a true team effort. We've been on the air today for 10 hours and 24 minutes and 29 seconds, but who's counting? And we also did a separate show. So a lot for a Monday, but this is obviously a very important case. And it's Dan, I just asked this question almost rhetorically now, but why don't people think of the consequences? Have you come up with some sort of rationale in your own mind as to why these types of people who commit these sorts of crimes, and it's probably being committed as we speak, a similar crime right now, why do they not think about, forget the lives that they're taking, their own lives, sitting and rotting in prison for the next however many years Kouri Richins is going to rot in prison for?
Well, when I was in the Queen's DA's office for a time, I was investigating homicide cases, and I was struck sometimes by how brazen people were and how reckless people were when committing homicide. And again, just like you said, putting aside the cruelty and the harm to the person that they're taking a life from, just people thinking they could get away with things and thinking that it's going to work out is really shocking. One of the things that strikes me here is those internet searches. Aren't we living in a day and age where everyone knows that if you put something into an internet search, other people will be able to find out about that if they try to look? But apparently not, because she did this in a device that was accessible by law enforcement that really helped put this case together. And people, I see this in all the cases I investigate, whether it's sexual misconduct or other crimes, where people are using electronic searches, electronic communication, photos, videos that they're sharing that really implicate themselves in major wrongdoing. Why people continue to do that, I'm not sure. Maybe people are just brazen and think that they are immortal and will get away with whatever they want to get away with. But law enforcement here put it all together.
Yeah, it is. Again, there's no winner here. That's why it's tough to cover these, because you feel like, and Joe Potuto, I mean, I don't know if you care to speak about this, but you feel like there's going to be this sort of, I don't know, like a moment of joy is not the right word. I can't put the right word in right now, but you get what I'm saying. And then it's very bittersweet, and it's almost like, I don't know, it's more bitter than it is sweet all the way around, because you've got a woman now going to prison the rest of her life. You've got the husband who is no longer in the world. I mean, and it's just sad. The family is destroyed. It's difficult.
Yeah. Well, it's the crime that does it. And after that, there's no way to repair it. You can't make everything whole again. You can't bring the father back. You can't give the kids their father. You can't give the sisters their brother. You can't give a father his son. I mean, so it starts out that way. And the things you want to happen, what the family would want, was, what we as society would want, is impossible to achieve. So you can only do what you can do. And what you can do is send somebody who's done it away for a long time or maybe the rest of her life. And it's not enough, but it's the best we can do.
Yeah. Dan, we've had jurors on from the big case that we covered, which is the Dan Markel and Adelson case. But the question here from Red 1989, if jurors grant interviews, what can they reveal about the deliberations in seeking an appeal? I guess. So whatever information they reveal, can that be used potentially in some sort of appellate case?
I've seen that happen, and usually it results in an appeal when the juror discloses something that shows a procedural irregularity with how the jury was acting. So if they're just talking about, here was my opinion, here was other people's opinion, we were split 7-5, and then we worked our way to consensus and a unanimous verdict, that's not going to create any issues for appeal. But if they say, oh, someone like a court officer told me something that I wasn't supposed to know, or someone said, well, I'm not going to follow the law, I'm just going to do what I want. Like those type of statements sometimes will lead people to say there was a procedural irregularity, they were denied due process, and then there's an appeal. But as long as they're talking about their personal experience that's consistent with the law and proper procedure, then there's no issue. The thing is, we live in a day and age now where people are not anonymous. Even if someone tries to talk anonymously, often people can dox that person and find out their identity. So jurors have to be really careful that when they talk to anyone in the media, their identity may get out there. That may lead to harassment. So that's something to be cognizant of also.
Yeah, Jen Ken saying unreal. She had everything and let it all go at 35. I mean, she was married to a wealthy man, 3 beautiful kids. Now she's not going to be part of those kids' lives. They won't be a part of hers, and neither will the father. And a lot of money was spent on attorneys and will be spent elsewhere. Don't forget, Kouri took out life insurance on the kids, Joe Potuto. This verdict takes them out of danger. I don't know that she would harm the kids. I definitely wouldn't put it out of the realm of possibility. But, Josh Grossman, her one-time lover, he might be relieved tonight to know that he's not still with her. I have no real doubt saying this, especially now that she's convicted, that she might have thought about doing this to the next husband potentially. What do you think?
Well, I don't know. I do think it's worrisome that she took the life insurance out. I mean, remember, she was so far into debt and was trying to cover expenses. And in the middle of that, she takes out insurance on the kids. It does make you worry about it. There's obviously no evidence that she would have done anything, but I'm not surprised that there are people in the chat who have drawn a line between the insurance and what might have come next. I don't know. She seemed to be so intent on trying to make money. She was married to someone who had a fair amount of money, and it looked like he was going to be continuing to make money. So it couldn't be the money itself that was driving her. I mean, because the family had money, it didn't look like he was holding money, not giving it to her. So it's hard to see what it was that pushed her this way. I don't know how much, Dan, you saw the trial, but I was absolutely flabbergasted at the amount of debt she was getting into. And it seemed as though her solution was to borrow more. I mean, she looked to me like a compulsive gambler, except instead of being at the roulette wheel, she was dealing in real estate. Instead of just saying at the end, I'm in so deep, let me stop. It was just more and more and more.
Yeah, well, Dan, let me just jump in there. So to Joe's point, she faces 26 more charges in a separate financial case. There were pecuniary charges that she was convicted for here, but there are 26 other charges. I assume that, what's your experience? Will the state move forward with those? Because I guess there has to be resolution there.
Absolutely. They have to move forward with them. This is such a serious case. And as we know, even if someone's convicted, it can be overturned on appeal. There could be a procedural problem. People get pardoned by, and they get out of jail that way. We see that happen. So you never want to be assuming as a prosecutor that someone who's convicted is going to be serving that sentence. And if there are other types of charges like we have here, you want to prosecute those, and you want to do those promptly, because the longer you go, the memories fade, witness interest diminishes, and it's important to go forward now. So ultimately, if she's convicted on those other charges, then the judge, in that case, will have to decide whether she gets concurrent time where both sentences are together or consecutive time if she's convicted on the financial cases. But she's facing most of the rest of her life, if not the rest of her life, in prison right now, I would think, based on this conviction today and what else is hanging over her head.
Wow. I definitely do not think she understands the scope of what she just got herself into, which she cannot get herself out of now. But from RLD 1989 to Joe here, can she ghostwrite another book in prison like OJ did and profit from it? There are laws. New York, there are Son of Sam laws where you can't profit. But
I'm guessing that Utah has a version of the Son of Sam law. Plus, she didn't write the book she wrote. I mean, well, when we found out that the book that she claimed she wrote to make her kids feel better was she paid somebody else to write it. So, and off the 2 letters that I saw her write, she's not a good writer.
Well, Bloodworth called her out in court for that today, and she shot daggers at him with her eyes. Dan, to you from Angel of Mine 66, are jurors in Australia, shout out to Australia, they're not allowed to speak to anyone after the trial is over. When we had jurors speak to us, it came up, one of the jurors came up as a potential appellate issue for something that the juror said. And they were speaking, you know, very intelligently and I thought pretty objectively. But should jurors be allowed to talk or not? I mean, we are the land of free speech here.
I think they definitely should be allowed to. Whether it's a wise thing to do, I'm not sure, but certainly I would want people to have the freedom to do that. I think that it's important for people to be able to tell their own experience and story. And also, I think it's helpful for us on shows like yours, broadcasts like this, for people to understand how the jury system works. I think that's a real public service for you to speak with jurors, have people listen to jurors, because it's kind of an opaque system to most people who aren't in the criminal justice world. And for people to understand not only how the system works, but also the importance of being a juror, because so many people, you know, when a friend tells you they got called for jury duty, almost always they say, I'm trying to get out of this. I'm trying to think of an excuse. And I think it's really important to be able to show people, no, this is really important. You're making really important decisions that affect people's lives in a really significant way. And you shouldn't just try to avoid it when you get called for jury duty. So I think for all those reasons, it's good for people to have the freedom, but it does expose people to risk for the reasons I said before.
Joe Potuto, if Kouri's assets are frozen, I COE loves to switch comments on me, but basically the question had to do with the freezing of assets. Is it sort of immaterial at this point? Or, you know, I was reading that the family has like a $10 million lawsuit against Kouri Richins. Is there any chance that they're going to actually like retrieve money that's maybe stored away somewhere in some random bank account, Joe Potuto? I mean, I don't think there's much left.
I didn't, listening to the trial, I don't know what assets she still could have.
Yeah.
I mean, she lost all the properties. She was in debt anyway and couldn't pay the short-term mortgages on them. So if she scrolled away money, she's really much cleverer with money than I would give her any credit for.
We have Greg Skordas here, who is, hey, Greg.
Hey, how are you?
Doing well. Thank you so much for joining. I know you have very limited time. First and most obvious question, how is the Richens family today? I was just talking about how this is bittersweet. I mean, there's really no winners, but is there a sense of relief at least, Greg?
Yeah, and you're exactly right, Joel. There's a tremendous sense of relief. A quick verdict, and I'm sorry I'm in my car, but a quick verdict was a little bit unusual, unexpected after 15 days in trial, especially with an aggravated murder. But I think they're sort of dialing it back right now, and everybody talk. But right now, a tremendous sense of relief. Nobody's happy, but the jury got it right.
Yeah. Greg, you're cutting in and out a little bit. Greg, for those who do not know, is number one, a fantastic human being. Number two, he is on ski patrol in Summit County. Number three is a defense attorney. And number four was a public defender before that. So he's done it all. By the way, Greg, on a lighter note, I understand Judge Mrazek is on ski patrol. Is everyone in Utah on ski patrol? And is he a better or worse skier than you?
He's younger, so he's better. These young guys, I can't keep up with them. I'm an old man, Joel, and I've challenged you to come out here and ski with me. Yesterday, I taught a toboggan clinic for the National Ski Patrol. It was a lot of fun, but I'm an old man.
Yeah. Back to serious stuff. So the obvious, the people that everyone's thinking about the most are the three boys. Their names were mentioned in court today. How are they doing? I know they're obviously very young, but I hope they're being cared for properly. And how's the family feeling about having to raise these boys now?
Well, they've been doing it for the last couple of years, as you know. We've talked about this several times.
Yeah.
But they lost their father, and now, for all intent and purposes, they've lost their mother. I mean, she's never ever going to get out of the Utah State Penitentiary, absent some appeal for something that is pretty much unforeseen at this point. Whether they have some relationship with her in the prison facility remains to be seen. They're doing incredibly well because the Eric Richins family just rose to the occasion. They absolutely took those kids with open arms and took care of them as though nothing had happened. And their lives have continued as though this wasn't happening, as much as you could imagine that happening given the circumstances.
Yeah, Greg, I want to be real mindful with your time. So just another couple of questions, but closings, were you there for closings today in the courtroom?
I listened to them. I wasn't there. I haven't had time to go up there, but I listened to them. They were long. They were painfully long. But I mean, I gave closings on a homicide trial last Friday, and I guess I was probably painful myself. But it was a 3-week trial, so you would expect there to be a fairly decent long summation so that the jury knows exactly why each witness was called and what their testimony was about. And then the defense, of course, they didn't put any evidence on at all. So their closing was all about creating doubt, how it is that the state hadn't proved their case, what reasonable doubt exists with respect to the elements of the crimes. And they went through that, I thought, to a very good, a very good amount, but it just didn't carry the day with this jury.
Yeah. Greg, you mentioned this off the top, the fact that deliberations for a 15-day trial were under 3 hours, and I think that includes dinner. How unusual is that, and what does that say about this resounding victory for the government here?
It's very unusual that you would have a quick verdict like that, because the jury has to be unanimous, and they had 5 counts. It tells me that the state had a very powerful case, and Kouri had great attorneys, and I'm not being critical at all, but they didn't put on a case. And I think the jury wanted to hear something. They wanted to hear from Kouri. They wanted to hear what's the other side of this. And it was a strategic move by the defense attorneys because they felt that the state just hadn't carried the day. They were comfortable that the state hadn't carried the day and that they were going to get a quick verdict of not guilty. But that didn't prove to be the right call in this case.
Greg, have you had to go up against Brad Bloodworth, because he seems like his stock rose today, and he's a tough adversary, I'm sure, in the courtroom.
He's a good lawyer. I mean, my cases with him have been nothing compared to this, just drunk drivers and such. But he's fairly new to that office. I've had some dealings with him. I find him to be a very respectable man, fairly new to the Utah legal community, but not a new lawyer necessarily. But he did a good job, and yes, he certainly did everything he should have done in this case.
By the way, where else are you going to get the former attorney for Kouri Richens, Skye Lazaro, and the attorney for the Richins family, Greg Skordas, on the same show moments after? You're not going to get it anywhere, not on Court TV, not on Fox, not on MSNBC, but you will get it on Surviving the Survivor.
He's right, isn't he, Skye?
He is. It's because we love you so much, Joel.
Yeah.
You're our first
over
priority.
on the freeway.
Hey, well, Greg, I love that about you. And Skye, same goes to you. Thank you for taking the time. We appreciate it. I want Joe. Joe, do you have a question for Greg? And then Dan?
I do. What do you think the defense could have put on as a defense? I mean, I agree with you that the jury wanted to hear something, but I infer from what you said that you think the tactical decision not to put on a defense was not the right one, but that depends on whether there's a defense that could have been mounted that it would have done anything. So what do you think they could have done?
Well, in simple terms, and that's a great question, they could have put Kouri on and have her say, I didn't do this. I mean, I know that's not a great answer, but, and I know it's a risky thing. Skye and I have done enough defense work to know that putting your client on the stand is risky. And hindsight's 2020. These are great lawyers, and I don't mean to second guess them. But a defense they could have put on was Kouri looking the jury in the eye and saying, I did not do this.
Dan, any questions for Greg Skordas? And then we're going to get to Skye.
I mean, I would just say that I think in that moment where she said, I did not do this, that would be helpful for her. But then she's going to be cross-examined by the prosecution. And then it's not going to go as well, because then she's going to be going through every single detail and ask for explanations. Why did you search for the fentanyl online? Why did you take this insurance policy? Why did you do this? Why did you do that? And when she can't answer it, then the case is over. People usually do not testify in their own defense, especially in murder cases. It hardly ever happens because fortunately, we live in a country where most people who are charged with murder had some criminal responsibility. It's not to say that everyone is. There are plenty of people who are wrongfully charged, but generally there's evidence to show that the person committed the crime, and it's hard to be cross-examined in detail by a good prosecutor about that. So I think that's why she didn't testify here. I don't know if that would have been helpful to her.
Yeah, a quick. Let me take just one quick moment. Monday through Thursday, we do a live panel show at 7:00 Eastern. Fridays, it's with my mom, who's a child Holocaust survivor. Hence the name of the show. We do that at Fridays at 1. But please hit that like button and subscribe. It goes a really long way. Just doing that to support the channel. Skye, Lazaro, Greg, I know you're pulled over. If you can bear with us for 5 minutes. But Skye, you were the one-time defense attorney for Kouri Richins. Am I allowed to ask, and feel free to tell me to buzz off, why you did not end up being her defense attorney through trial?
You know, my answer is always going to be the same, Joel. There was a conflict that arose that I can't talk about.
All right, well, so I know we saw you in court today, and you were there for closings. What was the atmosphere like inside that courtroom as closings kind of weave their way through today?
You know, it was a heavy courtroom today. People are tired. Everybody looked tired. I think the jurors were tired. They've been at this for weeks. I was somewhat surprised that the jury came back so quickly. Just given that there were 5 very serious charges, I expected them to probably come back at some point tomorrow. But it was, people took their jobs really seriously. The jury was very attentive. They were still taking notes. They were still paying attention. It was, I think both sides probably would have to say they were fairly happy with the jury that they sat, regardless of the verdict.
Were you able to have a word at all with Kouri today?
I was not.
Were you able to speak to her defense team at all after the verdict?
No, I came back to Salt Lake after closing arguments, and like I said, I did not expect a verdict this quickly.
Yeah, I just asked Greg that, and I'm going to let our smarter guest jump in a second for a couple more questions for the two of you. But Greg says how unusual it is, a 15-day trial, and these deliberations were done and over with in under 3 hours, including dinner. In your own experience in either Summit or Salt Lake, how unusual is this?
I would say this is pretty unusual. I mean, it certainly does happen in cases, but with the amount of evidence that was put on and in the types of exhibits that were admitted into evidence, I would have expected that it would have taken them a little bit longer to go through everything, or at least go through some of it again. I think a verdict that comes back this quick after that long of a trial has that many exhibits that I think they probably had their minds made up some point early on.
And STS Nation is always diving in with their own questions. What made you attend today, Skye? Why did you decide to go to closings?
You never really let go of cases. I worked on this for a long time, and I stayed away from the trial, so I didn't cause any distractions. But I wanted to be there to support. I spent a lot of time with Kouri and her family. When you do that as a defense attorney, doesn't matter who your client is, you develop relationships with them. That doesn't go away. And so I wanted to be there to be supportive.
And do you know how her mom's doing, Lisa Darden? There's been a lot of smoke around her, as I'm sure you know, but just from a mental health perspective tonight, I'm sure you haven't talked to her since the verdict, but how was she doing leading up to this?
She was doing pretty well today. I think, like with everything with these cases that take so long to get to trial, I think there's some fear and some relief that there's finally going to be some finality to it instead of it hanging over your head. Of course, you never want to defend, a guilty verdict. I'm sure she's not doing very well right now. But when I talked to her earlier today, I sat with her in the courtroom and she was holding on.
She's going to need to hold on. It's going to be a rough go for her as well. Joe Potuto, any questions for Skye or Greg? And then Dan, I'll have you jump in.
Well, I have lots for Skye, but none that she's going to be able to answer.
I appreciate the comment, by the way. Thank you.
Oh, there you go.
I don't get that very often.
Skye is a good human. That's the comment. But Joe Potuto, now you know what it's like to be a reporter. Ask away. Oh, I'm curious.
No. I'm not going to ask away because she still has a relationship to the client that she can't breach. And so the things that I'm curious about, you can't answer. And I know you can't, but.
Greg, let me dive in because, we're very victim oriented at Surviving the Survivor, and we've never met in person, but you're about as salt of the earth, no pun intended, in Salt Lake as they come, Greg. And I know you care deeply about this family. I know they're kind of taking it one day at a time, but how are they doing, beyond the trial, just kind of going through life day to day? The sisters, the father looks devastated, but I saw him kind of breathe in a sigh of relief at the reading of the verdict. I mean, how are they all holding up?
I think as well as can be expected. I mean, nothing will ever bring Eric back. Nothing will ever reunite this family. But I think there's got to be some level of relief. I think they're all exhaling right now for the first time in years and are going to be able to sit down and regroup as a family and raise those boys the way that they should be raised, which is what they've been doing anyway. And I think they'll probably start talking. They've been very behind the scenes and have not really spoken to the media at all. But I think that they're going to come out now, probably within the next week, and let people know their emotions.
Well, Greg Skordas, I know a platform that they're welcome on right there. He goes to black. He's pretending to not hear me. He's getting a call maybe, but Greg will, I'm sure, help us get the Richins on here. I'd love to speak to them and have Joe come back on and, get a sense of what they're going through firsthand. Skye Lazaro, I know it's easy to, Greg, I was saying, I know the perfect platform for them when they're, when the Richens family's ready to call. Oh, there he goes again. Let me bounce him out when he reestablishes. But Skye Lazaro, to you, you don't want a Monday morning quarterback, especially when you are working with a lot of these lawyers in a relatively small, legal environment in Salt Lake. But if you had to relitigate this case, would you come in with a different defense?
Like you said, you don't want to question. I think they did a phenomenal job. I think this was a really hard case. These cases that revolve around a lot of circumstantial evidence are really difficult to defend. In terms of not putting on a case, I tend to agree with them somewhat, and here's why. The state did hold back some things because I think they believed that the defense would put on a case and there was a possibility that Kouri might testify. And in that instance, on rebuttal, they just would have gotten one more chance to talk about, all of the things once again, and send the jury back on kind of this last high note that they have. I think we all probably have a different style. There's some things I may have done differently had I defended it, but they were the ones sitting there, so I'm probably not in the position to question that.
Yeah, they're, the Theodore Roosevelt man in the arena, man or woman in the arena. It's much harder to be in there doing it than it is to critique on the outside. But what about the financial trials, Skye, moving forward? Those I was asking Dan about it, but you're a little more close in proximity. The financial trial is going to move ahead. And do you have any idea of a time frame for that?
I don't know what the time frame will be. Those cases have been stayed waiting for this case to go to trial. It's up to Kouri, obviously, whether or not she wants to take a plea deal. It's up to the prosecution if they're going to offer one. But with the sentence that, she's facing after being convicted of this case, there's a possibility that they may, offer some sort of plea that she may or may not take. You always have to keep in mind that there's probably some pretrial litigation and some decisions by the judge that, are probably grounds for an appeal. Whether or not it's a successful appeal remains to be seen. But I would expect that there probably will be an appeal in this case.
And are you going to be involved at all in the financial side? Would that not at all?
I am not.
Okay. Greg Skordas, you got cut off, but when you said the family is going to be coming and speaking, publicly, obviously we would love to have them on our platform. I'll talk to you about it off camera, but let them know that they're welcome here. And I know you're sitting there in the Utah sun right now. So, Joe or Dan, or Skye, any questions for Greg? No final. Yeah, Dan. Well, Dan, you're muted though. We got to unmute you. Go ahead. Go ahead.
Am I unmuted now?
Yeah.
Hi, Greg. I was just wondering how you go about preparing a family for a verdict like this, knowing that it could be a bad verdict. It worked out for them, and fortunately, that gives them hopefully some comfort amidst this tragedy. But they also know that walking into that courtroom, this could be another nightmare following what they've already experienced. How do you prepare someone for that? That's something that I've never had to do in the way that I think you had to do here.
Great question.
That's a very good question. And, I think that the family felt like they had the best that the Summit County attorneys could do, that the prosecutor and the law enforcement did everything they could. And they were not going to look at this and say, well, you should have done this, or you could have tried that. So I think the family felt like they had a fair trial, that they had a fair shot, and that they were treated respectfully. So they were prepared for any verdict. And I don't know that they would have been particularly upset had it gone the other way. But obviously they're going to be much happier the way it did go.
Joe Potuto? You're muted. Everyone's muted for some reason. You have to unmute yourself there, Joe.
Yeah, anyway, I thought of a question I think you might be able to answer, and that is, do you think Kouri was prepared for the verdict that came today?
She had, as Skye said, really very good lawyers, and I'm sure they prepared her. But I also think, just from what I've seen from her, and I know Skye can't comment on this, that she'll never come to terms with this. She'll never, say I'm sorry, I did it. She's just out there, I think, and this is just my take on her. So she probably wasn't as ready for it. She probably still thought she'd gotten away with it.
Greg,
Skye, you worked with her and got to know her. Do you think she was ready for this in any way, or no?
That was a quick no. Greg Skordas, someone asked, she's 35. Does she have a shot in 40 years at 75 of getting out, or is this almost certainly going to be a life without parole because of the aggravated murder?
That's a fair question. I mean, anything can happen in 40 or 50 years, but I would not bet that she will ever see the light of day as a free person.
Wow. Greg Skordas, I've asked this of Joe. I asked this of everyone. I never get an answer because I don't think there is an answer. But your theory on why people commit these crimes without thinking about the repercussions and spending everything she had as a free woman is now gone. Forget the fact that you're taking someone's life. Why don't they think about their own life?
That's the $1 million question. But I think that some people feel like they've got it all figured out and they're going to get away with it. And she was going to be a very wealthy woman. And I think that she didn't care about anything else, and it was all or nothing, and she ended up with nothing.
Kelly McClellan for Skye here. In general, how hard is it in any given case to defend someone when at times you know that maybe they're guilty, not referring to anyone specific in general, like Kouri Richins?
I don't find it difficult. I've been a career criminal defense attorney. Here's at the end of the day, what matters is that people's constitutional rights are upheld. And if at the end of the day, the jury comes back with a verdict that's guilty, then that's our system. That's the sanctity of the jury, and that's what we task them to do. Our job as defense attorneys is to make sure that along the way that people's constitutional rights are followed from, the beginning of the investigation until the end of a trial. Because if we don't do it for even the worst of people, it doesn't apply to everyday citizens. And that's what we ask of juries, is to hold the state accountable, to hold all the state actors accountable, to hold all the witnesses accountable, and make a decision based on it. And that's the bedrock of our system. And that's why good defense lawyers are really important, because without them, there's no check.
Can I ask a question of Skye? I just had a follow-up question about that.
Please, go for
Skye,
it.
I know some defense attorneys tell me that when they work with a case like this, they want to know everything from the defendant, what their story is, understand it. Some tell me they don't ask those questions because they don't want to know and they don't want to be knowledgeable if someone perjures themselves in the stand. I was just wondering in general which approach you take, not necessarily in this case, of course, with a defendant in a high-profile, complicated matter. Do you want to know everything about their story, or are you more looking at legal issues and trying to frame the story in the best way for them?
I never want to be blindsided by something I didn't know or should have known. I think that's the absolute worst position you can be in as a defense attorney, is to be standing up there and learn something in court for the very first time that you don't have a way to counter, or a way to argue, or at least be prepared for it in a way that you can come up with a trial strategy or a defense strategy for your client that could be effective. Obviously, the legal part of it and questioning what the state's done is always a very important part. But you hope your client never lies to you, right? Like, you hope you never get in a position where you can't put your client on the stand because you're afraid they're going to perjure themselves. But the reality is I think you're usually better to know all of the things, because if you don't and you start down a road even early on with a defense strategy and you get blindsided by something, especially in a high profile case, it absolutely guts your case, because then you lose credibility yourself. Anything your client or your witnesses say, can lose credibility. So I usually, operate on, if the more I know, at least the better I can prepare my client.
Yeah.
I have a question with regard to maybe not Utah trials, but the county. I was struck by, in contrast to trials in other states, the extent to which Kouri could make facial expressions during the trial, the sort of extraneous comments that the defense lawyers made, I think, repeatedly during the trial. Is that common in Utah? Because it certainly was unusual to me, both things, that the judge or the prosecutors never tried to get a handle on. For either of you.
Greg, why don't you take that one, Greg?
Yeah, I'm sorry I keep cutting out. My phone rings and I have no idea how to disconnect the call without disconnecting myself, and it just won't stop ringing.
No
but
worries. Right there.
For some reason, Professor Joe, when you speak, I cannot hear anything you say. So.
Oh, I'm sorry.
Yeah.
Can you hear me now?
I'll hop in. It's right. It's just a weird glitch with this software.
Okay.
I'm gonna file a class action lawsuit against StreamYard too, and have Skye and YouTube. But Skye, the question was, Kouri was making a lot of facial expressions. It just seemed like, and Joe was asking about the, like, I guess, propriety or lack thereof inside the courtroom? Is that something that's common?
Well, and the comments that the defense lawyers kept making, extraneous comments throughout, just interjecting.
Yeah,
Both.
and also extraneous comments from the defense that are kind of just thrown in there. Is that common? She's asking in that part of Utah.
You try to prepare your clients in all cases not to react to anything that witnesses say. I don't think it's helpful. I mean, we heard an objection by the defense during after closing arguments that the prosecutor had commented on Kouri's demeanor throughout the trial. The judge ruled that there was a curative instruction given that you can't take Mr. Bloodworth's perception of those, but the reality is it's not helpful. So you really try, and it's hard, to lecture your client and remind them that they're being judged at all times by the jury. Every second that they are being viewed, the way they sit, the way they dress, the way they react to statements. So you really want your clients, it's a hard line. You don't want them to look stoic and cold, but you certainly don't want them to be overreactive, because juries just really do not respond well to that. And it does not make your client likable, which is really hard. It makes it really difficult to win a trial that way. The same thing with being counsel. You've got to stay just really stoic about things and very, very professional, because the extraneous comments really don't help you.
Yeah. Weaving Moss was reading my mind here. Has Skye worked any trials with Judge Mrazek before? Have you argued before him?
I've argued before him quite a bit. I can't remember if I've ever done a jury trial with him, but I've certainly done quite a few, suppression hearings or evidentiary hearings or preliminary hearings, things along, those natures in his court.
He's got a great voice, and he's a tall dude, and he's apparently an excellent skier. Guys,
Tell you, the public loves him.
He's a he's a total package. Skye, by the way, I noticed he did not have a wedding band on last week, and today he had it on, which leaves me to believe one thing, and that is that his wife watches Surviving the Survivor. She was like, "You better get that damn wedding band on," and he had it on today. So there you go.
She's like, "I'm reading the comment section, sir."
Greg, you keep getting cut off, but I was the last time I think was saying that obviously, our hearts go out to the Richens family. Again, we're very victim oriented. The platform for them is always open. It's always open for you. If there's anything that they need from a fundraising perspective, anything like that, just let us know. And we've got the best community on YouTube. So that is from the bottom of, I think, all of our hearts.
Joel, I want to say something, if I might. The last time I got cut off was, in fact, because the Richins family was calling me, and they were. I can't tell you everything we talked about, but they have asked, at least for the time being, that they.
Oh
God!
He's getting all these calls. Now everyone's gonna have to wait. So we call it tease.
Guys, I'm gonna have to jump off here in a minute.
Yeah, Skye, real quick for you, and I appreciate you giving us the time. A lot of people say that, she's an evil woman, she's devoid of emotion. I mean, Kouri, is there anything you'd like to say about her just on a human level, and your final thoughts here? I mean, it's a tragic day all around.
It is, and I don't think that's a true statement of her. I spent a lot of time with her. I can't, obviously comment too much on things, but my experience with her was far different.
Okay. Skye, you're a trooper. I know it's not easy to come on. Appreciate you coming on, and we'll get you back on for a different story. And let us know when your next big headline case is, and we'll be all over it.
I will. Let's talk about Charlie Kirk next.
Yeah, we'll do that. All right. Thanks, Skye. Take care.
Take care. Bye.
Hey, Greg, you have everyone.
I'm so sorry.
That's enough.
My phone will not stop ringing.
No. So what happened with the Richins, and then we'll let you go.
They just wanted to keep their privacy for a while. Everybody's calling them wanting to be on TV tomorrow, and they've just said, hey, we're going to dial it back for a while. So they won't be making any comments for a little while.
Okay. Well, you know where to find us, Greg. You know we're not high pressure pushers here, but I'll be in touch with you. And thank you for everything that you're doing.
Yeah, you're the best in the business, Joel. I love you. I'll talk to you soon.
Love you too, man. Bye-bye. So there you go. You've got Greg Skordas, Skye Lazaro. You've got the attorney for Kouri Richins, the one-time attorney, and Greg Skordas, who's the one-time attorney for Eric Richins' family, both on the show, and cannot thank them enough for taking the time, especially in light of the fact that the verdict was literally read, like, I don't know, an hour or so ago. But I think this is a good point to wrap things up. Dan Schorr, appreciate your insight. Obviously, Joe Potuto, I don't want to brag for sure, but he's one of those Harvard graduates, so he's, he operates on a high level. I can say that. Sometimes. But Dan, just your final thoughts. I mean, this was a very quick verdict and an overwhelming verdict. Now a father is gone. A mother is going to prison, likely, as you heard, for the rest of her natural life at the age of 35. And 3 kids have to be raised by someone else. It's sort of a lose, lose, lose. So I guess my final question to you, is there justice here at the end of the day? And your final thoughts?
I think that's a really great way to frame it, because all these cases we're always wondering, was justice done? And even if so-called justice is done, meaning the right verdicts based on the evidence, based on what the defendant did, it still leaves this feeling in your heart of just tragedy. And you can't feel like there's never a happy, positive ending in these matters. But it is important that this case was built. It was a strong case. It took a lot of work, a lot of expertise from law enforcement, from the prosecutors, from the police, and it led to someone who the evidence clearly showed committed murder to being convicted. And that's extremely important for the family, for deterrence for other people who might do something like this. But it certainly does not leave a good feeling for us or anyone, because you have another tragedy after the previous tragedies and the worst of the future is for the children who now have to experience a father who's deceased and a mother who's going to be in prison.
And big thanks goes out to Joe Potuto, who, thank God, she is a night owl, because Lorna McKenzie letting us know it is 2:40 in the morning in Italia. So thank you, Joe Potuto. Dan, thank you. Joe, you did all the hard work here. 15 days of gavel-to-gavel coverage. Your final thoughts with this overwhelming verdict today?
Yeah, I mean, justice doesn't mean making people whole, because you can't do it. But it would be a whole lot worse if people who committed really heinous crimes weren't punished for it. And that's the best we can do. I thought the evidence showed she was guilty, and I'm happy with the verdict. Not happy with the situation, but the situation was there before this trial started. She murdered her husband.
All I can say after this is thank God it's Friday. Oh, wait, it's Monday. It's only Monday. It feels like Friday, but it's only Monday. I think justice was served here. Again, there are no winners here. It is a lose, lose, lose. But for the family, they get a modicum of justice. There is no closure. You always hear that. I don't think there is closure. These boys are going to be hearing about the father for the rest of their lives, and they'll never really get to know him. It reminds me of one of my good friends, John Hume, totally different circumstances. He lost his dad in the Vietnam War. He actually made an amazing documentary on HBO called The Unknown Soldier, one of my childhood friends. But he just learns about his father through their friends, his friends, the father's friends. And he finally went back to Vietnam. I don't know if there's anywhere that these kids, obviously, they're going to have their families surrounding them. But the point is, they're going to have to learn about their dad through the history books. And that's a sad way to learn about your dad. And the mother will be in prison. So I just really wish all the best for the Richens family, and that they can somehow, continue to live and move one step forward at a time, and find some peace in all the turmoil. And we are thinking of them, as I know all of STS Nation is tonight. So on that note, love you, America. Love you, New York. Love you, Italy. Love you, Summit County, Utah. And justice has been served for Eric Richins. We will see you all tomorrow.